The Joint Legislative Ad Hoc Committee on Family Court Orders is called to order. If you would please note the roll of committee members. All right, ladies and gentlemen, this is going to be a long day for this committee. We are probably going to go till 4 o'clock. A couple of housekeeping items for you. We are going to have a hard stop at noon. From noon to 1, we'll have lunch. And I've been given to understand that we have some food trucks that are going to be available to you out off of, I'm guessing, probably 17th Street or in the Wesley Boland Plaza in that area. We will pick back up at 1 o'clock and try to be concluded by 4. Now, we got a lot of people to testify. First in order of appearance will be state agencies. Then we have parents, and right now we've got parents penciled in for about 10 to 15 minutes apiece. Please exercise economy of words. Meaning if you can tell a short story, tell it as short as you can, because there's a lot of people. I mean, I've never seen this kind of response in a hearing to have folks make a request to speak, okay? So one of the ground rules that we are going to set for today, I don't care if you use the name of an attorney, a therapist, a psychologist, whoever in the psychiatric community, or even the name of a judge. I don't care. What I do care about, I do not want to hear a co-parent's name that is not here, or an ex-spouse's name that's not here, unless they arrive here and you're working together. We can already see in the media, certain agencies want to spin this to make all of you out to be malcontents and individuals who are just outraged because you didn't win in court. Nothing could be further from the truth. This is about the conduct in the family courts and family court orders. So, with that in mind, please keep your remarks, your testimony narrow in scope to just that. This is a legislative body. Our objective here is to gather information that could lead to meaningful public policy changes in the form of new law or for us to eliminate bad law. I'm seeing a whole lot of north-south nods. So with that, we are going to start with the first up, Jennifer Michelson, Deputy Director of the Arizona Board of Psychiatric Examiners. Jennifer, if you would. And if you would, so that, because this is being recorded and broadcast, get that microphone as close to your mouth as you can. I'm sure that it's been disinfected somehow. Our pages take really good care of the building. If you would, please give your name, who you represent, and you have 10 minutes.
Good morning, committee members. I am Jennifer Michelson, the Deputy Director for the Arizona State Board of Psychologists Examiners. Can everyone hear me okay?
Yes.
Thank you for letting me know. I appreciate the opportunity to be here today. It's my understanding the committee had requested a brief overview of this agency. So I'll provide an overview of that and the board's established claims policy that is codified under Arizona Revised Statutes 32-2081. I do just want to note before I get started, I do have 2 of our current psychologist board members present here today, Drs. Diana Medina and Dr. Joseph Stewart as well, who are prepared to answer questions as well. So the mission of the board is to protect the public by licensing only those who meet the statutory qualifications by conducting investigations and adjudicating complaints that allege unprofessional conduct by taking corrective or disciplinary action against licensees when the investigation finds that a statute was violated. The board was established in 1965 to regulate the profession of psychology and has investigated allegations of misconduct on the part of psychologists specifically for approximately 60 years now. In 2010, the board began regulating a second profession, behavior analysts. Currently, there are approximately 2,200 licensed psychologists in Arizona with an active license and approximately 1,300 licensed behavior analysts as well. In terms of the board and staff composition, the board is comprised of 10 members, 5 who are licensed psychologists, 3 are public members, and 2 are licensed behavior analysts. The board members are appointed by the governor and confirmed by the Arizona State Senate. Since at least 2019, the board has had anywhere from 1 to 3 vacancies at a given time. There are a total of 5 board staff members, 4 who are full-time and 1 who is part-time. Board staff consists of the executive director, the deputy director, me, along with 2 licensing specialists and a project specialist. The current board staff are not licensed psychologists or behavior analysts. All decisions relative to a complaint decision or licensure applications, as an example, are made by the board at scheduled public meetings. The board meetings are held approximately monthly, and the board does also have several subcommittees that are defined in statute. That includes our application review committee, the committee on behavior analysts, and the complaint screening committee, which reviews psychologist applications. Relative to the issue at hand in terms of court-appointed psychologists, from 2009 to 2015, a party to a case who wished to have a grievance considered against a psychologist who provided court-ordered services was required by statute to first submit their grievance to the presiding judge, who would render a decision whether merit existed for the matter to be forwarded to the board. In that 6-year period, only 1 grievance against a psychologist was forwarded to the board. In response to parent advocacy efforts calling to remove the judicial screening step for review of grievances concerning court-appointed psychologists in particular, former Arizona Senator Steve Smith sponsored a bill that was enacted in 2015 establishing the board's current claim process. So this has been in operation for over a decade now, which I will address next. So this statute that was established in 2015 for the claims process specifically states, a claim of unprofessional conduct against a psychologist arising out of court-ordered services shall be independently reviewed by 3 members of the board, including a public member. Each of the 3 board members who are reviewing the claim shall independently provide the board's executive director a recommendation indicating whether the member believes there is merit to open an investigation. If 1 or more of the board members who are reviewing the claim determine that there is merit to open investigation as a complaint, an investigation shall be opened and follow the complaint process that is established in our statutes. Claims are not exclusive to a family court matter, as the statute applies to all types of court-ordered services. So, as an example, the board also receives claims against a psychologist when they provided services in a criminal case, such as providing a court-ordered competency evaluation of a defendant. They may also provide other court-ordered services for civil matters involving torts or something such as a guardianship case. So the statute that was created does not grant the board any authority to remove a psychologist from a particular court case or overturn any opinions or decisions made by the psychologist or influence a court of law or judge to disregard that opinion. The board's authority is also limited to determining in the course of providing service to the court whether a psychologist committed an act of unprofessional conduct. The psychologist is not notified of the claim when it is being reviewed, nor are they made aware of the claimant's identity at this stage. And my understanding is that when this statute was created, the purpose behind this was to ensure that court-ordered services were not interrupted, as oftentimes a psychologist was actively providing services when the grievance was filed. If a claim does become a complaint, at that point of time, the psychologist is notified and required to submit a response. And they are afforded their due process rights throughout the complaint adjudication process. This next slide just basically demonstrates that the claims process and statute is explained in detail on our website, and also when they submit their grievance through the portal. Board members have been supplied with the board's policy and procedures that articulate how claims are reviewed, processed, and prepared by staff, and are subsequently reviewed by the assigned board member. The claims are reviewed by these board members independently. It is somewhat of a detailed process, so I will not get into it today, but the next slide provides an overview of the claims workflow. The lighter blue boxes that you see on the left side illustrate the progression of a claims receipt, staff's processing and information gathering efforts, the board member independent review, and that claims found by board reviewers to have merit transition to complaints. Psychologist complaints are reviewed by the board's complaint screening committee, which is comprised of 3 board members. It's my understanding this committee was established in statute back in 2004. The statute for this committee states that they may take either of the following actions. They can dismiss the complaint if the committee determines that there is no evidence of a violation, or refer the complaint to the full board for further review and action at a later date. In terms of claims and complaint data, the green line that you see on there represents the number of claims submitted by the board by fiscal year from 2019 to 2024. Some of the claims in this data pertain to court-ordered services unrelated to a family court matter. This is just encompassing all claims that we have received and complaints as well. The average number of claims received from 2019 to 2024 is approximately 9 per year. So this data represents about 1 claim received per month or slightly less. This data indicates that about 40% of the claims during this time period were determined by the board to be open as complaints for further investigation. By comparison, the board receives on average approximately 4 times as many complaints as claims. So this does conclude my presentation. I hope this information is helpful for the committee. If there's any questions, one of our psychologist board members, Dr. Mendina, would like to make a brief statement if that's okay.
Okay. Actually, I have a couple questions for you first. So on your graph, if you can roll back, of the complaints that you receive, are you able to tell this panel whether, is there a cluster of repeat offenders? I guess that's the kindest way to ask it. Do you have, are these complaints across multiple people, or does there seem to be complaints that come, 2 or 3 of those 9 come to a person?
My understanding from the data is it involves all types of psychologists that perform many different aspects of practice. So in terms of the claims, and Dr. Stewart and Medina can speak to this, it's my understanding a very small amount of psychologists do this type of work, so there would be a higher concentration of claims against a few professionals for claims. But complaints, I would say it is very broad. Okay.
Well, if you can follow up with information to my office that we can include in our report of these proceedings.
Absolutely, Mr. Chair.
I'd like to know if there's a concentration of complaints around 1, 2, 3, 4 people over the last several years. The other question I have for you is, I spoke with the director in a pre-briefing about this meeting, and I understand she's on vacation. Is that correct?
That is correct, Mr. Chair.
I would like to obtain the content of those complaints, and I'm fine with the names being redacted. I'm interested in knowing what are the commonalities across all complaints.
Mm-hmm.
And while I have heard that there's an opinion within your agency that you don't have to furnish that, I would say under Arizona Revised Statute, you do.
I will certainly research that, Mr. Chair, and inform the executive director of the request.
Thank you. Members, any questions for Jennifer?
Mr. Chair?
Representative Fink?
And I don't know how you do this, but anyway, how does the board evaluate whether a psychologist has appropriately considered the best interest of a child in visitation or custody recommendations?
I would defer to one of my psychologist board members to answer that question.
Okay.
Perhaps Dr. Stewart, because they are the individuals that review this and make decisions relative to that, not myself as a staff member. So if the committee would mind, Dr. Stewart.
That's fine. If you would, sir, please give your full name and who you represent. And like I said, there's actually a switch on that table that can raise the table so that you can get the microphone closer to your mouth. Thank you.
Good morning. I'm Joe Stewart. I'm a psychologist. I'm a psychologist member of the Board of Psychologist Examiners.
Okay, so.
Okay, thank you.
Do you want me to, I'll repeat
Representative
my question here. So how does the board evaluate whether a psychologist has appropriately recommended the best interests of the child in making custody or visitation recommendations?
Thank you for the question, Representative Fink, and Chair and Co-Chair. That's usually spelled out in the order of the court. So the psychologist is limited to what the judge directs the psychologist to look at. And so the best interest of the child is, I would like to say, universally understood. Any specificity to that is through the court order, the language in the order.
Okay.
Representative Keschel.
Yeah, Mr. Chair, thank you. Doctor, what was your last name again?
Stewart.
Stewart, thank you. So some of what my understanding is, and I understand what you're saying, that it's in a court order, but some of what I'm understanding is that some of these psychologists are actually kind of superseding the judge in some of these and actually making recommendations or orders that they shouldn't be. Is that something that your board would potentially, if someone were to make a claim on that you would consider a serious enough offense to turn into a complaint? I guess my question is, what are you looking for as a board for taking those claims and then pushing them to the next level of a complaint?
Certainly, if there's a, as I understand it, Representative Kessel, you're saying that the psychologist is placing themselves in a situation of superseding the judge and doing what they want to in spite of any specific order. Is that correct?
Potentially, yes.
To that point, sir, I think what Representative Keschel is talking about is the claim of quasi-judicial authority, where essentially the mental health care professional is given extremely broad latitude, I mean, beyond what the judge may be aware of. I believe that's what you were referring to, yeah.
Well, certainly it's, as a forensic psychologist, I no longer do any kind of family law or child custody. I only do criminal cases. But if they're superseding, going beyond their scope of order, then that should be foundations for a complaint. As to whether that would proceed to the next level, I don't know without specific documents to look at.
Can I do it too?
To that point, I'm not going to ask you to go down any hypothetical rabbit holes.
Thank you. And I certainly appreciate that.
I do
They,
have
they scare me this early in the morning.
They should. They get very dark down there.
They do.
I do have somewhat of a to that point. So your board makeup, because you said, you just insinuated that you were potentially affiliated with the family court type situation. When the board members are chosen for the board, do they take into account, because it was said that they cover, it may be different types of court cases, not just family court. Is there like a specific thing that you, I guess, formula that you have that you're going to have two from the family court, one from the, do you know what I mean with who you pick for the board? Are they all from the same kind of background? Do you get a difference in background?
Let me see if I can respond to that, Representative Kessel. There are only 5 psychologist members on the board. And so on the complaint screening committee, I am one of those. So I look at whatever the complaint is. We have statutory guidelines to follow, what the statutes are. We see if the psychologist has violated any of those. We also have the American Psychological Association Code of Ethics that we look at. Is much a longer list, and see if the psychologist has violated one of those. So that's what I'm looking at. I don't know that I differentiate whether it came from a commissioner or a superior court judge or a criminal case or family law. It's more in terms of what the complaint is, how it's worded, comparison to the Code of Ethics and the laws of the state of Arizona.
Thank you, Doctor.
Thank you.
I'm glad that you brought up the Code of Ethics and the canons of conduct. So according to the American Psychological Association, the ethical principles of psychologists in the Code of Conduct, they do indeed refer to do no harm to the child.
Correct.
What we heard in the last committee meeting, and I wouldn't expect you to know this, and the fact that you're not in the family court program now, I get it. But if there is a complaint that comes from a parent that specifically references harm to the child, because this is sounding very much so far like it's about two adults, and the minor seems to be getting lost in the whole conversation.
Agreed.
Is that a kind of a complaint? And quite frankly, that's the reason this committee was drawn together, because it's become abundantly clear that the civil rights of children are being abrogated, perhaps by the court itself. Now, okay, ladies and gentlemen, okay, I guess I need to cover this
I think you hit a
again.
button there, Senator.
Just a minute, Doctor. I need to cover this again. We cannot have any outbursts like that. No moans, groans, or clapping, okay? There is a decorum here in the Senate. We need to make sure that we're gathering information here. This is not a court of public opinion. That is outside on the plaza, okay? Please, if we have an outbreak like that, I don't want to have to excuse people from the room. This hearing is for you, okay? So let's make sure that we give the individual who is at the podium due respect, and let's not have an outburst like that again, okay? If you would, sir. Could you, I'm going to restate the question because it totally broke my train of thought. If there is a parental complaint that is made to the Board of Psychiatric Examiners that there has been harm done to a child, I presume that that is something that the board would take very seriously.
Absolutely.
Okay.
And it's the Board of Psychologists Examiners, and if there is a complaint like that filed, we cannot go on hearsay, we cannot go on third-party information, so we look for original documents of such neglect or abuse or intimidation or threat of intimidation or absence of their legal rights. And so hopefully the complainant will provide that type of information. That's what we can act on. We cannot act on one parent accusing the other parent. As you so said this morning, you don't want to hear about a parent who's not in the room. And so we cannot act on information where there's inadequate documentation to support the claim.
And for the clarity, Doctor, I'm not talking about parent against parent complaints. I'm talking about the complaint of a parent to a mental health care provider.
Yes, sir.
So, for example, I'll just throw a hypothetical out there. I'm not going to ask you to answer it, but
Thank you.
You have a parent who is in a session with the child, and something in that session occurs where the parent observes a behavior by the provider and takes note of that, and then subsequently files a complaint about the interaction with the provider. I understand that some of these interactions can be hostile. This is a really sensitive area of life. I get that.
Mm-hmm.
But I guess where I'm going with this question is, this is about an interaction with a parent and the provider, or the child and the provider. Do you also take into account first-person testimony from the child themselves, the minor themselves?
We do not. We don't have a child advocate on staff that can sit with the child to take that type of information. I think that would be an excellent recommendation to your group and to the House to undertake and put that to codify that, where that would be a possibility. It seems like it would require a child advocate to be there, and someone would, the board staff would have to interview the child perhaps and gather that information. Is that approximating an answer to your question?
You're right over the target, sir. I've long wondered why, in cases that drag on for more than a few weeks, why a guardian ad litem or a similar child advocate isn't appointed by the court to see to it that that child's civil rights are protected.
Mr. Chair?
If I may, I think I have seen that done frequently. We have guardian ad litems in criminal cases and also in guardianship cases all the time. And I also remember back when I was doing child custody work many years ago that a guardian ad litem would be appointed.
So
that depends on the court.
I'm sorry, didn't mean to cut
That
you off.
depends on the court.
Mr. Chair?
Just let me finish real quick. So in your professional opinion, I think I heard you say that you believe that that would be a good addition, perhaps, to statutory assignments in order to make sure that the civil rights of the child are also represented in the courtroom. Is that an approximation of your answer?
I think a guardian ad litem being appointed could fulfill that role for protection of the child would be a wonderful idea myself.
All right.
I don't know why it's not done more often, perhaps.
That is a head scratcher.
I don't
Okay.
know.
Representative Fink.
Yeah, I apologize, Mr. Stewart. And along with that fact, because I've many instances where I've had people come to me where the child is with the psychologist and there has been what's documented, because you said you look at the documents. What the document is not what the child reports. So therefore, and that happens quite a bit. And so therefore, when you do your due diligence, that is not documented in those reports that you receive. So I'm hoping that the guardian ad litem would that take care of it, or being able to even have parents in attendance, or what would be other suggestions in regards to helping that out?
I think the guardian ad litem, Representative Fink, would be a good approach to that. You still have the psychologist in the room with the child by themselves. Is that the indication? So you still have that situation. So what the child reports to one parent, I think we all know that is not necessarily the thing that the child reports to another parent. And so hopefully the guardian ad litem would be able to get a more neutral environment and get an answer approximating accuracy.
All right.
I do have another question, or did you want to ask another one along that line?
One more. Let's
Go
get
for
it. No, go ahead. One more question for this gentleman.
Okay. One thing is, just generally speaking, would it violate the ethical canyons? We talked about, the ethical standards for psychologists to reject, ignore, or fail to acknowledge official reports from other court-appointed professionals, such as social workers or investigators, whose findings might contradict the psychologist's conclusions?
Let me see if I understand the question, Representative Fink. Should the psychologist examiner consider reports by other professionals, social workers, licensed professional counselors, substance abuse counselors, marriage and family therapists, that contradict the findings of the psychologist?
Correct.
Absolutely.
Okay.
Absolutely. In a fair hearing of the facts, I consider contradictory reports all the time in criminal cases, And I would think that that would be most appropriate in juvenile cases.
Okay, thank you.
This is probably more a question for, oh, I'm sorry, members, any other questions for the doctor? No? Okay. This is probably more a question for Jennifer. So does your board ever work with the Arizona Department of Child Services while reviewing complaints? I mean, is there a coordination of effort, or do you do what you do and they do what they do, and there the two shall meet?
It's typically a very separate process. I can think vaguely of some cases over the year of coordination to determine what their investigation has found, but it has been difficult to obtain documentation from them.
Good to know.
Okay. What about the Arizona Attorney General's office?
In what capacity, Mr. Chair? Our board is represented by an assistant attorney general.
Okay, well, I understand they represent you, but I guess I'm probably talking more about a referral for either criminal or civil action.
The board has made referrals in the past to the attorney general's office. My understanding, I believe, it has been to the criminal division with respect to unlicensed individuals either claiming to be a psychologist or practicing unlawfully. That is my recollection, I believe.
Okay. What about Child and Family Protection Division at the Attorney General's office while working on complaints about providers specifically?
With
I mean, I guess in a way you've already answered that question. I'm just trying to get clarity around the process that your board has for, at what point do you involve the AG's office? Is it after you have concluded your review and you've now made a recommendation, or do you call them in early at the first notice of something that could be a referral?
So any determinations are made by the board through the adjudication of a matter. So once the matter is resolved, then typically they would make a separate motion for any kind of referral.
Okay. What about the Committee on Family Court? Do you coordinate with them at all?
We've had no contact with them.
Really? That seems surprising. Representative Keschel.
Jennifer, thank you. Thank you, Mr. Chair. So as far as these psychologists, regardless of what, which court they might be, working with, who is responsible for, I guess, training for them to make sure that they're not acting out of their scope of practice? Would that be you, the board, or would that be the court that they're part of?
Mm-hmm.
And yeah, because I'm wondering where the oversight is for what they're actually doing.
Representative Keschel, thank you for the question. I would defer to Dr. Stewart in terms of the training for their scope of practice for that specifically.
Okay.
Thank you, Representative. Continuing education hours are required for license renewal. So many has to be done. They're
Every 2 years.
every 2 years. And so within that, the scope would be ethics as well, so that would be included there. I think there are 40 hours every 2 years for that. Now, I know for criminal court, and I'm sorry, I know this is another issue, but the state Supreme Court holds training every 18 months for psychologists in the criminal aspect. So being a witness, the psychiatrists and psychologists that do the competency evaluations, we meet every 18 months to go through the Supreme Court training. It's a 2.5 day training. And then that list of people that are in attendance goes to the various divisions of the Superior Court. In terms of family court, I don't know how that, if the family court has any such training requirements or not.
Okay.
Real quick to that point, I guess, so some of my concerns then, if you found out that a psychologist was acting beyond their scope of practice, would that be enough to take a claim to a complaint, I guess, to that level?
Absolutely,
Okay.
yeah, outside of scope of practice. If they were for instance, talking about prescribing medication in this state, there's 7 states that allow psychologists to prescribe medication. Arizona is not one of them. So if that was the nature of the misbehavior, if you will, then that would certainly be worthy of a complaint, and that would push it on us.
Okay, and one more, Mr. Chair. Have you ever, when there's an active, actually claim or complaint, not a claim, on an individual, a psychologist, are you open as one of your possible avenues to recommending that that person possibly be removed from a case at that point, or
We
how?
have no such power to do
Okay.
that.
Okay. Again, I don't know if this is for you, Doctor, or for you, Jennifer. To obtain licensure with the board, do you require somebody to complete education in the, quote, social basis of behavior, which may include social psychology, group process, cultural diversity, and organizational and systems theory?
Mr. Chair, I'm going to request that Dr. Diana Medina address this, as she has expertise in this area in terms
Okay.
of qualifications for licensure.
All right. Ma'am, if you would, please give your name for the record. Yeah.
Sorry.
That switch comes in handy, doesn't it?
It
Yeah.
sure
And please get
does.
as close to the microphone as you possibly can.
Okay. Good morning. I'm Diana Medina. I am a licensed psychologist and vice chair of the board. So in terms of education, absolutely, there are rigorous standards for education. Of course, social psychology is one of them, clinical psychology, human development. There are certain areas that we look at. Most of the programs that provide that education, when someone is pursuing a doctoral degree in psychology, have what is accreditation from the American Psychological Association, and they ensure that there is training in each one of very specific areas. Furthermore, once folks graduate, they need to have a certain number of hours of training. And when someone wants to specialize, so for example, neuropsychology or forensic psychology, they do so under the supervision of a neuropsychologist or forensic psychologist for, typically it's a couple of years until they are able to call themselves and present themselves as forensic psychologists or neuropsychologists or having a specific specialty.
Okay. I guess more specifically, the question is around DEI. Is that something that's required of potential licensees to go through a curriculum that's DEI based?
It is my understanding that as of this year, that requirement was revised, but it was in terms of having competency, cultural awareness, having so a certain level of competency in different cultural backgrounds.
Okay. Jennifer, if you wouldn't mind, I'd like to know what the requirements are. I mean, I don't expect you to answer this question now, but if you would forward that information on to me, I'd appreciate it. Members, any other questions for Jennifer or the doctors?
I think I have, this question would probably be for the doctors, Mr. Chair. So there's been a big topic here in Arizona has been the parent-child reunification process, where they're insisting that this is decreasing the time, 1 to 2 weeks to get things all fixed and better. I guess, what is the board's take on that? Some of what I have heard regarding that program, that it's costing parents upwards of $15,000. Is there really evidence that it works? Because I have some major concerns about that. So I guess, what is the board's take on that process and some of the maybe negative things that I'm hearing that coincide with that?
To my experience, and Jennifer, you can correct me, we don't look at that specifically because that is with the family, what the family court system and what that training entails to function in that capacity.
Would you, Mr. Chair, one follow-up, would you be open to maybe looking more into that and potentially, I don't know how you could possibly step in, but since you are a board of psychologists, it might help to have some good raw data to give to the courts to potentially help give some good, solid facts on that type of situation, and if it's really helping these kiddos or not.
Sure, absolutely. There is also, I mean, psychologists are one of the professionals that do that type of work. There are other professionals that are licensed by other boards that also do that type of work, but we can most certainly look at what pertains to our board.
Okay. I'd like to ask a hypothetical, if you don't mind, and I'll try to keep it high on the rabbit hole, all right? When you have an individual within an office who is not enrolled in to become a therapist, enrolled in school, or who is not a graduate of a school, is it appropriate for that individual to be assigned as a so-called therapist under the direction of a psychologist or psychiatrist, a PhD level mentor, if you will?
Yes, so that person needs to be working under the supervision of a licensed psychologist, and as a supervisor, the supervisor has full clinical responsibility over the work that is done by their supervisee.
Okay.
So if I am supervising someone who completed their doctoral degree, they're accruing hours maybe after, a postdoc, let's say, or works under my license, it is my responsibility to provide the supervision and guidance so that their work is reflective of our ethical guidelines and our statutes.
Okay, I get that piece, but that kind of avoided answering the question that I asked, and I don't think you
I
intended.
apologize.
I don't think
No.
you intended to do that. If an individual who is working under the direction of a PhD clinician either does not have their education completed or is not enrolled in education at all, is that a violation of the code of ethics? Because you've got an individual who is, they're not even in school.
Right. So I understand that part. Have they completed school prior? Is it they're
No.
not? So if they have not completed a degree that would render them, I would say, right, in mental health, and they're not accruing hours, right? Because that's how we bring up the next generation, right?
Right.
We teach. And so they need to be enrolled in an educational program. Then I'm not really sure how that would.
Okay,
Work.
so just to recap, they're not enrolled, nor have they graduated. Meaning they didn't go through all the way and graduate, and now they're doing their practical, their in-service, whatever your profession calls it. As a paramedic, mine was a practicum. I had to do so many hours in the emergency room,
Yeah.
so many hours in cardiac, so in order to qualify for my licensure.
Right.
I wasn't enrolled because I had graduated. So my question is, if an individual is acting in that trusted counselor, clinician capacity, but is not enrolled in school to do that, nor have they graduated from a program, is that a violation of the code of ethics? I'm sorry, I guess I should finish the question. By the PhD level clinician who they're supposedly working under.
Right. So I think that would fall probably under competence. I think it would be on the burden of the psychologist to show how this person has acquired competence. And I'll give you a hypothetical, if you will. Let's say someone has not a doctoral degree, but they had studied and obtained a master level degree. Maybe they started their doctoral training, but for whatever reason they did not finish, but have many years of experience and received training. It would be on the psychologist, on the licensed psychologist's burden to show that this person has competence. It does not fall into the typical categories of a practicum student getting hours to graduate, nor it falls under the internship, which is also required for graduation, nor does it sound like it would fall under the postdoctoral side of things, which is the hours that you accrue postdoctorally to obtain that, let's say, classification, that specialty.
Okay. All right.
So,
Members, any further questions?
Mr. Chair? I know, he looked at me.
One, we got to move on, otherwise
know.
we're not going to hear from parents.
I know. Representative Keschel alluded to this, but it was in regards to parent alienation, because oftentimes that's utilized in courts. Do you recognize that as a, quote, diagnosis to be able to warrant a lot of the therapeutic interventions and all of that?
as a formal psychological diagnosis,
Mhm.
represents, I do not.
Okay, thank you.
Mhm.
I'm done.
Okay, thank you very much. Next up is
Thank you, committee members.
April Elliott and Colleen Concannon, if you would, from the Commission on Judicial Conduct. And, yep, you know where the switch is at? Good.
I have a similar desk.
Okay, if you would, please get as close to the microphone as you can so we can get a good pickup. And give your name for the committee and who you represent.
Good morning, Chair Finchem and Chair Keschel and members of the committee. Can everyone hear me okay?
Yep.
Okay. I am April Elliott. I am the Executive Director for the Arizona Commission on Judicial Conduct. Also appearing with me is Colleen Concannon, who is one of our public members. And just by way of background, I've been attorney for 30 years this year and did family law when I was in private practice. And I previously was a Superior Court judge in Pinal County where I had a family law calendar. So let me jump in with, I brought some packets of information because I know my time was going to be limited with additional information regarding the commission. There's one for each member of the committee, and then there's one I believe you can incorporate into the public record for this proceeding. So what is the commission? The commission is actually created by Article 6.1 of the Arizona Constitution. The voters passed that in 1970, and there were some subsequent amendments in 1988. It's an independent state agency that is responsible for investigation of complaints against judges under the Arizona Judicial Branch. This extends to judicial officers at all levels, so from City Court, Justice Court, Superior Court, Court of Appeals, and the Arizona Supreme Court. But we do not have jurisdiction over federal judges, tribal judges, or any administrative law judges that work for an executive branch agency, such as administrative law judges that hear unemployment claims or workman comp claims. Likewise, the commission does not have jurisdiction over court employees, attorneys, members of law enforcement, or any other elected officials such as constables or clerks of the court. Judicial conduct commissions exist in every state, and they do play a vital role in promoting public confidence in the judiciary and in preserving the integrity of the judicial process. We are a forum for citizens with complaints against judges. We are not to be confused with the Commission on Judicial Performance Review, JPR, which is a separate entity that reviews the judges' scores on the surveys and then makes the recommendations as to whether or not those judges meet standards for purposes of retention elections. So people conflate us with them, and we are separate. So the Constitution sets forth who are the members of the commission. There are 6 judicial members who are appointed by the Arizona Supreme Court. There are 2 Court of Appeals members, 2 Superior Court judges, 1 Justice of the Peace, 1 City Court magistrate. 2 attorney members are appointed by the State Bar's Board of Governors. And there are 3 members that are appointed by the governor and then confirmed by the Senate. The members are all volunteers. They receive no compensation for their work, but they are entitled to be reimbursed for expenses if travel is involved. And the commission is supported by a small professional staff. The Constitution sets forth that the Arizona Supreme Court promulgates the commission's confidentiality rules. So what can the commission do and what can we not do? So we are limited to investigating allegations of judicial misconduct in violation of the Code of Judicial Conduct, and if warranted, then imposing informal sanctions or recommending the imposition of formal sanctions to the Arizona Supreme Court. The allegations in each complaint are considered on a case-by-case basis in accordance with the code. So some examples of judicial misconduct include improper demeanor, yelling, rudeness, or using profanity, improper communication, such as ex parte communications, communication with only one side, delay in performing judicial duties, public comment about a pending case, or improper off-the-bench conduct, such as criminal behavior or other things in their private life that might run afoul of the code. What can we not do? We can't change a legal ruling made by any judicial officer or direct a judicial officer to change a ruling. We can't have a judge taken off a case or have the matter assigned or transferred to a no judge. We cannot intervene in a pending matter. And neither the commission members nor staff can provide legal advice. So the commission is primarily concerned with the judge's behavior, not judicial decisions. Comment 3 to Rule 2.2 of the code states that a good faith error of fact or law does not violate the code. However, a pattern of legal error or an intentional disregard of the law may constitute misconduct. Any violation of the Code of Judicial Conduct must be proven by clear and convincing evidence. A mistake in a ruling does not automatically mean that a judicial officer has engaged in judicial misconduct. Judges are required to exercise their discretion when they make decisions. And even if a judge's decision might be legally or factually incorrect, the ruling is generally considered to be legal error and not ethical misconduct that the commission can address. When a complaint to the commission solely relates to the correctness of a judicial officer's legal decisions, the complainant is seeking the commission to function in the capacity of an appellate court. And correcting legal errors is the role of the appellate courts, not the commission. And by way of example for every person who's sitting in this room who likely says that the judge got it wrong in their case, there's another side that says the judge probably got it right. Those folks are not parties to our process. So for us to step in to make, to correct what we think might be legal errors is not our role. They have an ability to be heard through the appellate process, and that's where those is the better forum for those to be resolved. However, we understand that appeals can often be very costly and complicated. There's no charge to file a complaint with us, and it's a fairly easy process. So unfortunately, a lot of folks come to us when they really should be filing an appeal or some sort of other appellate review. One of the things I forgot to mention, but I thought of it when in listening to the prior presenter, one of the things that is prohibited for a judge to do under the code is that a judge is not permitted to conduct an independent investigation. A lot of people misunderstand that. So a judge is limited to the information that is presented to them by the parties. So they have to rely on what's presented to them, including expert testimony. And there was a lot of questions for the last folks that I anticipate there might be similar questions for me, but the wishes of the child are only one of the statutory factors that the court can consider. So just anticipating that. Our complaint process, anyone can file a complaint. We do accept anonymous complaints. There is no charge for filing a complaint. However, the complainant is not considered to be a party to the commission's case. That's set forth in the commission's rules. But they are entitled to receive acknowledgement of the receipt of their complaint, notice of any public hearing, and the written dispositional order regarding their complaint. What becomes public is outcome driven. In dismissed cases, only the complaint and dispositional order are public after all identifying information is redacted. If the complaint does result in a public sanction, the record is public. Meetings of the commission are not subject to the public meeting laws under ARS section 38-431.08A3. Had I known we could bring a PowerPoint, I probably would have done that.
That's all right. You brought a stack of trees
I
instead.
did. I'm not environmentally conscious today.
That's all right.
A complaint form can be obtained off the commission's website, which is www.azcourts.gov/ AZCJC, or by calling the Commission's office at 602-452-3200 to have a form mailed or emailed to you. The members of the Commission review all the complaints after staff has completed an investigation, and it is the members of the Commission, not staff, that decide what action to take on a complaint. For the last 2 years, the Commission has received in excess of 500 complaints per year. This year, if the numbers hold, we are on track to receive more than 600. The disciplinary counsel position in our office is primarily responsible for the investigation of all complaints. We have one permanently funded disciplinary counsel position. For the last 2 years, the Administrative Office of the Courts has assisted in temporarily funding a second position through grant funds, but there is no guarantee that those grants funds will extend beyond June 30th of 2026. We have submitted a legislative funding request to permanently fund a second position with no success so far. That request is still pending this year. It's a daunting task for only one person to investigate 500 plus complaints. For this fiscal year, basically from July 1st of 2024, and I cut it off at April 30th, 2025, we had received 463 complaints. 103 of those, or approximately 23% of those, related to family law matters. We do not track involvement of behavioral health professionals in family law complaints, such as therapeutic interventionists, court-appointed advisors, parenting coordinators, best interest attorneys, or guardian ad litems, or any psychological or custody evaluators.
Excuse me.
Mm-hmm.
I hate to interrupt
That's
you, but
okay.
I've got like a dozen questions that
Sure.
are buzzing around in my head, and I'm going to forget them if I don't.
Go ahead.
You just gave a number for the last 12 months, and I'm sorry, that number was what, 400 and?
463, basically from July 1st of last year to April 30th of this year.
Okay,
So that's
how
fiscal
many of
year.
those are founded, or are they all unfounded?
Statistically, I didn't run that specific.
I'd like to know that, and I'm not
I
going
was
to
gonna
ask
say-
you to make up a number. Just
No,
let me know
but
what that number is.
I can say generally, our dismissal rate hovers between 85 and 90%.
Mr. Chair.
And that is not unique to our commission. One of the items that is contained in the packet that I gave you is information from the Center for Judicial Ethics at the National Center for State Courts that discusses why commissions nationwide disregard a large percentage of complaints. Generally, the main reason is because at their core, the majority of the complaints are disagreements with legal rulings. And that's beyond what we're able to address.
Yeah, Mr.
Okay.
Chair, I have a number for 2024. Out of 485, three resulted in reprimands.
I think that's inaccurate because the way that we post to our website is by the year of the complaint. So there were some 2023 cases that were resolved in 2024. So the annual report that is in the materials that you have breaks it down by what was technically resolved in 2024.
Okay,
Well,
we'll review the
Yeah,
complaint. or
and
the
to that
report.
point, so you talked a lot about the Constitution. I love the Constitution. We're limited. At the federal level, if there are issues with a judge, Congress can investigate that judge. Here, we don't have the power to do that. So we rely on you via the Constitution to help in some of those manners. So I'm wondering, I understand what you're saying because I will tell you right now, a lot of what I've heard is the law is being broken from the bench. And everybody tells these families, oh, we'll just appeal it. But the success rate of that is very low too. So these families' kids are left in the hands of judges that you're hoping will follow the law.
Well,
And so I'm wondering what responsibilities, we need to give to you constitutionally so we can actually get somewhere.
And to that point, I find it a rather flippant response. Well, we've got the appellate process. These are people who are being bankrupted by court orders. Now they have to pay to go back to court again. I have a bit of a problem with that. But
I understand your
I know you're
concern,
trying
but
to
understand what our limits are currently at.
No, I understand.
And appellate judges go through a vetting process. They're vetted by a committee. They're appointed by the governor. They stand for retention.
With all
the
due respect,
public
ma'am,
doesn't have a vote on who serves on
this about the appellate court.
I'm
okay?
just saying the public doesn't have a vote with who sits on the commission. So I'm not really sure it's fair to shift that responsibility to unelected individuals.
Okay.
That
Fair
was my
enough.
point.
Let's try and finish up with your presentation within the next 5 minutes, because I know there's a whole bunch of questions, and we still have to get to parents.
Okay. So in terms of public outreach, the public can bring complaints to us regarding family law judges, but just understand that it is not the commission's role to re-weigh the evidence or redetermine witness credibility and determine whether or not the judge's decision on custody, parenting time, support, or the employment of an expert was appropriate. We received many complaints. Just back off from that. So 2 years ago, we did begin a Coffee with the Commission event in which we invited members of the House and Senate Judiciary Committees to come and have coffee with the Commission and learn more about our process and ask questions of the members. That was to allow the people's representatives the ability to learn more about our organization and what we can or cannot do. Unfortunately, in a world of limited resources, we do not have the funds to do more robust public outreach. We have discussed potentially doing a video that we can put on our website regarding our role, as we know that some folks learn easier via video than reading the information. So that is in the works, but in terms of more travel to do more outreach, because a lot of members of the public really do not know that we exist, we just simply do not have the funding to do that.
That it?
And with that, I would open it up to questions for
Right.
either Ms. Concanon or I.
All right, great. I have a couple questions for you.
Sure.
So, hypothetical, would it be improper for a judge to threaten a parent or a minor in court or outside of court through their attorney, that if they were to come to this committee and testify, that they would be held in contempt?
I can't opine because that's the member's purview. I'm not sure, and I would also probably want to know more context in terms of that. But maybe Ms. Concanon would be better to answer that.
Please give your name and who you represent for the record.
Colleen Concanon, I'm a public member of the Arizona Commission on Judicial Conduct. To answer your question, that would absolutely be investigated. And just so you understand what the investigation involves, it involves talking to every party that we can find involved in it. We make the effort to go out there and see whoever can talk to us, and especially people who are afraid of losing their jobs. We're very careful with that because that's something we don't want to see happen, and all we really are trying to get to is the truth. And all commission members review all cases. Sometimes people don't realize how much time we are already putting into this, but it's hundreds and hundreds of hours a year to make sure that we have thoroughly investigated everything we can. If we can't find the information, then yes, sometimes injustice is done. But we're certainly trying to get that every time we can.
I appreciate that. Is your position a paid position or a volunteer, ma'am?
No, I'm a volunteer.
Okay. Now I'd like to move on to the question of quasi-judicial immunity. I think I heard you say that your responsibility is only to review the actions of judges and complaints concerning judges. Is that correct?
That is correct. We don't have jurisdiction over anyone else.
Then why on earth is quasi-judicial immunity offered to non-judges who appear to be outside of the scope of your examination?
That I cannot answer. I think that would be a question for the folks that conferred it.
Okay.
I have a personal theory in that they wanted some of this, they wanted the quasi-judicial immunity, much like the judges have, so that there's a layer of independence that these individuals cannot feel threatened or intimidated by what others do.
Okay, but ma'am, that doesn't make sense to me.
Again,
They're
I didn't
acting-
enact that law, so
Forgive
that's
me
probably a better
just
question.
moment. Please
Sure.
let the chair finish.
I'm sorry.
if an individual is protected by quasi-judicial autonomy, who on earth is holding them accountable? Acting in the capacity, essentially, as a judge to make certain orders happen.
I can't answer that.
That's a fair enough answer. Thank you. Finally, my last question is, if it's revealed in court that there has been a crime against a child, specifically child abuse, whether physical, mental, or emotional, does the court have a duty to respond and report that to law enforcement? I mean, is the court, is the judge themselves, do they have a duty to notify?
I don't want to misspeak. I don't believe judges are considered mandated reporters under Arizona law.
Okay.
I not 100% certain on that.
Thank you for your honesty. We'll research that.
I actually do have a different question. There is a judicial ethics opinion that discusses a judge's duty to report illegal conduct that is revealed during court proceedings. It's an ethics opinion. And it essentially basically says it's within a judge's discretion. However, the opinion goes on to talk about that for every person who might testify that perhaps they've cheated on their taxes or, got money under the table that wasn't declared, things of that nature, that, those are somewhat discretionary. But if it's more serious, then the opinion talks about then the judge should heavily weigh whether or not it could be reported. One of the factors to consider is it reported by anyone else?
Understood.
Judges will oftentimes make referrals to the Department of, I wanted to say CPS because that who was in my day, but the Department of Child Services to investigate when there are allegations like this, because the court isn't really equipped to be a criminal investigator, but they can make referrals.
No, I thank you. I absolutely understand that. And I guess my point in this question is, if the court becomes aware of child abuse, whether physical, mental, or psychological, does the judge, like anybody else, have a responsibility to report that to law enforcement? I'm talking about there's evidence, there's first-party testimony from the minor.
Again, I would say that the ethics opinion states it's within the discretion of the judge, but as far as I know, I don't believe judges are mandated reporters.
All right, thank you. If we need to research that, please. All right. All right, members, any other questions? All right. Thank you very much. I appreciate your time and your testimony. Okay, next up, Mr. Jax Atwell. Jax, are you here? Raise your hand. Oh, there you are. All right. And I'm at the risk of trying to limit your time, please, economy of words is great because we are already at 10:15 and we're just getting to parents. So I know you probably have got a lot to tell us, but please proceed. Give your name and whether you're representing yourself or somebody else. And you got 10 minutes and then we'll probably open it up for questions. All right?
All right. Mr. Chairman, members of the committee, my name is Jax Atwell.
Jax, if you would, please get as close as you can to the microphone. Thank you.
How's that? Mr. Chairman, members of the committee, my name is Jax Atwell. Thank you for allowing me to speak today. I commend the committee for stepping beyond political routines to listen to the voices of like-minded voices to represent not just ourselves, but countless parents who could not be here, those overwhelmed by the system, and families who have suffered loss, despair, and injustice. I stand before you only by the grace and strength of God. My time is short, so I'll represent the facts directly, referencing exhibits, so you can see the evidence for yourself. My perspective is unique as a former police officer in 2 states and as a licensed private investigator in 2 states for the last 15 years. My wife and I have gathered evidence in ways few others can. After 6 years of fighting for a right to be a father, I am now facing bankruptcy, crushed from all sides, with no resources left to defend myself and fight for the well-being of my son. The only thing I have left is the truth. With nothing to lose, I am here to expose the corruption I have witnessed. Family law cases in Arizona are rarely about the children. My minor child is hardly mentioned, if ever. Yet there are mountains of casework against me in the shape you'd expect in a high-profile criminal case. Being a parent is one of the most important titles you can hold in life. I'm honored to have and raise two amazing young men and help raise an amazing bonus daughter and bonus son. They're all striving and thriving in life. Yet when it comes to my youngest child, I'm bankrupted, harassed, and beat down because of what? All because I chose not to be in a relationship with a mother, but still wanted to be an active parent in his life. This is something any family court should strive to support rather than strip away. Please understand that in my limited time here, I'm representing just the tip of the iceberg. Systemic abuse and financial devastation. Initially, I came prepared to share the mental and physical abuse my family and I have endured, and abuse-fueled lies, cherry-picked information, official documents being disregarded, and violations of Rule 69 and established legal timeframes. While my case has been horrific, it may not be the worst on record. My experience as a private investigator for similar cases has shown me that others face far worse injustices. With that perspective, I want to focus on the financial impacts that the system, for example, pediatricians in contact with opposing counsel and in charges for medical records. I don't know if you guys have copies. They were supposed to get copies of exhibit.
We don't, but you'll be able to give them to Zach here once you're done.
All right, thank you. $500 cash only charges being mandated by child advocacy appointments, the CAA. Judge orders counseling from an unlicensed marriage counselor, counseling fees of $165 an hour for a situation no marriage ever existed, causing distress with my spouse.
Excuse me, Jax, was any of this covered by insurance?
No.
Okay, so let me get this straight. You've got individuals who purport to be therapists, who purport to be licensed therapists,
Correct.
and they don't accept insurance.
I don't know. I mean, I don't have insurance, so I don't know if they accept it or not.
Oh,
It wasn't
all
ever portrayed to me. We were given one person to go to and no options to go to anyone else.
Okay, all right, please proceed.
Opposing party inflates income deductions on every affidavit and financial information, which is, it'd be obvious when you look at it. I'm sorry, you don't have them copies of it. Contempt of court findings and maximum fines with interest when father cannot pay, pushing him towards financial ruin or bankruptcy, though bankruptcy itself is unaffordable without saving for it. Overinflated rulings being punished for accruing interest at the maximum legal rate. Credit being manipulated in court to inflate child support obligations. Mother gets credit for these items, yet father is found in contempt by judicial officials for not paying half, double dipping. One of the bigger things I'm here to talk about today is the state tuition office and the state tuition office representative organization, IBE, which is a Catholic organization that gives scholarships. Mother lied under oath paying that she's paid the tuition.
Okay, hold on a second. I asked everybody, please do not make accusations about the opposite side of the argument. This is about the court.
Understood.
This is about lawyers, and this is about therapists. So let's move past, because we're not going to relitigate that part of it.
Understood, Mr. Chairman. Let me rephrase.
All right.
The opposing party was giving cash value for the scholarships to the state tuition office.
And that was presented to the court?
Correct.
All right.
I was denied legal rights to a document in a recorded call with the IBE, the attorney Robert Fee. He's the actual attorney for the IBE state tuition office organization. My email seeking clarification for the Robert Fee is also included here, where I'm trying to clarify what I'm getting at. The subpoena issued to the IBE attorney, subsequently motions to quash, were handled irregularly. Why would a state tuition office approved organization like the IBE need to file for an order of protection from the father trying to obtain a way to prove the scholarship funds? And again, those will be in here for you guys to see. The law requiring school tuition organizations and donor information was not properly followed or enforced. The judge granted the motion to quash. This has allowed the mother to collect $9,000 per year since 2020 of state tuition office funds received as cash value, and get the tax exemption also, and other perks the scholarship allows. That is over $60,000 the court has awarded cash value to a parent. It has refused to correct it.
Okay, Jax, so I just want to understand, this is an order of the court?
Yes.
On order of the court, okay. Can you obtain that court order, or do you have a copy of that court order?
I don't have it with me, but yes.
Okay. Next, and you're about out of time, so I'm just going to try and expedite this a little bit with
All
some
right.
questions, if you don't mind. Do you have any documents showing the payments of any and all kinds of directly associated charges with your case?
Yes.
I think that's what you've been referring to? Okay.
Yes.
Were you ever required to participate in a reunification, re-education camp?
No, it was not.
Okay. Were you represented by legal counsel upon learning that your child, well, I guess that didn't, because you're not a participant. I think that's all the questions I've got for you now. If you would just wrap up with what you've got. You got about a minute to finish up, and then I'll open it up to the rest of the committee.
All right.
I'm sorry to cut you short, but
No, I understand.
as you can see, we got a lot of people.
And there's a lot, like I said, is tip of the iceberg, Mr. Chairman. The final order irregularities that I can actually prove that the judge actually didn't write all the order through a linguistic analysis.
I'm sorry, you're saying that the judge did not actually write the order themselves?
Correct. I can prove that through linguistic analysis. And so there's cut and paste with the correct L-type texting that the court uses, and then there's cut and paste that's obviously not the judge's, confirmed with multiple writings of his, samples of his writing. This is also confirmed with several different linguistic analysis, including an analysis out of Sweden called REACT,
Okay.
which is a domestic linguistic analysis for doing this domestic issues.
Okay. If you would, I noticed you've got a whole bunch of documents there. If you could turn those over to Zach here, the handsome
right.
gentleman here with the beard, when you're done.
I will, Mr. Chairman, I will just conclude this. Obviously,
Okay.
there's more parts of this. In conclusion, I share these experiences not only to highlight the personal toll, but to call attention to the systemic issues that need urgent reform. Ultimately, only attorney, state departments, and judicial officials benefit from the loss of time and finances suffered by families like mine. I urge this committee to review the exhibits and consider the evidence of a system in need of true accountability and change.
All right. Thank you, Jax.
Mr.
Members,
Chair.
any questions?
I have one, Mr. Chair, Jax. So just to kind of sum up what you were just saying, I'm sorry, I'm a visual person, so I was wishing I had those documents to look at while you were talking. But you're saying that basically one party in this situation was benefiting financially and the other party, the opposite was happening. They were being, I mean, so to speak, ruined financially. Is
Yes.
that kind of the sum of what you were saying?
100%.
Why? What do you think the purpose is for that?
It's unknown. I have striven for the last 6 years to try to uncover that. I've tried to uncover the why isn't always going to happen. A lot of parties involved, a lot of things I didn't get to go into here today. Other things were done in the court order that I was supposed to go do. And so then you have all these other departments and things going on that are all benefiting from the court system.
Okay, so to that point, I have one follow-up. Do you have, because it seems like you've got some evidence, so to speak, do you have any evidence of judges benefiting from one party benefiting?
As far as being able to directly correlate, where I've been able to prove, they're getting $1 for doing this.
Yeah, I mean,
No,
yeah, okay.
no.
All right. Members, any other questions? All right. Thank you very much. I appreciate it, Jack.
Thank you.
If you would, just hand those documents to this gentleman right here. All right. Next up, Robert Del Garbino. Robert, you have 10 minutes. If you would, please give your name. And if you're representing yourself or someone else, give us an idea who you're representing. And get as close to the microphone as you possibly can.
Good morning, Committee Chair, Senator Finchem, and your esteemed colleagues. I have a document. Zach, have you distributed this to all the members?
Yeah.
All right. This is a 14-minute page. I represent not only myself, my family, but hundreds of other families. What I'm going to tell you is how the court system has been subverted and abused by psychologists. And I hope you grant me the 14 or 15 minutes.
I'll give you 12.
Allow me to
Talk fast.
Yes, sir. Allow me to get through it and then ask questions, please. We're here to expose the despicable acts and deeply rooted corruption in family court system perpetrated by some reprobates over the last 20 years. Scoundrels that have leveraged flaws and created loopholes in our family court system for personal gain at the expense of our children. There are some great family court appointees. They solve family issues quickly with little expense. I personally have had experience with a few of these. Let us now turn our attention to how groups of organized family court appointees and their associates have taken advantage of children and families in crisis by creating additional problems with long-term adverse effects on the mental, emotional, and financial health of the family unit. They do this by taking advantage of the family court system. They do this for long-term profits, power, and personal capital gain, just like any other organized criminal activity. In many cases, the court appointees easily create a biased paradigm that creates, feeds, or lengthens an already horrible family situation. They do this at the expense of suffering, abused children, and parents. And this is how they do it. In high conflict custody court cases, family court typically appoints a therapeutic interventionist, a TI. This instantly creates a revenue stream for the appointee, a TI, therapist, psychologist, or court-appointed advisor. The length of time that revenue stream continues is highly dependent on the ability of the appointee to solve the problem. Do they solve the family problems quickly, or do they stretch out the problem? I've experienced both and have the hard evidence to back up these claims. This problem begs the question, is it the family court's job to fix families or to simply adjudicate according to Arizona law or their feelings? We believe these matters should be adjudicated adhering to the laws of Arizona and what is in the best interest of the child. The family court also requires each parent to supply an affidavit of financial information, or AFI. This discloses each parent's finances. The TI has access to the AFI. This is how they can size up the earning potential from each family. When the family court orders therapy, a TI is assigned. Typically, mother, father, and children are required to see a specific therapist assigned by the TI. This immediately sets the stage for multiple things to happen. A, required weekly therapy sessions ranging from $250 to $400 per hour on average for mother, father, child, or many children. At an average cost of $325 times the 3, that's $975 a week per family, or $50,000 a year if you take a few weeks vacation. It's purported that one TI has 97 cases in his case file. Multiply 50,000 times 97, near $5 million worth of income. It's a very lucrative profession, isn't it? B, supervised visitation. The costs vary. An example, $2,000 per month for 2 4-hour visits per month, or $24,000 per year. This is ordered in many cases. C, intensive family therapy, IFT. Estimated costs, mine was $15,000. I've heard up to $40,000 for these camps or intensive family therapy sessions. In addition, new terms were developed during the course of my case. There were pre-intensive family therapy costs, post-intensive family therapy costs, and the names for more charges developed as the case went on. I've listed my case if you like to review it, the numbers there on the sheet. D, a false narrative, and this is a very important part. A false narrative is created by the TI favoring the abusive parent. This sets up continuous actions by the good parent to save the children from further abuse. These actions are like hearings, cases, more psychological reviews, whatever they can do to save the child from further abuse. This false narrative capitalizes on the instinct of human nature to protect their young, mothers and fathers alike. There's good and bad in both sides of the camps, right, of the genders. The good parent will spend or do whatever they can legally to protect the children from further damage by the abusive parent, whatever they can. They'll spend every dime. The false narrative paints the good parent as bad and the abusive parent as good. This is typically reflected in false reports to the court by the TI. I'm going to repeat that. This is typically reflected in false reports to the court by the TI, and I have hard evidence of that.
I was just going to ask, Robert.
Well as others.
Is this your personal experience, or is this a generalized experience that is second or third hand?
Both.
Okay. Let's try
Personal
and stick
experience and experience from talking to more than 20 parents
Okay.
who have had the same paradigm applied to them.
I appreciate that. So let's try and stick primarily to your first person experience, okay?
It's my intention over the summer to dig out more cases to give you more hard evidence.
All right, thank you.
You're welcome. This results in the abusive parent getting reoccurring temporary custody through any legal means available. One is a reoccurring no contact order. In my case and many others, a no contact order was or are issued without cause or due process, which violates parents' civil rights. You have to have due process to take a kid away from someone, temporary or not. This perpetuates family conflict instead of resolving it. Here's an example, and I've listed a case for you here, of Sachs versus Raymond Branton. It explains exactly what I've described with bias and false reports. You asked, do I have another case? There is one. In addition, I have multiple instances where the handwritten notes obtained through subpoena of multiple TIs that are in direct conflict with the reports provided to the family court system. Hard evidence. The judge created orders using false reports, thus causing additional damage to the family, while the TI and his circle of influence, colleagues, and army of therapists continue to profit from the weekly therapy fees collected. Remember, this therapy can go on for years and has gone on for years. Number 4, a circle of influence has been created and used by TIs. There's a specific group I and many other parents are now aware of. These circles of influence are used repeatedly in many cases. The false narrative is reinforced through multiple mental health care providers that remain loyal to the false narrative proffered by the leading TI. Businesses referred and repeated case by case to therapists who align to the false narrative, thus creating a group that has conspired to mislead the family court system. I've experienced this firsthand. Others have described the same web of therapists that they were or are ordered to see. Another means that they use is psychological evaluations. They're misused as punitive measures, ordered without cause. There's a high profit in this. They're demanded by the request of opposing counsel, sometimes by the leading TI. In my case, the ineptitude of these highly paid appointed professionals is clear and repeated in many other family court cases. In my case, the court orders state, father is to get a psychological evaluation, or words to that effect. And you can pull up the case and see the order. No specific provider or timeline was ordered. Father did as the court ordered, using a highly qualified, respected professional in the field of forensic psychology, family psychology. Cost $9,000. The TI declined to accept it at the next hearing, declined it, and ordered a second psychological evaluation by a specific individual within his circle of influence at an additional cost of $14,000. By the way, no personality disorders were discovered. But
Excuse me. Okay, so two things. No personality disorder was discovered in the first examination, correct?
correct,
Nor in the second.
correct.
Okay. This is just a general comment, not just for you, but for everybody testifying. We really need to, and so far you've done a pretty decent job. We got to focus on facts and your experience and not make allegations of crimes because, and here's why I say that. The facts will reveal any potential for perhaps a referral. I don't want to jump to the conclusion that a referral is necessary until we have the facts as a foundation. Okay?
Okay.
All right. Thank you.
Please
proceed.
I'll try to apply that as I understood.
You might have to kind of massage your remarks a little bit, but we don't want to make any criminal allegations at this point because this is a fact-finding hearing, not a presumption hearing. Okay?
Right.
All right. Thank you.
So, no personality disorders were discovered, but additional 90-day no contact orders were enforced while the process dragged on for months. The second psychologist doing the evaluation decided to take 6 weeks and go to Africa. I was not allowed to see my son during that time. I had to wait for the second psychological evaluation.
Okay. Excuse me just a second. Let's go back to the first psychological exam.
Yes.
Were you able to submit that to insurance and have
No.
insurance cover it?
No, sir.
Was any of this covered by insurance?
These two psychological exams were not covered by insurance. And I did have good Blue Cross insurance, very good insurance.
To that point, Chair,
Yes, ma'am.
thank you. To that point, I just wanted to state that court-ordered therapies are not covered by insurance. And usually it's the insurance is the one that makes that designation.
That's
I appreciate
correct.
that, Senator. It may be a distinction without a difference, but it doesn't sound like this was ordered by the court. This was ordered by a TI, who is not an officer of the court, but a contractor with the court.
That's correct. The court order, the judge asked for recommendations from the TI as they often did, always did in my case. The suggestion or recommendation by the TI was to the judge, he should have a psychological evaluation. The court then ordered the psychological evaluation.
Okay, so there was indeed an underlying court order. Okay,
Yes.
all right. Thank you for the clarity. Go ahead.
Okay. This kept my son and I apart for an additional 90 days, an additional 90 days. This went on and on for 11 months.
Excuse me, and that's because of the psychological examination.
That was part of it.
That has been ordered.
Well, that was part of it.
Okay,
Initial order was done without cause.
okay.
Okay? There was
Got
no
it.
just cause. There was no evidentiary hearing. It was just recommended by the psychologist, and the judge ordered it.
No foundation as
None.
to why this should be done.
None whatsoever. My rights were violated.
Okay, all right.
Point 6, The family court judge always asked the TI for their recommendations during my experience in my trial. This has been repeated by other parents to me. This is how they operate. The orders following the hearing or trial always or often follow the TI recommendations, apparently without gathering, reviewing, or giving appropriate weight to the hard evidence that is contrary to the TI reports or recommendations. Reference my case. It seems like the family court rulings and orders are being directed by the TI, not the judges. While this allows for plausible deniability on the judge's part, it also hands the power of the child-parent rights to a non-legal, unqualified party who can financially benefit greatly from the abuse of power and prolonged family crisis. Where are the checks and balances? Point 7, TIs are granted immunity. Immunity appears to be the broad and far-reaching. Too much power is handed to TIs in the family court system. That power may have been abused. I reference a case you can review, the Sachs versus Branton case. It goes right to that point. On 3 points in civil court, criminal court, and family court, Sachs lost. Immunity was cited, case dismissed.
Okay.
Those are facts. Family court does not always follow Arizona law. Point 8. Constitutional rights stripped away without due process, cite my case, removing children from a parent's care. More specific examples and legal citations are forthcoming from my attorney on my case, in particular, in the legal language, which I'm not qualified to provide.
Yep. Mr. Chair, Robert, I want to first make a comment on something you said. If these TIs are acting as judge, my biggest problem from a government these judges are elected by the people. The TIs are not elected. That is a huge problem. So I just want to say that because it's very disturbing to me. But I want to talk to you specifically because I had asked a little bit about the reunification type program. I guess, what was your experience with that? What did it cost you? How long were you kind of stuck in that hamster? Just all of the basics of that reunification
Certainly.
therapy.
The IFT program cost $15,000. The pre and post averaged, I think it ran up to about $4,500 from my recollection, okay? My experience with that program was 20 minutes with Dr. Branton, the TI, who ran the IFT, in his office. I got the bum's rush out of the office when he asked me to tell my son to do everything he said, regardless of what it was. My response to him was, I will tell my son to work with you in your program and do everything you say up until a point he does not feel safe. And we're talking about a very intelligent 15-year-old at this point in time, not a 5-year-old. He's old enough to know what's right and what's wrong. My experience beyond that was I was never invited to an intensive family therapy session again. Not one. I spent near $19,000 for intensive family therapy and got 20 minutes with Dr. Branton. Did that answer your question?
Okay. Please, we need to have you wrap up because I got a whole bunch of people in the holding pattern.
Understood. The damage doesn't end when the children reach the age of majority. A number of things to set the stage for long-term grifting of family resources, creating a continuous long-term revenue stream of therapy, and causes even longer-term problems when children age out. Children having reached the age of majority find themselves needing help to deal with the additional trauma caused by not only the abusive parent, but also the brainwashing done by the TIs who use dark psychology in their processes to reprogram the child to tell them their abusive parent isn't abusing them. It's all in their head. Mm-hmm. Then there's the emotional damage done to the good parents who which can spawn the need for therapy to recover from the trauma of watching helplessly while their children are taken away, forced into the homes of the abuser to suffer additional abuse and brainwashing. Eventually, the good parents discover the brainwashing that the TIs have done to their children, making the child believe he is at fault. This is the goal I hear repeatedly. It is true in my case. They made my son feel like he was the problem, not the abusive parent. Testimony by survivors who aged out is available. See the video testimony, and I've cited Tori Nielsen, who spoke to the House of Representatives last year on 3/19/24. It's a very moving testimony. Please watch it. It'll give you greater insight into our problem that we're trying to overcome here. And that's all I have. I've got some sightings on the back page from my case, but
Okay, Robert, if you would, please make sure that Zach gets whatever materials you've got to turn over to us, and it'll be a part of the majority report. Members, any questions for Robert?
Yes, I have a question.
Representative Fink.
I was actually part of or helped out the parents to be able to get the ban on the reunification camps. But I see this intensive family therapy. Did that happen right at the time that we were getting that bill passed? And is that basically the substitute for these reunification camps?
it went hand in hand with reunification camps. Yes, it was going on at the time we were working on SB 1372. So that was coincidental to my case. So my son, luckily, didn't get drug off to another state or trafficked to another state for a reunification camp. Victoria Nielsen did, and you can see her testimony if you didn't hear it before. Did that answer your question?
Well, yeah, I was there. But what I'm saying is that we banned reunification camps here. Is this intensive family therapy the loophole to be able to basically do the same thing?
I don't know. I only had 20 minutes of it.
Okay.
I just couldn't say. Other parents may be able to say,
Okay,
speak
thank
to
you.
that.
Well, that's also something that we can research and try and
Right.
validate. Okay. Members, any further questions? Robert, thank you very much for your testimony.
Thank you all.
All right, next up, Mr. Jeff Taylor. Mr. Taylor, good to see you again. If you would,
Nice to
please
see
give
you
your
also.
name for the record and who you represent, and you've got 10 minutes, and I'm going to put you on the clock.
I can probably do it in 3. Thank you, Mr. Chair.
Excellent.
and
I'd like to
members.
hear your time savings.
Okay. My name is Jeff Taylor, representing the Salvation Army, and I've had probably almost 2 decades of experience in family court, not for myself, but for our clients. So I've had a broad range of experiences, but what I noticed is that the family court system is really an industry. It's an industry to create extensions. It's an industry that will create increases in billable hours. So let's just take one case. So a woman's going to file a divorce proceeding. The papers are served. Now they've got 2 attorneys that run to the court to see who can get an order of protection first on the other person. And that just takes someone going to see a commissioner. Commissioners want to be judges, and so they want to err on the side of the caution. So let's say it's the woman. She says, I'm in fear. No reason to be in fear. He doesn't ask, what are you in fear for? Order of protection is then placed, which now encompasses the children. Now that attorney has leverage over the other side because now they use the children as a weapon. And just to take this one case further, so there was an allegation of drug abuse on the one parent, the male. So the normal protocol was 8 random drug tests over a 2-month period. This individual did 106 drug tests over a 1.5 year period. All were clean, extending then the therapy and all of the other things that were ordered upon this person.
I'm sorry, Jeff, I need to stop for just, so 106, were these a routine that was set by the court? Or is this something that he took upon himself to prove that he was clean? Or give me a little bit of context.
It was thank you, Mr. Chair. And yes, it was ordered by the court, and that the drug tests to be witnessed. That's very key. Witnessed drug test. That means somebody sees you give the sample.
Okay,
and
simple
that's what this
math
person
tells me
did.
that, I'm sorry, I didn't mean
Yeah.
to talk over you, but simple math tells me that's a drug test every 3 days?
It
for
was
a year?
twice. It was twice a week, approximately twice a week for a year and a half. All clean.
Oh, and there, throughout the entire testing regimen, there was not a hint of, okay.
There was only the allegation of a drug history, but no behavior.
Okay.
Then the family law attorney started to coach their client to make, because you have an order of protection, right? To start making allegations that you had to call the police. I think he's outside. He might be here. I don't know.
Okay.
25 calls to the police.
Let me stop here. So this is, for all intents and purposes, this is speculation.
Mm-hmm.
I'm looking for firsthand experience that you observed. And if this isn't something that you observed, let's try and get back to where you observed something
Yes.
that you can report.
Thank you, Mr. Chair. I was in court with this individual for a year and a half. He was one of our clients.
Okay, I guess that's pretty close.
Yes.
All right, thank you.
And the allegations, Mr. Chair, of calling the police, this individual was in our program with a sign-in, sign-out sheet and couldn't be there, was in our residential facility.
Uh-huh.
How this person stayed sober through this experience is beyond me. There was no opening up, or there was no reward for the hard work that this individual did to handle his addiction. There was no payoff. But during that time, the judge ordered supervised visitation along this way. In the second report from the person doing the supervising, it said, I see no reason for this person to be in supervised visitation.
Where'd that report come from that said that?
From the individual that was doing the supervising. So the judge ordered the individual to have supervised visitation, which the individual did, and started this process of supervised visitation after a year of drug tests that were clean. And in the second report, which were weekly, Mr. Chair, in the second report, it started off with, I see no reason for this person to have supervised visitation.
Oh, okay, Jeff, just for clarity, and I'm sorry, I'm trying
That's okay.
to make sure that I understand the timeline here. Second report, the individual that the court appointed to supervise tells the court no reason to continue this. Yet the court continues to call for the drug test. Was there anything else besides the drug test? Was there mandatory therapy? Was there mandatory intervention? Or was it just the drug test?
Mr. Chair, the therapy the individual was in was a 6-month residential drug treatment program and now is in transition. So still in a program.
Okay.
Long-term residential treatment. So I went with the individual to court to bring to the court's attention the second report stating there's no reason for this person to be in supervised visitation. And the judge, when questioned, have you read the report? The judge hadn't even read the report and kept those same orders in place.
And this
Hadn't
judge's
even
name?
read the report that judge ordered.
The judge's name?
Well, there were 2 Reinsteins at the time. There was a really good Reinstein, and there was a not so good Reinstein. And I'll
Don't
leave it
pass
at that.
judgment, I'm just looking for a name.
Pete Reinstein.
Okay, all right. Okay, your 3 minutes is up.
Thank you, sir. And thank you for taking on this issue. Members,
Thanks.
thank you for your time.
I appreciate your testimony. All right, next we have Mr. Monty Schultz. Mr. Schultz, if you would, please give your name for the record and who you represent, if you represent somebody other than yourself.
My name is Monty Schultz. I'm a licensed clinical social worker in Prescott, Arizona. I'm also a licensed independent clinical social worker with a Nebraska license. I appreciate the opportunity, Senator Finchem and Representative Cashiel, that you chaired this type of hearing. I've seen these issues. I've been a social worker for the last 14 years. We just moved here 2 years ago, and I didn't think that I would be involved in this type of hearing again, as this issue is nationwide, right? And you are taking the initiative to address some pretty significant problems with the family court system. I've been
I'm
through
sorry, Mr. Schultz, you moved here from?
Nebraska 2 years ago.
Okay, and I think what I hear you saying is you moved away from a similar problem to a similar problem.
This court is this issue is nationwide, in my opinion, right? I mean, I've testified as an expert witness in Virginia. I've been involved with the TI system in Colorado. I've been involved with it here as well, even though I choose not to work with children anymore, and this is one of the reasons I do not. In my humble opinion, I do believe children are being abused in this system, right? Kids have rights too, right? And we are, in many, many cases, taking fit parents out of the lives of our children, right? And it's done as a grift for the court system. It seems like, as I've experienced the system here in Arizona, I'm watching it as, or seeing it as, we appoint these TIs. Are they really mental health providers, or are they investigators, right? And if they're investigators, do they have the credentials to investigate? This bill 2256 was regarding parental alienation, which is something that should be considered abuse, right? So if they're investigating parental alienation and not reporting this to the agency that is statutorily required to investigate abuse and neglect, who's the investigators, right? So here we have a problem with the family court system. We had another individual come up and say that judges are not statutorily required to
make a referral?
Make a referral for child abuse. Thank you. There's a moral problem with that, right? These are individuals who are first lawyers, who are probably statutorily required to do this, and become judges. Who's getting rich within our system, right? It's lawyers, and in Arizona, it's TIs, right? This is a grift. I bill insurance for my services. On average, I make from $60 to $110 per session, right? I'm glad with that. I'm okay with that. These people are making upwards of $300 per session, right? And they can't bill insurance because it's court ordered. You know, but however, I'm not sure that that's really accurate, because I've had people that have attended my sessions with me that are court ordered to be in therapy, and insurance companies pay for it. So it's really the issue of how much they're getting paid.
Monty, it just occurs to me, if I think I hear you saying that to hide behind the court order aspect of ordered therapy may relieve a therapist from having to abide by certain insurance company requirements or regulatory requirements?
Absolutely, yes.
Okay.
When you're credentialed with an insurance company, you agree to provide services
within guidelines.
Within their guidelines.
Okay.
Mr. Chair, usually it's called customary, usual and customary fees that the insurances will pay. And so therefore, what I'm understanding is that they charge so much more, therefore they would not get paid because it's beyond the usual and customary fees.
Well, beyond that, here's the real issue with the insurance. If the insurance company is willing to pay $100 for your services, and you bill $300, there's no mechanism to collect the other two because that's against the insurance guidelines.
Exactly.
Right. So therein lies the grift. Right. If you are doing this for a fee for service and you're charging $300 for this per session with, so then you're making 3 times the amount of money. Right. And again, the kids are the ones that are losing out in this. Right.
To your point, thank you for rescuing me on the term. I appreciate it. Okay, Monty, we've got 2 minutes for you to finish up. If you would put a bow on this.
Okay, here's the thing. We're talking about GALs earlier and GAL training. We're talking about training for TIs. We're talking about training for lawyers. If you and you established this in your bill 2256, right? You have to look at where they're getting that training. More likely than not, it's all at the same place. And so they're all like-minded, right? And so are we going to end up in this situation of repetitive problems with the family court system because they're all receiving the same training and there's nobody from outside the system able to work within that to provide a check and balance for the TIs that are currently doing this, the lawyers, all of this, right?
Would it surprise you to know that there nowhere in Title 13 is there reference to a criminal act called parental alienation?
No, it would not surprise me at all.
So that perhaps explains why certain individuals are not duty bound to make a report because there is no such crime.
However, there is a crime for psychological abuse. However, right, it's almost impossible to prove that. My wife worked for Health and Human Services for 20 years as an investigator and as a supervisor for juvenile parole and abuse and neglect. 0 cases of psychological abuse. in
Well, and
20
I
years.
think to that point, it's being used as a weapon
Yes.
to say that they're basically weighing psychological abuse or parental alienation versus physical abuse in a lot of these cases.
Absolutely, and it seems like to further that, it seems like the court system is appointing these TIs as case managers versus using the judicial system to solve the divorce and custody issues.
I'm going to throw a hypothetical at you, and if you prefer not to answer it, I'd appreciate, just be very frank. If you are an individual making a recommendation to the court about somebody that the court has asked you to look at, a recommendation for therapy or extended something, I don't know what all the options are in your world, would it be inappropriate for the court to turn around and order you to provide that care?
In my opinion,
For failure of an arm's length transaction?
in my opinion, yes. Right. And here's the reason why, is because if the court is ordering me to provide a service, I'm providing that service. The court is supposed to regulate coercive practices in family court. At that point, are they doing that?
Mr.
Thank you.
Mr. Chair, I have a question.
Representative?
So in your opinion, I have heard from various parents, but that these TIs have immunity, and the explanation that these parents have received, why do they get immunity, is because that nobody else would do the job, so they need to have immunity. Is that what you've heard, or is that what you have seen?
That's what I've heard, and I don't understand. If they were practicing within the guidelines of, say, the APA or the NASW, why do they need immunity?
That's my question.
I don't have immunity.
Yeah. Okay. Thank you.
That's perhaps one of the most interesting observations made today. Why? All right, members, any further questions?
I have
right. Thank you,
I have
Mr.
a
Schultz.
question, Chair.
Senator Hatothli.
Thank you. Thank you very much for your testimony. My question is, how are these fees, how are they assessed when we talk, and you made a reference regarding, or well, you didn't, but the prior individual did, how individuals have to submit their finances. Is there a correlation between that information that's submitted and how these court appointed advocates or advisors, which also include the TIs, do they use that as a way to establish their fees? I don't, that's what I want to know.
I don't know the answer to that question because I'm not a TI, nor will I be a TI for the reasons I've talked about here.
Thank you.
Okay, members, any further questions? All right. Thank you, Monty. I appreciate your testimony. Just, I suppose, an observation. Once again, we go to this question of quasi-judicial immunity, and I would substitute authority for immunity, and the delegation. Now, there's a non-delegation doctrine for the legislature. In fact, that where that came up is the Chevron deference opinion out of the Supreme Court, that the legislature cannot delegate its responsibility to agencies. It occurs to me that, and perhaps this is something for the legislature to take up in the next session, why then are judges permitted? I mean, these are supposed to be the arbiters of, neutral arbiters of questions of law and fact. Why then are they delegating responsibility? This is tracking well with what you had suggested, that perhaps they're case managers. They're not actually offering therapy. They're acting more like traffic cops to send people off to get out their checkbook and pay for services. Sorry, that's an observation. I guess one of the questions that I've got for you tracks along with the idea of a guardian ad litem or representation for the child. Because I think what we've heard so far is that this is all about the adults. Yes. I've not heard a single person talk about the kids, not one, other than parents. So that gives me grave concern about the focus of the family court orders. Do you think it's appropriate, or should it be, in your professional opinion, should it be the state's responsibility to appoint a guardian ad litem, I hate to use guardian ad litem because that's got a very specific connotation, but representation for the child in this? Once the court has entered into this therapeutic regimen, it seems like there needs to be somebody representing the interests of the court. If you would mind commenting on that before you walk away.
So I'm not sure that the typical term guardian ad litem usually means attorney, right? Other states expand that a little bit and will allow professionals in my field to serve as like advisors to that youth, right? So I don't know if it's if it's a good thing or a bad thing. Because again, you have to look at where these individuals received their training for family court, right? And it seems like in Arizona, there's not very many places, and they're using one specific place.
Okay.
Well, and really quick, Mr. Chair, to that point, if we start talking about getting a guardian ad litem, we need to be really careful. There's a lot of research done that a lot of times they're not even talking to the kids. Right. There's a whole documentary, Undercovers, that specifically looks at how the corruption is right in the middle with that person. So we would definitely, I think we need something, but we would have to definitely regulate that and really know what we're dealing with.
And who's going to pay for it?
Yeah, true.
Okay. Thank you, Bonnie. I appreciate it. All right. Next up, and I probably should make an announcement right now. For those of you who have grumbling stomachs, lunch is available out on the Senate lawn. You can't eat or drink in here, but if you find that you need sustenance before 12 o'clock noon when we break for lunch, there's lunch for purchase out on the Senate lawn. And by the way, the Senate does not make a penny off of it. Okay. Now you can laugh. All right. All right, next up is, yes, there was a reference to an arm's length transaction there. Next up is Steve Alcott. Mr. Alcott, are you in the room? If you would please come to the microphone, give your name and who you represent. Oh, you don't want to talk? Okay, great. We just saved some time. Next up, Vivian Miller and Claudia Reedy. Forgive me if I butchered your name, ma'am. If you would please come to the microphone, give your name and who you represent, if you represent somebody other than yourself. Oh, there's a little switch right there. Just push it down, and it'll go down.
Just hold it. Yep.
There you go. All right. And if you would, get as close to the microphone as you can when you give your name and you're speaking, okay?
Hello, thank you. Hello. Thank you for having me here. I am Viviana Miller. This is Claudia Reed. We are part of a sect of Me Too Court 383 in El Paso, Texas. We're here in support for all victims of family courts. This is a nationwide problem. This case began with an ex parte order, which is very familiar in a lot of cases where an ex parte order is being filed. To this day in which I was never given due process, let alone a day to fight these accusations, in which my daughter was forced to move here in Arizona with someone who was a stranger, who is now our abuser. This order, in fact, was random and out of the blue. Upon hiring an attorney, being told continuously by many attorneys actually, who should be holding up their ethics but do not, that I would not stand a chance unless I go through jury trial, in which everybody knows jury trial costs more than $20,000. But in the end, the judge will still decide the parenting time. Despite going to jury trial, the judge will still decide. And that's in many cases. In my personal case, the opposing party's attorney is the judge's campaign treasurer, in which many parents are dealing with this judge and this attorney hurting their children with their abuse of power. Children are being mentally abused, physically, spiritually, and sexually, all under these court systems who do not care and threaten them for speaking up. To these judges and attorneys, every child is merely just a dollar sign.
Okay, ma'am, if you would, please contain your comments to your personal experience.
Okay.
That's what we really want. That's where the meat of the matter is, okay?
Yes.
I know that you came a long ways to testify, but that's really what we want to hear about is your personal experience.
Okay. Not just in, there was an instance where I was told to file the grievance by the DA in my town, and because the opposing party's attorney made a false email with his email a part of it. He told me I filed a grievance, and when I did so, my current attorney that I had withdrew because her words was because I have to look out for my family too. She was indeed afraid of retaliation, and I did have that in an email where she was afraid of retaliation.
And I'm sorry, retaliation from?
Against the judge.
From the judge?
Yes.
Okay, just time out. Because she was representing you, I presume you believe to the best of her ability?
Yes.
She experienced some level of fear of retaliation?
Yes.
Would that be because she wasn't going along to get along?
They tried making it a false email, trying to say an email clarifies as a court order. And I brought that to the DA's attention, and the DA said file a grievance because his name was on there. And when I did so, she withdrew. Because
I'm sorry, file a grievance because of why? What was the
for trying to say an email was a court order. It wasn't a court order.
Oh, okay, so somebody misrepresented an email as a court order in order to try and compel you to do something.
Yes, sir, the opposing party.
And when your attorney brought that up, the court didn't want to hear of it.
I had taken it straight to the DA of what do I do next, because the DA was my previous attorney who was working on that order. So when I brought it to him, like, hey, they're falsifying your email in this email saying that you agreed upon this, what do I do? He went and said, file a grievance. And when I went to go file that grievance, she called me immediately, hey, you did this, I need a withdrawal. Because I have to look out for my family.
Okay, so this wasn't the attorney, this was the therapeutic interventionist.
No.
This is the attorney.
Yes, the
Too
attorneys.
many players here. Okay. All right, I think I'm following you now. Ms. Keschel.
Mr. Chair, just for a point of clarification, is your case still in Texas, or is the jurisdiction here in Arizona?
We are looking to move it here in Arizona.
But currently it's in Texas.
Currently in Texas, because this is a nationwide problem, we came in here for
No,
support.
I really appreciate that you're here. Thank you.
Okay.
And,
Senator Warner. Ma'am, time out. Just
Sorry.
got a question.
sorry.
Where is your child?
She's here in Arizona, Phoenix, Arizona. She was forced to move here in Phoenix, Arizona, with someone who was never a part of her life.
Okay, point of clarification. Your child is here in Arizona with a non-parent?
No, so it's her father. Her father, who was never a part of her life. He was I can't say never. He was maybe 3 times a year.
Okay.
And it was very
We're not
random.
gonna go down the
out
path of other parents.
Yes.
Okay. The question is well taken that your daughter is here in Arizona and you're trying to move the case from Texas here to Arizona, correct?
Yes.
All right, thank you. Please finish up. You got about 2 minutes.
Many of us parents in that court have a gag order because they don't like the children to speak up or the parents to speak up as well.
I'm sorry, this is a court in Texas that has a gag order?
Yes.
Okay.
We are here in support that this is a national emergency, to be the voices of the children from Texas and all over who are suffering, including my own, who was forced to move here in Arizona. Yes, children are resilient, but upon those words, we are turning those same children into adults with problems. It starts with us. We have to do better. These children are learning to lose faith in the same adults who are supposed to protect them. This is a system that should protect them and not exploit them or profit off of them. And that's all.
Thank you for your testimony.
Thank you so much.
Ma'am, do you have something to add, or are you basically the ditto?
It's really short.
Okay. Please give your name for the record and who you represent. And you've got like 5 minutes, okay?
My name is Claudia Rede. I am from El Paso, Texas. I decided to come here because my granddaughter was removed from her mother by an ex parte order and relocated to Phoenix, Arizona. My granddaughter's father's attorney happens to be the judge's campaign treasurer. My granddaughter was never in immediate danger. I just wanted to say, Arizona, you're not alone. The family court crisis is a national problem. Many of the issues heard here are the same issues we have in El Paso, Texas. I feel the biggest issue is family court judges having immunity and no real accountability in their actions. Judges handing gag orders with the threat of time lost with the child. Judges given the power of discretion and not always based on law or the best interest of the child. Thank you for allowing me to speak.
Thank you both for coming. Members, any questions?
Mr. Chair,
Representative Fink?
I'm just curious because usually gag orders I hear more in criminal cases. So what was the basis and the authority to be able to issue gag orders on parents and the child?
To protect the privacy of the child.
Okay. Thank you.
That's an interesting twist. All right. All right. Thank you, ladies. I appreciate your time and your testimony. All right. Next up, we have Mr. Martin Lynch. Mr. Lynch, you in the room? If you would, Mr. Lynch, please give your name and who you represent if you're representing somebody other than yourself.
Mr. Chair, members of the committee, we appreciate your efforts to search for solutions to what we all know are pervasive problems. My name is Martin Lynch, and I represent We the People Court Services and the NAACB, which is another court reform organization. I made a copy of a report that was published in 2005 for you to look at the details of, because there's a historical record that shows that the problems that we're dealing with now have been around, and they go back as far as you want to look. And it has to do with checks and balances, or specifically the lack of checks and balances because absolute power corrupts absolutely. So any individual human being, and that includes judges, lawyers, legislators, governors, everybody, that thinks that they have unlimited power to do whatever it is that they want to do, well then you can expect to have a meeting like this. So I just wanted to point out that what we're dealing with is a problem that goes beyond just family court. It has to do with the violation of separation of powers, where we expect to hire an attorney, and that attorney is going to represent us because we're giving him good money, and a lot of it. And come to find out that the lawyers and the judges are all part of the judicial branch of government, and that's in the Arizona Revised Statutes, Title 32, Chapter 2. If you look, that piece of legislation is no longer around. It's gone. What happened to it was it used to be the regulation of the legal profession by the legislature, along with the other 40 regulated professions that are in Title 32. And so they took it out. And what that did was it allowed the judicial branch of government to usurp the authority that rightfully belongs to this body and to the people through our elected representatives. And so now what you have is lawyers and judges who are all part of the judicial branch of government, and their job is the job of the lawyers is to take the money, and the job of the judge is to help them do it. And then what happens is that later on, these lawyers become judges. The lawyers or the judges retire, go back to practicing and making all the money. And so you can see that it's a revolving door of conflict of interest. And so if you have lawyers that are representing all these different organizations, including giving legal advice to our own legislature, if these people are compromised with a conflict of interest, well then the wheels have come off the entire system. And so the real problem is we come to the legislature, and Representative Keschel can tell you all about it, is we come to the legislature and we say, okay, we're going to put checks and balances back. That's all we need to do. And we have a bill, and it goes to it gets assigned to a committee, and then for some reason or another, or no reason, it's because it's all done in secret, is that bill is not heard because somebody told somebody something in secret, and nobody knows what was told. There's no debate, and so we are in a catch-22, and that is the foundational element of it, is we cannot get our legislators to put a bill out there to restore checks and balances. And
Excuse me, Mr. Lynch, do you have a specific bill number that you're talking about? I have. Oh, all right, I'll just check with my partner here.
And there were bills prior to this, dating back, I'm going to say 7 or 8 years, where we've been down here working these problems. Right. And that's how we've established that we can't get anything done here because the system is compromised.
So can you look like you might be old enough to know. No offense.
Sadly, I am,
Sorry.
most likely.
I meant to say you look like you've been around the block a time or two. Never mind.
Yeah.
You've got historical knowledge, tribal knowledge. Do you happen to know when approximately the move in Title 32 away from the legislature into what presumably I would say is probably the bar? Do you know about when that happened?
I don't. I do know that Article 6.1 of the Constitution, which was brought up by April Elliott, because she represents the CJC, came about, I think, in the 80s. And that was a solution that was thought to bring a resolution to the problem that we have, because then judges would have oversight. And she just came in here and told you that they have no authority, no jurisdiction to do anything about the decisions of a judge in any particular piece of litigation. They can work around the edges if the judge is crazy or if he's yelling or screaming or whatever it was that she told you. But when it comes to an appellate action, they have nothing to do with that. And then the other thing that we found out is that in these appellate actions, even if you're quote unquote represented by an attorney, if that attorney does not set up your trial court case properly in order to prevail in the Court of Appeals, well, then when you get to the Court of Appeals, they throw it out and say, oh, I'm sorry, the thing wasn't pled properly at the trial court level. And this goes on over and over again. I can show you examples of it where the Court of Appeals, Arizona State Supreme Court, ruled that because the lawyer didn't do what they were supposed to be doing, now we can't help you. And that was a DCS case. But I mean, the failure mechanism is ubiquitous across all these courts. It's DCS, family court, guardianship, probate. It's everywhere. And
forgive me, but it seems like that would be, I know makes absolutely no sense. Who would you go to? The court, if you were to challenge the lawyer's authenticity and qualifications, basically defective representation.
Yeah.
Where are you going to go? The court?
We go to the state bar.
Yeah.
And then the state bar is going to tell you, and I think one of the ladies here said that out of all the complaints made to the CJC, 485, 3 were valid. So in other words, there's no enforcement going on there. The state bar is the same. Go ahead.
There is a difference between the judicial performance folks and the bar, although it may be a very thin veil between the two. I've had plenty of experience with the bar, and I know exactly what you're talking about. So that's another problem altogether. Okay, you got about a minute to, let's try and wrap this up.
Board of Psychologist Examiners, I have firsthand experience there. I had a psychologist who recommended that I furnish pornography to my teenage son. So I go, that doesn't even sound right.
I'm sorry, time out. Who said that?
A court-appointed psychologist.
Can you reference a case?
My own personal family law case.
Okay, that's close enough to first person.
Yeah.
All right.
Yeah, I mean, I sat in the office and listened to him, and I said, what should we do about this? And he says, well, we should furnish him with acceptable pornography. That's what I listened to. And I go, what is that? And so I do my research. That's how I am. And I find out that that's a criminal act. And so we went to the Board of Psychologist Examiners, and they said, I know none of these people are probably lawyers, but the results that I have documented was that when the judge appoints a psychologist to one of these cases, that person who's been appointed is now sheltered by judicial immunity. They now have the cloak of judicial immunity, and any kind of enforcement of their code of conduct belongs to the judge. They said, we do not have jurisdiction once that court order is issued, giving them an appointment to this case. So this Board of Psychologist Examiners can tell you, oh yeah, we can do this, we can do that, we have all these different things we do. Well, none of it applies once there's a court order for a psychologist to become assigned to the case.
Well, with all due respect,
they don't tell you
sir,
that. Go ahead.
I don't give a bloody damn what the court wants to say. When someone is engaged in a criminal act, quasi-judicial immunity does not apply. You're committing a crime. That's like saying a judge who orders the very same thing is exempt because they're a judge.
Correct.
Not in this state.
So we did a criminal referral. We've been to the FBI up on North Black Canyon Highway. And all these law enforcement agencies say, well, you know what? Let the judge handle it. Or they say, we're too busy protecting the country from terrorism. And it's like, wow, okay, well, I think I have terrorism here, but, you know. So in other words, they have prosecutorial discretion. And that's a principle that we want to defend. We don't want to throw it out. However, we're looking for checks and balances here, and they do exist. They are in here. But if your lawyer is not prepared to do what's necessary to, number one, make your trial court case subject to an appeal, and number two, to take the thing to the appellate court. And then the lady just before me said that the judges exert coercive control over the judges. I'm sorry, the judges exert coercive control over the lawyers. And so we're back to Title 32 again, which is blank. Chapter 2, which is blank. And I'll just end on one last note. I keep hearing best interest of the child, best interest of the child. In the Constitution, it says due process and a bunch of other things. It doesn't say anything about that. But there is Supreme Court case law. One is Troxel v. Granville, and the other one is Santosky, where they establish that the primary, most inalienable right that all the people have is to parent their own children. And so that serves our interests. And the problem that we have is that this best interest of the child thing is an artificial construct, and it's subject to the unlimited interpretation by a judge, one person. And when you get into this court of equity, then all of your rights go out the window, and you're subject to what that person invents as what they think they need to be doing. And once you understand that the lawyer's job is to take the money, and the job of the judge is to help them do it. This is the unspoken rule. And so they have this revolving door going back and forth and everything, and it's not something that we haven't seen in a bunch of other areas of our society. And so, so I just thought I'd just throw out that we have looked at, what we need to do to fix this thing, and individual pieces of legislation have been blocked by something secret going on behind the scenes. And there's something called a Department of Government Affairs that's over at at 1501 West Jefferson, across the street over there at the Supreme Court building. And those people's job is to come over here and tell you what needs to be put into the statutes. And so until we can rein in these violations of separation of powers coming from across the street over there, then we can come down here and ask you to do stuff forever, and we're probably going to have another meeting like this 5 years from now. Who knows?
Well, Mr. Lynch, actually, we're going to have 3 more of these, and we are going to continue to try and unpeel the onion. Quite frankly, between the last installment and this one, there is a picture that is coming into focus that is actionable by the legislature. Don't think that the folks across the street have more power than you do. I want to assure you, in the words of Supreme Court Justice Ruth Bader Ginsburg, the people are the ultimate legislature. So your testimony here today, the testimony of these folks, is extremely important, because this is not, in my view, a political matter, but politics certainly is in it. Representative, I'm sorry, Fink, you had a question?
Thank you, Mr. Chair, and thank you, Mr. Lynch, for coming. I believe that parental rights, you kind of said what I was going for. I consider it kind of the 9th Amendment right, because the founders didn't want to, they were concerned that they might not have written down all the different rights, and so they have the 9th Amendment right. I consider parental rights a 9th Amendment right. And we've had discussions back and forth. We had a bill in regards to a jury trial, because it is a self-evident truth in regards to, parents and parental rights. And we've heard people say, "Oh, don't know if we want to do a jury trial." Yes. What are your thoughts on that?
Well, the limits of the power of the judge. Let's just talk about all these enormous fees that people are one after another coming up here telling you they're all going bankrupt. Bankruptcies and suicides are like another topic. When it comes to veterans and active duty military, there's a Department of Defense report that talks about how family court is one of the causes, root causes for all the suicides you're seeing in the military. So this is something that you can put your finger on.
Mr. Lynch, could you, you've cited this DOD report, could you get that to me, please?
Okay. But I will tell you that the biggest check on the power of these people to take all your money is in the 7th Amendment. It sets forth a dollar limit that the judge has unlimited authority to take your money. And there's a dollar limit in the 7th Amendment over which the judge no longer has that authority unless you do not demand a trial by jury. In other words, I don't need legislation. I can go right here. And it says anything over $20, well, that authority belongs to a jury. That's what it says. Okay, but if you don't have an attorney who's willing to say, well, you know what, $20,000, that sounds a little bit much. Here, we want a jury to decide if you're going to take my children away unless I give $20,000 to your friend over here. And that's when, and this stuff is going on right now, and it's not something you hear about, it's not something that's publicized, but it is in individual cases where these cases just resolve once you take their authority to steal your money away. Well, then why are they messing with you? Why don't we just get rid of you and go on to the next poor person who doesn't know that we can't just arbitrarily take your life savings away from you? So,
and to that point, Mr. Chair, it also in the Arizona Constitution, there is also the right to a trial by jury as well. So I
Correct.
think that is something that is supposed to be the check on a lot of these abuses.
Yeah. Mr. Chair, I need one before we let you go, Marty. And you've been at this fight for before I was in the legislature. So thank you for doing that. I need a point of clarification what you talked about. I think you said Title 32, that it just disappeared. What do you mean that there was something on the law books in Arizona that just, I really want you to clearly say.
it's the regulation of Chapter 2 of Title 32. Used to be the regulation of the legal profession as prescribed by our elected representatives through the legislative process. That's what it used to be. But somebody came in here and said, oh, you guys need to get rid of that because we're smarter than anybody else, obviously, because we're judges. If you don't believe me, ask one of them. And they say, well, we'll go ahead and regulate the legal profession because it's so hard and difficult to understand, only we can understand it. And what we understand right now very well is that this whole system, this whole process has been co-opted into a money-stealing operation. That's what it is.
Well, and I think to that point, Mr. Chair and Marty, I know you had a piece of legislation that you ran, I think it was my first session, about having to do with the court being able to lobby us over here in the legislature. I have no idea how one branch of government is allowed to lobby another branch of government and affect all of you. I don't understand that. They say that they don't lobby, they only lobby when it has to do with fees. Do you believe that to be true?
Not at all. I mean, I've sat in this room where elected representative would say, well, somebody will present a bill, and I don't remember the specifics of it, but I think it was February of last year, and they said, and one of the representatives here said, the senators said, well, I've got to find out what the courts think before I vote. And it's like, oh, okay. Well, you better do what the courts tell you to do. We all know that. And because lobbyists run around here like they belong here, when the fact is anybody that knows the Constitution or as interpreted by high level court rulings knows that you guys don't belong here at all. Get out of my office. What's the matter with you? Is this a stupid test or something? I don't know. Get out.
Your point's well taken. There's a reason that the Constitution, in fact, ladies and gentlemen, we're going to have a little Constitution question here. Right. Article 1 is the legislature for a reason. It's the closest to the people. Article 2, the executive. It's supposed to do what the legislature tells it to do. Execute. Article 3, the judiciary. They're there to call balls and strikes. Did you break the law? Did you not break the law? This notion of 3 co-equal branches of government is a progressive era falsity. It is a fiction. So for the legislature to bow down to another branch of government, your point is well taken, sir. That is not our job. Our job is to represent the interests of the people, and in this regard, the interests of children, especially. Because who else are they going to turn to? You got 2 parents, please don't take any offense, they don't like each other. They don't want to be together. But there's still a child that's misrepresented in this whole affair. So, Mr. Lynch, thank you very much. I want to make sure that we get another couple of parents in before we break for lunch. Okay, next up, I appreciate it, and if you would, please get that material to my office because we want to include that in our report. All right, thank you.
Mr. Chair, to his point real quick, I had a bill for administrative courts to have a trial by jury, and I did have the legal, or the judicial branch not wanting to do that.
Yeah, well, we can talk about that offline. All right.
I thought we could say names.
We'll get it on the record at some point, but not today. All right, Atalia Durfield? Atalia? I probably butchered your name. I'm sorry. Hi. If you would you please come up and, let's see, you're going to have to bend the microphone down just a little bit. Get it as close as you can. I take it by your appearance you may not be over 18.
No.
So you
I'm
are
16.
a minor.
Yes.
Would you please give your name for the record and tell us your story? You have 10 minutes.
Okay. Good morning, members of the committee. My name is Atalia Durfield.
Get as close to the microphone as you can.
I'm 16 years old. Thank you for giving me the opportunity to share my story with you today. When I was 5 years old, my parents got married. I remember being so excited when we moved. I had never lived with my father before. My excitement was short-lived. My first memory of my abuse, I was around 6 years old. For the next 7 years, I endured so much from my father. When I was 13 years old, my dad was living out of state for work. He had been doing so for months. My mom decided to file for divorce. Once she did, he moved back to Arizona immediately, demanding 50-50 custody of my younger sister and I. From the very start, I made it clear that that was not what I wanted. I spoke to countless professionals. I told the courts that I had been severely physically and emotionally abused by my father. I spoke about how I had been hit, screamed at, called names, grabbed, or shoved. I often felt like I was walking on eggshells in my own home. I lived in fear, and I carry that fear with me every day. I begged the court not to make me go back because I was and am terrified. My father was given supervised visitation with my sister and I. The supervisors claiming I would be protected and that my boundaries would be respected. They were not. I was appointed a court-appointed advisor. I spoke to her only twice, once in person and once over the phone. I tried to be honest about my experience. I wanted to make her understand why I didn't want to go. When she spoke in court, she spoke out for me. She asked the court to take my wishes into account. My father was given unsupervised parenting time and joint counseling with me despite this. I didn't want to go to the counseling, but since it was court-ordered, I went in open and willing to try to repair our relationship. But it quickly became clear that I was the only one trying. In those sessions, I was gaslit, lied to, and accused of making things up. The therapist and my father seemed to gang up on me. It felt less like counseling and more like giving my father permission to continue treating me poorly with the therapist as a witness. Even though my court-appointed advisor advocated for me, even though I told the truth about what I had been through, and even though I made my wishes clear, the court still gave my father unsupervised time with my sister and I. I felt invisible. I had done everything they asked of me. I spoke up. I shared painful memories. I trusted adults with the hardest parts of my life. But none of it mattered. It felt like no one believed me, or worse, like they believed me but didn't care enough to protect me. The message I got was that my voice doesn't count, that my safety doesn't matter, and that what happened to me isn't important enough to change the outcome. All I ask of you is to listen when we speak and protect us when we are afraid. Thank you.
Thank you, young lady. Members, any questions?
I'd just like to make a comment,
Please.
Mr. Chair.
A comment or a question? I'm sorry, I'm having a hard time hearing you.
A comment.
Yeah, get right up into the microphone so I can hear you.
Oh, yes. I just want to say thank you. Thank you for your bravery and for coming up and telling us your story. Really appreciate it. Thank you.
Senator?
Thank you for coming and sharing your story, and continue to be brave and keep sharing. Thank you.
You got a lot of courage, young lady. And after speaking with a number of, as the court would say, minors, you are just as articulate as any adult I've ever met. My compliments.
Thank you.
Thank you for coming today. All right. Okay, next up, Tia Korick. I know you want to bust out with the applause, but if you want to compliment her, at noon we'll be breaking for lunch. You probably want to talk to that young lady because she's an up-and-coming leader. All right. Tia Korick, if you would please give your name for the record, who you represent, if it's somebody other than yourself, and get as close to the microphone as you can. All right?
Okay. I apologize. My name is Tia Korick. Her story reminds me a lot of my daughter, so I am apologizing in advance because that just made me really emotional to hear.
It's okay. We're all a mess.
So thank you for the opportunity to speak today. I'm here to share my experience with the family court system, not just for myself, but for the countless families caught in a system that too often fails to protect children and punishes the very parents trying to do the right thing.
Hey, Tia, you can slow down a little bit. Okay.
I'm not a great public speaker either, so
That's
I apologize.
Okay. I'm not going to put you on a time limit, but just know you're the one between lunch and these folks. But that's okay. But that's okay.
Okay. I'm here. My journey began in 2017, but the true nightmare started in 2021 when my children disclosed abuse. I did what any responsible parent would do. I reported to police, DCS, and the court. Instead of getting help, I was punished. My children were taken from my care and placed with their abuser simply because I reported the truth. The police initially refused to investigate and told me to get an order of protection.
Excuse me. What police department?
Peoria Police.
All right, thank you.
Well, actually, it started with Phoenix Police that told me, but Peoria Police is the one who actually investigated everything for 3 years up until current.
Okay, I was just looking for a reference of where this occurred.
A judge granted it, but only for my daughter, and refused to include my sons, sending us to family court instead. Just 2 months later, despite the order of protection being in place and never appealed, the court gave full custody to their father. A court-appointed advisor and best interest attorney were assigned. Neither ever met my children, reviewed medical or counseling records, or visited their schools. They submitted biased, even falsified reports. They were exposed in court, but no action was taken. When I brought my concerns to the procurement department overseeing these contracts, they admitted they were not monitoring compliance, including whether or not professionals even had active insurance as required, and nobody was monitoring their caseloads. I have done my own research that many of these court-appointed advisors are earning millions of dollars off of children. They are not ever meeting the kids, but getting a paycheck to do so. The day after custody change, my daughter was kept home from school. She was verbally assaulted for speaking up, locked herself in a bathroom, and called the police. She later attempted suicide and was hospitalized in the ICU for a month. I wasn't informed. I later learned the court-appointed advisor and her father falsely told the hospital I was barred from contact, though no such order existed. A hospital worker, sensing something was wrong, risked her job to allow us to speak one time. That was my only contact for months. The entire time my daughter was in the hospital, I was not allowed any access to information. I wasn't allowed to speak to her. She wasn't allowed to speak to me. She would be crying. And she was given an angel to sit by her on that day that allowed us to at least speak one time. That was in the beginning of December 2021. I was granted a 2-hour visitation on Christmas Day and then denied access again for 4.5 months. No speaking to my children, no seeing them whatsoever after I was the primary parent since birth. I filed motion after motion to enforce court-ordered parenting time, all when ignored by the judge, who issued this order as retaliation for me disclosing these abuse to the court. When I went to court for the initial emergency orders, we came in and they said, well, DCS and the police hadn't done anything yet. They must not believe you. You better make sure the kids go to their other to the other parent's home. I pleaded, like, what do you want me to do? I cannot push them outside the door when they're crying and refusing to go. And he told me, ma'am, you better make them go or I'm going to take them from you 100% and put them with father. I pleaded, please don't do that. He said, well, then you better do as I say.
Who's the judge?
Judge Scott Blaney. I had a
I'm
total
sorry,
of Judge Scott Blaney. He is now in the criminal court. He moved over from family court.
Okay.
However, I've had a total of 8 documented judges throughout my case during 2021 to 2024. So every time I would file a motion with the judge saying, like, he's not allowing me my parenting time, he just ignored them. The only reason my kids were taken is because, again, I went to the court. A police investigation opened up after our hearing where he told me they better make sure they go. At that point, Peoria Police ended up opening an investigation due to the doctor's office calling the police and reporting their concerns for sexual abuse. Because of that, my kids were taken 100%. I didn't see them. Finally, in April of 2022, I finally got into the court.
I'm sorry, Tia, can we go back just a second?
Yes.
This is your daughter's physician contacted law enforcement and reported suspected sexual abuse, I presume by the father.
Correct. Yeah.
Okay.
Yep.
I just want to be clear on what you had said.
I apologize too, because I can be a
that's
little
all right.
all over.
That's why I stopped you for just a second, so you could collect yourself and now go on.
So the police came to the doctor's office. They told me the kids cannot go to their fathers while this active investigation is ongoing. So now I was put into this position of, who do I abide by? The judge is telling me, you better make sure these kids go. And now I'm saying, if the kids go, DCS is going to take your kids from you. So what do you do? Obviously, I still didn't let them go. Finally, in April of 22, once I was able to see my kids, I got into court, I should say, they ordered me to supervised visitation. Again, just for reporting the abuse. There's no other allegation anywhere on me, ever. So they ordered me to supervised visitation. They gave me 2 hours per week of parenting time and 2 30-minute phone calls a week, where I solely had to pay that expense for $1,000 a month, despite no findings against me. That lasted an entire year. There were nothing in place to review this. They do not review these records that they're ordering from the supervised parenting time agencies. You have to try to get them admitted during your hearing. So I had hundreds of reports with not one concern about me and multiple disclosures documented by these parenting agencies that my children were continuously making disclosures of what was going on at their father's house. When I finally got rid of my attorney after paying, who even knows, over $50,000 probably within a 6-month period, I fired her, and I was immediately able to get myself off of supervised visitation. I was able to present the DCS guidelines for supervised parenting time, which stated this should be reassessed in 90 days. That never was done. At this time, then Judge Campanella was on my case. Let me just tell you, before that, there was also Commissioner Ash, who immediately recused herself. Then there was Commissioner Paula Williams, who tried to rule, at least in my favor, of finding father in contempt, immediately taken off my case. Then Judge Campanella was put on my case. He took me off supervised parenting time, but did not change the hours. So I continued with only 2 hours of parenting time all the way up until June of 2024. I kept fighting. I filed motions, emergencies, and even an appeal. All were denied. And I would like to say, I've been attending so many different meetings for years. I've been going to family court committees. There are so many of these same judges, including appeals judges, sitting on these family court committees, who then later, doesn't even make sense, sat on my family court case when he's an appeal judge. Don't understand how that happened. That is Judge David Gass. Again, nobody would change the orders from 2 hours a week. In April of 2024, I showed that father had been evicted. He was homeless and living with family members. He was leaving the kids unattended for several days at a time, making my daughter be responsible for them. In February of 2024, my daughter turned 18, and she had to make a very, very difficult decision to come home and leave, to protect herself and leave her brothers. So she had to leave them. When we went and got her stuff, it was documented on body cam footage. the significant amount of verbal abuse and just behavior that paternal family would display in front of the children. I went into family court. I showed again, like him destroying my daughter's bedroom, this body cam footage that shows how aggressive they were to not just my daughter, obviously to me, but in the presence of my children. Again, in April of 2024, they refused to act. Parenting time stayed exactly the same again. Then on June 1st, 2024, I picked up my kids for a scheduled visit. Minutes later, I received a phone call. It was private. Usually that means it's the police at this point. When I answered the phone, it was a detective from Peoria Police asking me if my children were with me. I confirmed they were, and then they conducted a raid on their father's house that he was staying at, where he was subsequently arrested for multiple sexual crimes against children, not of my own children either. DCS reported to my house that day and attempted to take the children from me. It was an 8-hour standoff.
Wait. Peoria PD verifies that your children are in a safe place before they conduct basically they execute a search, take him into custody on a warrant.
Yep.
Then DCS contacts you to take your children from you?
Correct. So his family showed up at my house. I immediately contacted the police. The police reported to my house at first, trying to get them to leave, saying they didn't have any rights to my children. They would not leave. They escalated DCS.
I'm sorry, who said you didn't have rights to your
No.
children?
They were telling his paternal family that showed up at my house. So he was arrested.
Okay. Got it.
And then his mother came, his sister came, well, both of his sisters came, his brother came, his sister-in-law came, and they would not leave.
So this is the father's family
Yes.
that does not have a court order for any kind of parenting time, obviously,
Mm-hmm.
shows up at your house in an attempt to try and take the children from you.
Correct, and they would not leave even with police instruction. So the detective, then they had escalated DCS to my house. And I should tell you, I've made numerous complaints to DCS. Doctors have contacted DCS multiple times. My children's medical doctors have testified in the family court disclosing that my daughter's disclosures were truthful, that they were not fabricated, and that she was not someone who was feigning or fabricating these disclosures. All of those were denied because she wasn't a court-appointed medical provider. So when DCS, I'm sorry.
We've got just a couple of minutes.
Okay.
So if you would, could you put a bow on this, all right?
So DCS came, they tried to take the kids from me. Eventually, Department of Child Welfare got involved. They escalated this all the way up to the Attorney General's office to say, no, the children can be staying with me. This happened on a Saturday. Monday, I went to family court, got temporary emergency orders. They put in those orders, and I got a police report as well that documented all of these evidence that was being presented against the father. They put on the order. I was given emergency temporary custody while father was incarcerated. Immediately after that, maybe about 2 weeks later, the county attorney, Erin Petticone, she subsequently dropped all of the sexual abuse charges despite the mountain of evidence, significant evidence that cannot be denied. And I apologize, I don't want to know the exact date, but I want to say June 15th of 2024, we then had another court hearing for the temporary orders. When we were walking, I went into the hearing, was waiting. Father got arrested on the way in for additional crimes against children, including aggravated assault against a child with a handgun. Temporary orders were affirmed again with the same thing. Because Department of Child Safety got involved and saw family court was not protecting the children, they have then escalated this all the way up to Attorney General in order to file a juvenile petition in order to protect my children. That was eventually thrown out. Said it has to be handled by family court because I'm a safe parent. And this is the same thing I've been told repeatedly throughout these things. So every time I would make a report, you're a safe parent. It is your job to go to the family court and fight for your kids. So then you go to family court and say, well, DCS didn't do anything. They know DCS doesn't do anything because there's one safe and protective parent. The police didn't do anything. Well, that's because 99% of all sexual abuse crimes are not prosecuted. Of course they didn't do anything. And so this is kind of just what's transpired. I have my kids. I'm one of the lucky few at this point. It is not because of my own fighting, despite how hard I fought. I have failed my kids because I could not protect them from the abuse. My daughter saved herself because she turned 18. My boys are lucky that they are with me. And it's only by the grace of God, because he was able to make a way when there's no way. Nobody else would listen to me. Nobody else would listen to my kids. Nobody would talk to my kids from this court. I asked so many times for the judges, can you interview my kids? Can you order the court-appointed advisor to speak to my kids? Can you order the best interest attorney, who is supposed to represent their best interest, talk to my kids? Wouldn't even meet them. Never even met them. And so please, I appreciate you so much for just trying to expose what is happening. I am not alone in this. There are so many parents who are experiencing the same thing, and most of all, children who are just suffering, and they are going to grow up, and they are going to, I don't like to say this because it's not fair. However, it's very common that they are going to redo the things that they have experienced growing up. And somebody has got to protect them. Somebody has got to enact some sort of legislation that says, no, you don't have absolute power. You can't just be mad because you didn't do as the man said. It doesn't work that way. There has to be checks and balances. I have so much information I could provide you that it would be overwhelming. But I appreciate you guys doing something, and thank you very much for this opportunity to speak. There was a lot more I wanted to address about some of these initial lady that came in about the judge's performance complaints. Last year in May of 2024, the Superior Court actually held a law day where pretty much no members of the public attended besides me and my friend. They thought they were just in a room amongst their peers. And they're telling the group, they aren't investigating family court complaints because, just like you said, one party's always unhappy. They don't even investigate them. And if they do, and they found there's misconduct, they allow them the opportunity to retire versus facing any sort of repercussion. And I have that on recording as well, if you would like that.
Thank you for your testimony, Tim.
Thank you very much.
This will not go unnoticed.
Thank
and
you.
That's your closing comment is exactly why I asked folks, please, let's limit this to personal experience, the court, and not the ex-spouse. I gave you quite a bit of latitude because I think the circumstances dictated it.
Correct.
Members, do you have any questions for Tim? All right. Thank you very much for coming. All right, ladies and gentlemen, we are at 12 o'clock noon. We're going to recess this committee until the sound of the gavel at 1 o'clock. Okay, the Joint Legislative Ad Hoc Committee on Family Court Orders is back in session. And for those of you that are standing at the podium, if you could kind of move aside so that this young lady can step up. All right, if you would you please give your name, who you represent, if it's somebody other than yourself?
Yes.
And it appears that you might be a minor, is that correct?
That is correct, yes.
All right, if you would please get as close to the microphone as you can. And I'd like to get your name.
My name is Maggie, but I'm happy to share my legal name in private.
Okay, that's fine.
Good afternoon, senators and members of the committee. Thank you for your work to protect children and families in Arizona, especially in the face of our family court system crisis. I'm 15 years old, an Arizona native, and my brother and I have been trapped in the family court nightmare for most of our lives. I'm an AB student, a member of Mayor's Youth Council, and I actively participate in choir, theater, and the performing arts. I also volunteer in my community and serve in leadership roles at my church. I care deeply about fairness, service, and doing what's right. I'm here today because I believe the family court system in Arizona needs to start listening. I believe that they need to start listening to children, and especially teenagers like me, who have lived with the consequences of the family court's decisions. Throughout my life, I've been told by professionals that as a child, my voice doesn't matter. This has made me feel like property and not a human being with rights. It has never made sense to me. I am old enough to lead, to speak publicly, and to serve others, but I'm told that I'm not old enough to say where I feel safe or which parent I'm more emotionally connected to. In my own case, my wishes were ignored even when I tried to speak up. When I resisted going with a parent that I did not feel safe with Due to abuse, I was threatened by law enforcement with juvenile detention. I was physically removed from a vehicle by my abuser while the police stood by watching me. In that moment, I was left bruised physically and emotionally. After that, I lost time with the parent that I felt safest with. I was told because I resisted an exchange with my aggressive parent, I could not see the parent that I preferred. This was supposed to be in my best interest, but it felt more like a punishment for telling the truth about my feelings and my needs. Now my 5-year-old half-brother is caught in the same nightmare. He is placed with a harmful parent who has very concerning behaviors. We were given different custody schedules and made our time limited. Recently, we were separated entirely due to supervised visitation. This happened after my brother confided in me, his big sister, someone he trusts, about his horrific experiences. When we speak out, all it does is make our living arrangements worse. Because of that, now we only see each other a few hours a month. We are incredibly close and we want to be together. Being separated is heartbreaking and absolutely not in our best interest. What hurts the most is knowing that a parent who has always kept us safe, the one who provides stability, love, home-cooked meals, emotional support, and helps us thrive in every era of our lives, was the one that we were taken from. And I am not asking you to make decisions about my personal case or my brother's today, but what I'm asking is that you hear my voice and the voice of other children like me. We have lived the outcomes of family court decisions made without our input, and we are still carrying the consequences. Family court has caused us immense pain. Children deserve to be heard in a way that truly matters. When we speak up about our concerns for our safety, we should be protected. We should not be punished. Our voices and our safety and our emotional well-being must be part of the legal process. It should not be an afterthought. Thank you for listening. I hope my words inspire you to enact a children's choice law that will protect children and finally give them the voice that they deserve.
Thank you, Maggie.
Thank you.
Members, any questions for Maggie?
Thank you.
I salute your courage, young lady.
Thank you.
Okay, next up we have Christine Morrison.
Thank you for this opportunity. My name is Christine Morrison, and I'm from Michigan. I am court docket 954609DM. I wrote the book Judicial Criminals, The Greatest Fraud Upon American Society, America's Legal System. My website is judicialcriminal.com. Family court judges are above the law and order whatever they like, and you are coerced into agreements. I was precluded any legal remedy with up to 10 appeals filed, an attorney malpractice trial, and 3 motions are still under advisement. Non-custodial parents are criminalized, falsely arrested, silenced, looted of their assets, homes, possession, and life savings for parental rights. My case starts with a settlement agreement. An original and 2 amendments were entered without my consent, without my signature, and it was wrong per the court transcript. There was no property settlement. There was just custody and accurate financial information. The opposing attorney in the attorney malpractice trial said, because her then attorney has made prior errors which precluded her from having visitation with her daughter, she couldn't be with her daughter. That's it exactly. Defense attorney stipulated on the record the clients did not consent to the original or either amendments. I was awarded $220,000 for the attorney malpractice trial. The trial cost more than $220,000. The attorney appealed it. The appeals court reversed it. The appeals court awarded him $36,000 in costs. That attorney then liquidated $80,000 from my retirement accounts. I also didn't show up for a creditor's exam, and the court issued a warrant for my arrest contingent upon me paying the $36,000. That was back in the early 2000s. Child support. In 2019, Minnesota issued that the administrative child support process is unconstitutional. During the attorney malpractice trial, we had subpoenaed IRS corporate returns that showed in excess of $2 million. My ex reported $17,000 to the friend of the court, $500 a week, and his attorney testified in open court he believed his client wasn't submitting accurate income. The IRS subpoenaed corporate return trial exhibits are in the court and the attorney malpractice trial. Judge number 2 was the Chief Circuit Court judge.
And, excuse me, ma'am, this is in Michigan, correct?
Michigan,
Okay.
Macomb County Circuit Court.
Okay.
Judge number 2, who I was in front of, Chief Massaroni, for 8 months after the child support was entered against me, I became medically disabled. I asked the court, the friend of the court, for over 8 months for a modification. I was denied. In September, 8 months later, the opposing counsel went in on an ex parte show cause order against my family. On 9/1, orders came out for a seizure, sealing, inventory, setting aside a quitclaim deed to a third party, and immediate possession of my home. On 9/2, a lien was put on the title. On 9/23, there was an ex parte motion requesting a court order to sell my home. On 9/22, my then new attorneys, 2, filed a motion for abatement of the child support, a rehearing of the 9/1, 9/2 orders, and a disqualification of the Chief Circuit Court judge. That judge denied disqualifying himself. The motion was then reheard in November. Long story short, I was made homeless for over 8 weeks. I did get my property back, but it cost me more money than what the property was worth. And even when I got my property back, I went to file a police report for all the contents missing, and the police told me to go file with the court. Judge number 3 violated federal law and assessed against me $33,000 in retroactive child support. She also tagged on over $12,000 in attorney fees. On January 12th, the full cash bond was posted. My attorney filed an appeal for reversible error, and the next day she issued a bench warrant for my arrest. In the meantime, I had had bounty hunters after me. They came to my home asking for my whereabouts, went to my neighbors and pulled a gun on them. That's what you are subjected to. With the court orders taken under advisement, the settlement agreement, that should be void and null. I have asked Michigan legislators for decades now for legislation and to void the settlement agreement. There's a 2005 case in Michigan, Logan versus Logan, where the Court of Appeals said that
You get 2 minutes, ma'am.
the trial court erred when it failed to enforce the settlement agreement because it's American contract law. It's a contract between two parties that they can't not enforce, but they did that to me. And there have been many attorneys that have filed to the U.S. Supreme Court for no remedy in law, and they're all dismissed. We have filed to the International Criminal Court. No legislation is going to correct this national crisis, and it's all because of one thing. It is called Title 4-D, and Melanie Cummings in 2002 wrote to and testified to the Senate in New Jersey, the defrauding of the hardworking American taxpayer, welfare reform, and the role of the family court. And Renee Beaker, who was chair of Michigan Now, stated, good fit mothers are losing custody in 70% of contested cases, along with their homes, professional licenses, and life savings. The third judge threatened that if I did not show up on the show cause for the third appeal, that they would suspend my occupational licenses. So you have absolutely no rights, no right to a remedy in this court, and it's all because of the Title 4-D funding. What people don't know is this year alone, forensic psychiatrist Bandy Lee has said that the reimbursement is between 50 to 170 billion per year. So all the state courts go back to the Title 4-D fund, and they're reimbursed money, billions, all of them. The biological parents now are basically like the Cash for Kids scandal in Pennsylvania. We are slaves to this system for the Title 4-D that they've been collecting for since the 70s.
Thank you, Ms. Morrison. Members, any questions for Ms. Morrison? Okay, ma'am, thank you for your testimony. Next we have Haley. Haley in the room? Hopefully there's only one Haley. Haley, going once? Going twice? Oh, sorry. You were behind. I'm sorry? She was.
Oh, sorry.
All right. Hi, Haley. If you would please give your name for the record, and if you're representing somebody other than yourself, please tell us that.
Yes.
Also, are you a minor?
I am not.
Okay. Well,
Thank you.
gotta ask.
My name is Haley Worrell. I'm 27 years old, a wife, a mother of two, and as of this Wednesday, a law school graduate.
Congratulations.
Thank you. While this is a time of celebration for my family, it's also a moment of deep reflection and sadness because of the reason I went to law school is rooted in tragedy. In 2017, my oldest son was medically kidnapped by the Arizona Department of Child Safety. What followed was a cascade of systemic failures that led to my husband being wrongly convicted of child abuse, and he is now serving a 12-year sentence for a crime that never happened. On November 12th, 2017, my husband and I, at only 19 years old, brought our 4-month-old son to the emergency room in Prescott, Arizona. He had woken up with a swollen arm. Before any x-rays were done, the emergency room doctor came in, assessed, and said that his arm was broken, and immediately contacted the police and DCS. From that moment forward, everything that happened was marked by a rush of judgment. The doctor refused to perform any other tests other than a full-body x-ray, tests that would have shown our son suffered from vitamin D deficient infantile rickets and hypermobility Ehlers-Danlos syndrome, both which he's since been diagnosed with. The initial full-body x-ray uncovered 4 rib fractures at various stages of healing, an arm fracture, and a fracture in his wrist. With one simple blood test, they could have discovered the explanation for the unexplained fractures and treated him like we anticipated when we had brought him in. The detective and the DCS investigator interrogated my 19-year-old husband for over an hour before he finally told him, "You and your wife are his main caretakers. It's either you or your wife going to prison for this. If you want your son and wife to go home safely, you need to tell us what you did." My husband falsely confessed out of fear for our safety, a threat which was meaningless as they placed him into foster care immediately after, despite his coerced confession. The family court judge implied during our first hearing that due process wasn't required in her courtroom when she stated that this is not criminal court. We do not need proof to take your child away. A gag order was placed.
I'm sorry, when did this case happen?
2017 to 2018.
The name of the judge?
Judge Anna Young.
I'm sorry?
Anna Young.
Okay, I'll send her a copy of the Constitution.
Yeah. Yep.
All right. Please proceed.
A gag order was placed on us so that we could not speak out during this whole process. My parents, while gathering character letters to try to get placement of our son, was threatened with contempt of court because they were telling people that he was in foster care. A CASA representative screamed in fear upon seeing my husband out on bond during our first child family team meeting. Already labeling him an abuser with no trial or evidence, there was never a presumption of innocence for him. DCS caseworkers told me that I could have my son back if I left my husband and testified against him. They asked me to abandon my husband, that I had known and trusted since I met at church when we were 10 years old, and to testify differently than I believed in exchange for my son, something morally I could not do. Our family advocate summed it up early on when she told us, "You are not getting your son back. He is a healthy baby boy. He is adoptable." Our caseworker, with others during our case, posed proudly in t-shirts that they made for a photograph that said "Professional Kidnappers" on the front and on the back, "Do you know where your children are?" This was never about protecting a child. It was about preserving a narrative, their false narrative, and when the system decides what it wants to believe, truth becomes irrelevant.
Excuse me.
Yes.
Was that photo
Yes.
out on the internet?
Yes. It got national attention.
Oh, it certainly did. It got my attention.
Yes.
If you would, could you please see to it that staff receives a link or a copy of that photo?
Yes, I absolutely can.
Because I think that needs to be a part of the record.
Absolutely.
All right.
Yes, absolutely.
Okay, you have 3 minutes left,
Okay. My parents weren't granted custody for 11 months, despite being under the protection of the Indian Child Welfare Act, because they believed in our innocence. Only after passing multiple home studies, psychological evaluations, and making degrading sacrifices like agreeing to remove all the photos of my husband off of their walls, and having no personal contact with me or my husband, were they even able to get temporary custody of him. Even while in foster care, our son sustained 2 more fractures, but the focus remained on us, parents who had no contact with him at the time the fractures occurred. We complied with every demand that they assigned to me: parenting classes, counseling, psychological evaluations, drug testing, everything in the reunification plan. My husband wasn't allowed to participate, and a no contact order was placed between our son and him, so he was not able to have supervised visitation like I was. We paid out of pocket for him to do everything that they assigned me. We paid for him to do still, so that they would see that we were committed to fighting for our son. And still, after jumping through their hoops with flying colors and no indication from any of their chosen professionals of an inclination for either one of us to be abusers, they denied us reunification with our son. At our severance trial, supervised visitation workers cried on the stand while testifying to my abilities to be a loving mother. It did not sway the judge. Before the trial, we were waiting for an expert report confirming our son's injuries stem from the metabolic bone condition, and the judge would not delay the trial to await for the evidence. The trial proceeded anyway before my husband's criminal trial and against the advice and opinion of the Foster Care Review Board, who recommended waiting for the outcome of the trial before proceeding with the severance trial. Because of this, he had to plead the fifth to every question. He obliged on every question except for one. They asked, "Did you hurt your son?" And he said, "No, I did not hurt my son." There are countless wrongs that occurred in our involvement in the family court system that I could name, but that would take all night, so I will leave you with one. Our final caseworker, the only one who had actually come to our home, had spoken to us. He assured us that he believed the truth would prevail. He listened to us, talked to us, and for once, someone believed in us. But on the stand, he testified that my husband was an abuser and that I was a danger for supporting him. We emailed him after we were shocked and betrayed, and his response was this: "Haley, I appreciate your comments. I do not believe there is anything I can say to help you understand my role. How I feel about you and your family is very different than how I was required to testify as a child safety specialist. Some of us DCS employees find ourselves in very difficult positions. If you hate me because of the trial, you are completely justified." That is the system in one single sentence. Even those who know the truth are required to lie under oath to protect the system in their rush of judgment, and not the child. Our son was not abused by his parents, but he was abused by the system that stole him from a loving home and by a system that robbed him of his father. He is still being victimized every weekend when instead of waking up with his dad, he only has 4 hours in a prison visitation room before crying and hugging his daddy goodbye. Even more than that, our youngest son, who was not taken from us,
has become yet another victim of the system who was robbed of his father and moments with his father. While he took his first breath in this world, his dad was sitting in a prison cell waiting for the prison guard to let him make a 15-minute phone call to check on his wife and son's safety after birth. Both of our children suffer every day without their dad, and because a procedural bar is so high for appeals, we are still left without relief. I went through 6 years of law school to help make a change in the system, and I am not in the position yet to make that change, but you are. Today, you have the power to take the first step towards accountability and justice for Arizona families like mine, for Arizona children like mine, who wish at every wishing well to find that we find for their daddy to come home. Please be the voices for the families who are, who were, and will be silenced, and to ensure no other child becomes collateral damage in the system that's supposed to protect them. Thank you.
Members, any questions?
Mr. Chair.
Ms. Fink?
I guess I'm just kind of flabbergasted that after the diagnosis of the Ehlers-Danlos syndrome, which is very much well documented, that not everything was reversed. Can you explain a little bit why they did not take that into consideration?
Yeah. So it actually just went in front of the criminal conviction went in front of the Court of Appeals, and because of the procedural bar of how they view newly discovered evidence, it has to be newly discovered means that it cannot have been brought up in trial. And so to them, the issue of metabolic bone conditions was brought up at trial by the state's experts, and they had said that he did not have any. Even though it was different kinds of testing, they said that the issue of genetic testing had been discussed at trial, so it was not new evidence. So it was a procedural bar. They said that it would make a difference, and that it was, during oral arguments, they said that it would make a difference and that it was relevant, but in their opinion, it was not, it couldn't count because it was brought up at trial.
I'm flabbergasted. Anyway.
Another question? You done?
I'm done.
Thank you.
Hold on. I wanted to give my colleagues first bite at this apple.
Absolutely.
Have you examined, I'm not, at the risk of provoking a lawsuit, have you given any thought to an action against the physician who failed to recognize that your son had such a malady?
We've definitely thought about that, and that is something that we're working through right now. We've focused solely on trying to get my husband home to his babies, but now that we got our son in a safe place with my parents and that I'm able to live with them, our focus right now is on him, and then eventually we will think about all of this for the, my grandparents' drained retirement or our sold house to try to cover all the legal bills. That's something that we can think of in the future.
So tell me a little bit more about that, if you don't mind, ma'am.
The
You had to
financial
sell your
drain.
house, your financial ruin, it sounds like.
Yeah, my grandparents, thankfully for them, thankfully for us, had saved up quite a retirement, and it's almost all gone. My grandparents had to go through a cancer treatment for my grandma and almost didn't have enough because they had used all of it on lawyer funds. My parents had been taking money out of their 401k and having to be penalized for that, of course. We had to sell our home to pay for lawyer bills as well, and it just doesn't stop. Experts, all of that costs money.
So I want to make sure that I heard what I think I heard. That Judge Young
Yes.
told you that you have no civil rights in her courtroom?
The very first courtroom, they sat us all down and they asked us if we had anything to say.
And this was on the record?
Yes,
or
this was on the record.
conference?
This was on the record.
Okay.
The first attorney, the attorney for DCS, he didn't have anything to say. The guardian at Lidum, she stood up. She said normally she would move to sever a case like this immediately, but she wanted to dig up some more dirt on the mother, me, the 19-year-old. And so being shocked, I didn't say anything. My husband was next, and he said, "Your Honor, I didn't hurt my son." And that is when she made the comment, "Mr. Worrell, this is not like criminal court. I do not have to prove that you did anything to take your son away."
And of course, you now know otherwise.
Yes.
Okay, I guess the next question I have for you. Did the court itself or representatives of the court attempt to turn you against your husband?
Yes.
Okay. All right, Haley, if you would, please don't, do you need to run off? I know
No.
it's a trip up the hill.
No,
No?
I'm good.
All right, I would like to have you speak to our staff so that we can get your information. I would like to get a copy,
Absolutely.
a transcript of your court case
Absolutely.
to include in the record. That is absolutely reprehensible, that a judge in this state would tell somebody that they have no civil rights.
Yeah.
But I don't want to jump to a conclusion. Perhaps you misheard. Perhaps she misspoke. Perhaps that didn't happen. As you know, part of legal doctrine is if
Absolutely.
it ain't on paper, if it's not in the four corners,
Absolutely.
it didn't happen.
Yep.
Okay? All right. Thank you, Haley.
You're welcome.
I appreciate you coming up.
Thank you.
Mr. Schultz, are you still in the room? If you don't mind, I've got a question about what we've heard from Ms. Haley.
Yes, sir.
Would you say that this is an example of alienation by the court itself?
Absolutely. And this happens frequently as well, right? We view parental alienation as the wording, it's parent, right? However, when the
If you would
state
get as close as you
when
can to
the
the microphone.
when the state assumes the parenting role, right? Here they are alienating a parent from a child.
Because it shocks me that the court or some out-of-control state agency would demand that photos of a child's father be removed from the home.
It sure seems fishy, does it not?
I think you're being kind. All right. Thank you, Mr. Schultz. All right. Lucy, I'm going to murder your name. Bellamina? I'll let you say it. If you would, please give your name, and if you're representing somebody other than yourself, who that might be.
Good afternoon. Thank you
And
so
get
much.
as close to the microphone as you can.
Good afternoon. Thank you so much for this opportunity to speak to you. I come all the way from Orange County, California. I wanted to tell you about my harrowing story of my son's medical abuse, extreme bias against a protective parent, retaliation for exposing the truth, and sex utilized as a bargaining tool for custody. I am a teacher and a school principal in charge of an entire school of children by the state of California, which grants me teaching credentials. I'm also a mandated reporter, and I've also had to report abuse or suspected abuse to CPS. My son Jacob was a happy, healthy, and thriving young man, a child at the time, for 12 years that I raised him. Unfortunately, when we went through family court, he was appointed a minors counsel, which is similar to guidem ad litem. Minors counsel Diane Vargas provided false testimony in court as a retaliatory effort against me since I filed 2 bar complaints regarding her professional misconduct. The judge also decided to retaliate against me as well. And the judge, Donald Gaffney, legally kidnapped my son from me since I exposed the truth regarding minors counsel's ICE in court through documentation. Minors counsel falsely testified in court that my son was in danger and that I was an unfit parent. However, the 730 evaluation that was court ordered stated no such thing. I was placed on supervised visits for 4 hours a week despite raising my son for 12 years and also having 2 grown adult daughters and being an educator and a mandated reporter. As a school principal, I have 2 master's degrees in education. But yet I was being supervised by someone without a college degree. I was so perplexed by this train of events. Due to the cost of supervision, I had to sell my home and to pay for my attorney's fees and all the reunification therapy that I was subjected to. The court refused to provide appropriate alimony despite the enormous disparity in incomes. As a teacher, I made a meager salary, which I was very grateful and blessed with. However, my ex-husband made over $300,000, which was over 3 times the amount that I made. But I was only given $468 a month to survive on. My son Jacob was medically abused by my ex-husband, but Judge Donald Gaffney at the ex-parte hearing said there was no such abuse, despite medical documentation. I also filed 2 CPS reports informing them of my son's medical abuse, and it was disregarded.
Excuse me, ma'am.
Yes,
When
sir.
you say medical abuse, can you further define that for me?
Sure. My son, through the medical records, where his stepfather, which was my ex-husband, it's not even his biological father, took him to the doctor and performed various medical procedures, yes, that were not, that he had already had at that point. And the doctor's office didn't think to question this previously or to obtain previous medical records from Chalk Hospital.
Okay.
My son Jacob is now suffering with lifelong medical complications, and he will for the rest of his life. In 2021, I had asked my ex-husband if I can see my son because I knew the court would never grant me custody of my son, despite me being in charge of the health and welfare of an entire school of children as a teacher and a school principal. My ex-husband provided an offer that I exchanged sexual favors in exchange for seeing my son. I was sexually raped for 6 months, but I had access to my son. And as a mom, I would do anything for my son. Apologize.
Take your time.
After the 6 months, I could no longer endure the abuse. We went back to court, and the judge said that I had violated a court order by seeing my son, and I was the one who was punished. My ex-husband, David Velema, was not punished for raping me and not allowing me to see my son in the process. There were 2 judges, Donald Gaffney, as well as Judge Thomas Lowe at the Orange County Family Courts in California that presided over my case. And both of them denied me alimony, custody, and also terminated my visitation rights. Even though the state of California allows me to be in charge of an entire school of children as a principal, as a teacher, for the health and welfare of these children, but yet I don't have access to my son, that's really disturbing to me as a parent and as an educator. I once again became a danger to my son, and the court and Minors Council refused to let me see my son, and again, I was placed on supervised visits. This reunification therapist, Jessica Sinclair, was appointed by the court, and she did not take insurance since she had previously been convicted of insurance fraud. And I was forced to pay cash or Venmo, which is from my checking account, for these reunification therapy sessions. Again, she provided false testimony in court to increase her profit margins. I want to express to you how far I've done, as many parents have spoken today. I filed, besides the 2 bar complaints that I filed against Minors Council that were dismissed by the bar, I filed 2 judicial complaints against the 2 judges. That was dismissed. I also wrote to the Board of Behavioral Sciences that is in charge of Jessica Sinclair as a therapist, and have not heard back since, and I know many other parents have done so as well. She is no longer teaching by choice, or I'm sorry, not teaching, sorry. She is no longer a part of the Orange County Family Courts in California by choice. She recused herself because of all the articles that have come out regarding the corruption that she perpetrated against the clients that were court appointed. She is, however, practicing in another state. I've also reached out to the FBI to inform them regarding the legal kidnapping of my son. It's been 6 years that I have not been able to see my son, except when I was raped, and that I was allowed to spend time with my son. For all I know, my file's sitting on an FBI office just collecting dust. I've called and spoken to 4 FBI agents, and they informed me that they can't provide any status on my case. To me, as an educator and responding to parent concerns, student concern, and staff concerns, I provide due diligence to ensure that I problem solve and I work with the people that I'm put in charge of If the highest levels of government, if I can't depend on them, who can I depend on? Is it possible to make our judges accountable for their actions and not have immunity for abusing our children? Thank you for your time. I appreciate you.
Thank you, ma'am. Members, any questions?
Mr. Chair, if I can address an answer to Senator Hatali. She had asked a previous parent regarding finances. Just in my case, if I can speak to that, the court asked for a financial documentation. So all our paycheck stubs, bank statements. So when they look to see that one of the parents has a substantial amount of assets, they will drag it on for as long as they can. And that's how it's deduced as to the colluding that takes place regarding the abuse that our children are enduring.
And I presume that California law is similar to Arizona law. You don't have to agree to the so-called therapeutic intervention with that broad basket of psychological word salad. You don't have the option to agree to participate or decline. Is that correct?
No, it's court mandated.
Okay.
Mr. Chair.
Regardless of anybody's ability to pay.
Correct, yes. I wasn't able to pay, and therefore I had to stop at one point the supervised visits, and then I collected some more money, asked family, friends for funds so I can continue to see my son.
All right. So let me say it another way. They don't care.
Yes, Mr. Chair.
Did the court question you, and this does have relevance here in Arizona, did the court question you on what other family members, what assets they might have? Did you have to disclose that to them, or was there discovery about that?
Not to my knowledge, Mr. Chair. It was just what my ex-husband and I had, our paycheck stub, the home we owned.
Okay. It just seems somewhat curious to me that they would force that on the earnings of a lower income parent as opposed to one who is perhaps more capable of covering the cost, and not, was there any opportunity to have a proportional assignment of cost, or did that not even enter the conversation?
Well, that's where it's decided upon, depending on the disomaster, how much you should get for whether it's child support or alimony. But because my attorney at the time was colluding with minors counsel, it was actually a conflict of interest. She had been his mentor during law school. So because of that, there's a current situation around that situation.
Okay,
regarding the law firm, but yes, so go ahead.
Who, your attorney, was the mentor to who in law school?
So minors counsel, which was my son's attorney appointed by the court,
Okay.
was the law professor or mentor for my attorney.
And the court saw no conflict of interest there? That's stunning.
No.
Okay. Representative Cashel.
Yeah, so thank you, Mr. Chair.
I'm so sorry to interrupt. I wanted to also say there's an article, Sex for Custody in Orange County, California, and Representative Keschel, I did email that article to you.
Okay. Would you see to it that we get that? For the
Yes,
record? Okay.
I will. So thank you so much for coming. I'm sorry for everything you've been through. But from what I just gathered from something you said that's a little shocking to me is the court order on your supervised visits was based on whether you could pay for the therapy or not. Did you say that when you were unable to pay, they took away any visitation from you, or did I misunderstand?
So we had gone to court to inform the judge that I could not no longer pay for supervised visits. So at that point, the judge, just said, well, if you can't pay, you can't see your son. Then when I took some time, collected some money, and like I said, family, friends, was able to get some substantial funding, then I wanted to still see my son and didn't want to get raped again. And so I wanted to be able to see my son. So then I went back to court, and the second judge, Thomas Lowe, that's who my case was transferred to, he denied me visitation and custody of my son, despite me being in charge as an educator and a school principal of an entire school of children by the state of California.
Mr. Chair?
Representative Fink.
Thank you. Maggie, thank you for coming all the way from California. I have some questions on the reunification therapy. Why was that court ordered? Was there efforts to get, again, that reunification effort so your son would go to the stepfather, or why was that ordered?
So after going back to court, after being sexually raped for 6 months, the court said that I was the one at fault in violating court orders. Minors counsel again lied in court. It was the same one, Diane Vargas.
Okay.
She informed the court that, and lied to the court and said that the child didn't want to go with me, even though he had just spent 6 months in my home. And so that's when the judge, again, honored her request and the false testimony she provided again, and sent me to reunification again.
And therefore, after that, with that therapy, finding out that she had insurance fraud and all of that, did that take, was that taken into consideration at all? Okay.
No. Representative Fink, no.
Okay, thank you.
Members, any other questions? All right, ma'am, thank you.
Thank you for your time.
You're quite welcome. All right, next we have Lee McCarty. Hi, Lee. If you would, if you don't want that quite so high, there's a switch to your right that you, or you can do that. If you would please give your name and who you're here representing, if it's somebody other than yourself.
Hi, I'm Leah McCarty.
Get
Thank
really
you.
close to the microphone.
Thank you for having me today. I am here representing a family from Arizona. Their names are Jonathan and Rebecca Burr. They are constituents in Arizona who went out of town on a vacation to see their sick mother in Nevada at Clark County. They are homesteaders. They have 40 acres in Apache County and currently have a lease for a home in Maricopa County that would give them a safe place to reside back in Arizona. The beginning of December, they went on a trip to visit their ailing mother. And when they got there, they saw how desperate the mother was and they wanted to spend the holidays. It was cold here. So they decided to reach out to Clark County for assistance in temporary housing through the holidays so that they could be there for their mother. The requirement was that they were to be seen at this hotel by the department, whatever, I don't know what the department in Clark County is called, but their social services were to come to the hotel and they were to assess the children and the family and the needs that they were required. They came with police officers armed. They came with the fire department, the ambulance. They separated the parents and took the dad outside of the hotel room, and they left the mother and the 3 smaller children. So the ages of the children are 1, 2, and 4. They're very small. And then they have a 13 and a 14-year-old. They also have 2 other children that had been previously taken from other states, and they had been gone for many years. So these 5 younger children are the ones that they currently still have. Long story short, they were, the children were immediately taken from them and put into separate housing situations. The 3 younger ones were put into a foster home. The 2 older ones were put into a care facility that had barbed wire on the inside, right next to their DCS office or their courthouse. There's something there in Clark County. And the parents were then not allowed to leave the state, because if they left the state, that it would be abandonment and the children would be fast-tracked adopted out of the system. So they were forced then to live on the streets. They've been living on the streets of Vegas since December, the 1st of December. They have their 2 dogs with them that have lost a significant amount of weight. Not that that's is relevant to this family, but they have these dogs. They have everything is in their car. And the state has told them that they are now constituents of Clark County. The reason I'm here today is their court cases, they have another court case tomorrow. The end of this month, May 30th, is the last date for the 6-month period of time that this family has to get these children back. There has been no medical reasons for them to have taken these children. The youngest son has an eye problem that he was born with. They are holistically treating these children. They do not vaccinate. They're homesteaders. They had a business on their property. They raised goats, chickens. They lived a natural, organic life that people have the right to do in this country. And they were deemed unfit, medically negligent to their children because they had dirty feet. They weren't wearing shoes and they had dirty feet. And so that is written in the statements, and they were taken from this family, and they have tried to get help from Arizona. I personally have met with Jerry Sheridan 3 times. I've sat in his office. I've spoken at sex trafficking events. My background is I spent 2 years in the streets of Phoenix working with sex trafficked people, helping them get off the streets. I had a ministry. Our bus has been shot at. We've been in fights with pimps trying to help girls on the streets. So I have a very active group of people that tries to help people that are trafficked. This family came to me through a friend, and I have just tried to stand in the gap. They currently come to my house when need be for food, shelter, washing their clothes, having a safe place to sleep at night.
So the family in Nevada, do they have an attorney?
They did, but they do nothing for them. They represent themselves. They are extremely knowledgeable in the Constitution. They defend themselves on every level. And they have no representation but themselves. We now have an ADA advocate here in the room that has been helping me. It's a lot. It's a really, really big deal what's happening. They also found they had pulled a bond on their youngest son that matures in 2054.
To what purpose?
With the Treasury, yeah, it's a bond against the youngest child. They are trying to they're trying to take him from Nevada, and they're trying to do eye surgery from a pro bono doctor in Utah. The child, they've vaccinated. We believe that they have vaccinated the child. He was mobile, getting to walk, pulling up, crawling, all the things that infants do. And now he's slumped over in a chair. And when they do visitation through the Zoom, the baby's just slumped over in a chair and there's nobody in the room. The dad's saying, hello, is anybody there? Is anybody watching our children? The 2- and 4-year-old are running around hitting each other. There's nobody there. I do believe what has been happening, and this is just from research, they are taking illegal aliens that have come across this border and been given Social Security numbers that I'm assuming the Biden administration. Now they have Social Security cards. They are now the caregivers of these foster care homes. They don't speak English. The older children have expressed this in that group home. They've said they're Cambodian, they're every nationality, and they don't speak any English. So now the children don't even have somebody that speaks English. In the court documents, the father has been accused of raping the 14-year-old daughter, and that the 1-year-old is the product of that rape. Yet the father's not been arrested for anything. They've now told all 5 children that the father is not actually even their father. And
okay, who told them?
The social workers.
Okay, so I would like to humbly suggest that you contact the Arizona Attorney General and ask for her to be an intervener in that case. Do it now.
Okay.
Okay. Members, any questions?
Yeah, Mr. Chair, to that point, how does Nevada have jurisdiction over this family?
They don't. They've stolen these children. And in fact, 2 weeks ago, they told them, if you lose this case, we are going to take your children from you and vaccinate them from birth all the way to whatever age they are. Every single vaccine that they have missed from childhood, they're going to get in 1 day. And then they've told the parents, you now are constituents here. And if you want your children back, you have to get a home here in Nevada to provide for your family when they have 40 acres and a 5-bedroom house in Maricopa County legally done. It's
you need to contact the Arizona Attorney General and ask her to be an intervener.
Okay.
Okay. Members, any other questions? All right, ma'am. Thank you very much for your testimony. I appreciate it.
Thank you.
Next up, Ryan Murray. All right. Ryan, I hate to be a curmudgeon on time, but we're going super slow. So if you could do 7 minutes instead of 10,
I think I can.
that means that we can get 2 more people to testimony before we conclude.
So thank you. My name's Ryan Murray.
Get as close to the microphone as you can, right?
I'm here for representing myself, Ryan Murray, as well as We the People. It was my understanding that loss of a parent is the most traumatic thing that can happen to a child. My children have lost a father for 6 years, and I have been in Arizona Family Court trying to make sense of it all and trying to be a loving and available father. I started with a judge by the name of Allison Bacchus, who took a Rule 69 50 custody agreement that was in writing and threw it out, and I have not been a father since.
I'm sorry, did she give a reason for throwing out the stipulated custody agreement?
Mother said on the stand that she had changed her mind and hired a different attorney. It was the attorney Francis McGinnis who decided that child support and 100% custody was what they were going for.
Okay, so you're not engaged in a 5225 plan?
No.
All right, thank you. Go ahead.
I was referred to David Weinstock, who was said to be the expert in the state of Arizona, and that he would help, go through the TI process and would hold the other party accountable to the immediate reunification that I had in a court document. And in that original court document of immediate reunification, 6 years later, that still has not happened.
Did you have a contract with him?
Yes.
And forgive me, I'm trying to understand if the court made a decision unilaterally, how did this Weinstock fella enter the picture?
Yeah.
If he wasn't appointed by the court.
It had to do with the carousel of collusion of people working together. So my attorney had a relationship with him and referred
Okay, so
me.
just a minute. He wasn't appointed by the court to act as a judicial delegation to intervene on your case. Is that correct?
That is correct.
Okay.
So at that point, he referred us to Pastor Brooks Gibson for this immediate reunification. Pastor Gibson had lost his license, which I did not know at that time, and took a meeting before with the opposing party. And when I showed up, it was said that there would be no immediate reunification. So I went back to court, and it was referred to a Marcia Farrick as a therapeutic interventionist. When my attorney wrote a letter and said, hey, we've got something here that says immediate reunification, she recused herself. It was then referred to Annette Ruskin, and Annette Ruskin was given the same documentation of immediate reunification. She said that it was not her job to follow the court orders and that she was the determinator of whether or not there would be any reunification. That never happened under Annette Ruskin's watch. Over a year. I then was referred to Carolyn Mullen, who tried to facilitate immediate reunification, and Mother opposed her as being appointed. So it got put off again to another therapeutic interventionist. His name was John Sciali, who actually is referred to as the most expensive person in the TI world in the state of Arizona. I did not attain immediate reunification with John Sciali. So between the carousel of lawyers and TIs, the only thing that was consistent was a request for my AFI. Everybody wanted to know what my W-2 said, what my payroll stub was, what my bank accounts were, what were the lines of credit that I had. And unfortunately, your description of the goose that laid the golden egg feels very personal to me, because I'm on the throes of not being able to pursue being a parent anymore because I'm going to be bankrupt. I'm right there right now after 6 years of fighting for this to be possible. There has been a gag order to not say anything from day one. This is the first opportunity that I've had a chance to even say anything.
Who's the judge?
The judge currently is Julie Mata.
Is that the one that put the gag order on you?
No, it was Allison Bacchus. And then
Okay.
Ted Campagnello, who basically said I didn't have a voice and that I didn't have any rights of a father.
Which seems, excuse me, that seems very odd.
It is very odd.
Since there is a group that parades around this country as a father's rights group that actually endorses the whole TI process. In fact, they're instrumental in installing it. So I guess that we'll have to follow up on that. But please proceed. I'm sorry I took your time.
The difference is, you know, I have a 3-year global master's degree, and I've traveled around the world studying campuses abroad, and am an expert on corruption in global business. Fraudulent actors are people that engage in deception or fraud that harm the outcome to gain personal and financial gain. And when somebody asks me for my pay stub and my W-2 and how many credit cards I have before they ever ask about a child, civil rights of children are being overlooked for greed. And my case is personal to me. Racketeering is a set of illegal activities aimed at commercial profit. What we have here today in Arizona is a business that is making a lot of money. Others before me have detailed it, and it's very painful to hear. Racketeering is defined as a coordinated effort by multiple people to repeatedly earn a profit, typically by fraud and threats. I was always threatened to not be a father. I was always threatened that I wouldn't have access. It's 6 years later, and I still don't have access. Collusion is a secret agreement or cooperation for illegal or dishonest purpose. 2 or more parties working together secretly to achieve a goal that is unethical and unlawful. And this, unfortunately, is happening daily in our state of Arizona. And I plead for everyone to think about the civil rights of our children. Thank you.
Thank you, Mr. Chair. I have a quick point of clarification.
Please proceed.
Something that you said, I just want to clarify what you're saying, is what I heard. The therapist basically claimed that he was the one that had authority over to decide the child what
Annette
would happen to your
Ruskin
children.
said repeatedly that
sorry.
it didn't matter that I had a court order for immediate reunification.
And that the name of that individual, because you were talking over each other.
Yeah, Annette Ruskin.
Annette Ruskin. Okay.
So, yeah, so thank you. You are saying exactly what I thought I heard, that Annette Ruskin said, I don't care about any court order, and then she got to decide what was best for your children.
And I found out in her lobby, speaking with her child, that her daughter was not allowed to have a relationship with her father. Imagine how I felt on that day when I had a retainer of over $2,000 for immediate reunification and I wasn't able to speak to my children.
So let me get this straight. Who prevented you from communicating with your children?
If I had a court order, in my opinion, that said immediate reunification, it was the TI that kept me from communicating with my children.
So did the court make any kind of an order preventing you from having communication with your children?
No.
Let's take the TI out of the picture right now. Did a judge tell you you don't get to have any kind of visitation with your kids?
No.
Did the judge give you any kind of plan like a 5225 shared co-parenting plan?
I shared that with the therapeutic interventionist. I said, these are the custody arrangements that I see as being normal, and they were not addressed and never discussed.
Okay. Now, let's re-inject the TI into the process. Given the fact that the judge did not even address it, the TI is the one who prevented you from having any contact with your children?
That's correct.
Okay. Did the term parental alienation ever enter the conversation?
Every day.
Uh-huh.
And you know what I was told? It's not alienation, it's estrangement. And I'm semantically challenged by that, because if I can't speak to them and I can't see them and they don't have my love, I believe that that is alienation.
Okay. So the term parental alienation, it occurs to me, and I'm not going to ask Monty to come back up here, but it occurs to me that if you take out parental and you insert, I don't know, provider alienation, that individual is actively, and I know that there's two thoughts about alienation. There's active, where an individual is influencing by either word or deed against a parent. And then there's passive. It's the parent who's like, I am not going to say a word about my ex-spouse's lifestyle. I'm just going to be silent. That's also been called parental alienation. But for you to have a provider intervene and cause that, when you're the one, I'm just trying to understand here, you're the one paying money to them to promote contact, to promote involvement, and move away from the alienation schedule. Am I whacked in the head, or is that basically what's happened here?
That is exactly what happened.
Okay. All right, members, any other questions? Sir, thank you very much for coming forward. I appreciate it. Next up, we have Monica Ballard. I don't know if it's Ballard or Bullard. Ballard, okay.
Since this is about the children, I brought to 50.
Okay, hold on.
My name is Monica Ballard. These are pictures of my children.
Okay.
Because it is all about the children.
Bunch of cuties.
Yes, they are. So, and my name is Monica Ballard, and I'm representing them. I'm also a veteran teacher here in Arizona, native Arizonan. Worked at Cottonwood Oak Creek School District for many years,
Okay.
and now I'm a therapist. Because of what I went through in the family courts, I had the choice. I said, am I going to go to law school or am I going to become a therapist? I'm going to do something because this is so wrong. So that's why I'm here. I'm a therapist.
All right, you got 7 minutes to tell your story.
Okay, yes. So I would like to, my kids were this age when I first had to go through the family court system in Yavapai County. They're now ages 18 and 21. Barely got free 2 years ago. It took the almost death of one of my children to get to that stage. So I just briefly want to share, we all know that adverse childhood experiences reflect later in life. So we're talking things that happen in children's childhood is going to affect them as an adult: suicidality, criminality, mental illnesses, all that kind of stuff. And the family court system is contributing in Arizona to that, to these poor outcomes. My children, when this process started, had 4 ACEs, 4 adverse childhood experiences, which is why I divorced their father, because that's not the home I was going to raise them in. By the time I was done with the family court system, they each now have a 7. And have had a host of issues that are related to that.
Excuse me, can you give me an example of adverse?
So, yes. So any type of, so there's a checklist, and there was thousands of people study done.
I just need one example.
So it would be physical abuse, emotional abuse,
Okay.
Neglect,
Okay.
addictions, that kind of stuff.
I was just looking for some context, that's all.
Yes. So going through those in childhood later are directly related to alcoholism, directly related to any of these homeless people you see on the street. My heart goes out to them because I know that's directed to their childhood. That is directly linked to their childhood. So the higher risk, and so that's what's so terrible about this. This is a bipartisan issue that everybody should care about, because if children are protected, that is going to alleviate a lot of stress on systems later, a lot of stress on the family, like the judicial system, a lot of stress elsewhere. So it's a bipartisan issue that everybody should care about. As a therapist, okay, so one reason I went back to school is obviously a lot of therapists don't accept insurance, and I have 4 children now that I'm going to help for the rest of their lives heal from what they've been through. And so I'm like, I'll go to school and I will get the tools that I need to help them, but I also want to help other people as well. And in doing that, in my time at a state university here, I saw one page in one of my textbooks that talked about domestic violence. If you wonder why therapists don't get it, I had one page in one of my textbooks that talked about domestic violence in my graduate degree studies. So if you want to know why you go to therapists that don't get it, that is why. What I know about helping abuse victims is from my personal experiences and my 10 years on my own, reading everything I possibly could about pathological personalities, how they get away with it, what their tactics are. All of that I now have in my toolbox because of my own studies. I did not get that in college. I did not get that in my graduate degree. And that's scary.
Even though you were studying to be a therapist?
Correct. I myself, in trying to save my family, went to 6 different therapists. Of those 6 different therapists, 2 recognized you are with an abuser, you need to protect your children, you need to get out. 2 out of the 6. The odds are very bad. So now I've also been before 6 family court judges. Out of those 6 family court judges, 2 recognized abuse. 2 recognized that I was with an abuser. To me, I know a lot of people talk about money. I didn't see money as the issue. I saw a profound lack of education with therapists, with DCS workers, and with judges. Profound. So during my graduate studies, I got to go work at DCS, and it all made sense why my kids were never protected. Are you aware that to work at DCS as a caseworker, you need to have a 4-year degree in anything? I can have a 4-year degree in recreation management or English or anything. And I can go and be a DCS caseworker. It doesn't have to be in social work. It doesn't have to be in psychology. I don't need any background in anything at all. 4-year degree. I go for 6 weeks of training, and I'm a DCS worker. Yes.
Well, you just said something that really caught my attention. So do you think that it sounds like your educational experience is fairly recent?
Yes.
When did you graduate?
Last summer.
Oh, congratulations.
Thank you.
Would you say that the books have become, on a scale with center being what it should be, have they become more a politically correct agenda, or are they really aimed at therapeutics?
First one. I had to just toe the line during schooling. There was a lot of political stuff.
So you regularly paid the BS card on
yes. Oh, yeah. It was
professor.
Hoops. Yep.
It kind of reminds me of Katie Pavlich when she, before she became a newscaster. Shout out to Katie Pavlich. Mm-hmm. She was called U of A Katie on a radio show down in Tucson years ago. And every Friday they heard from U of A Katie, and she regularly railed on the crap that she was fed in class and how she simply had to go along to get along to graduate.
Exactly.
Is that your
exactly.
feeling about what you had to do?
100%. And not to put down any marginalized community, but I was required to take an entire semester-long class directed at this one particular marginalized community that deserves attention, no doubt, but that's one small community, whereas domestic violence permeates every single court case that comes in the family court. Why was I not given an entire class on understanding domestic violence, understanding abusers, recognizing those tactics, how to help victims? 1 page. And I was very aware because of what I've been through. I was very watching for it. Never. And so I have a master's degree in social work is what I have now. Okay. And it was a very small amount.
Forgive me, I got to ask you again. You know what DEI is, right?
Yes.
Okay. Would you say that not just the textbooks, but also the instruction is permeated with DEI?
Very heavily, and at the expense of actual real issues that every client is probably facing. If you're in therapy, an abuser, traditionally 11 people have to go to therapy. 11 people around the abuser have to go to therapy from dealing with that person. So to not get that kind of education in school, and this is a state university here in Arizona that I went to. Great people. My professors were great. The people I went to were great. But that was a profound lack of... It made sense why every therapist I went to could hardly figure anything out because they're not given those kind of tools. So that, and then my time at DCS, It suddenly made sense because these are people, and I also, all throughout my graduate studies, my professors probably got sick of it. I was writing about family courts and the problems and all that, and I would love to share all the statistics, 30 plus citations of, you're twice as how much you're likely to lose custody of your kids if you allegate abuse. Huge. The people that end up in family court, 90% of people solve it on their own. 90% don't even go to court. Then the next 4 to 5% need like a lawyer or some mediators. It's only the last 4 to 5% that go all the way to trial and have a stranger make decisions for them. Guess who is involved in that last 4 or 5%? Always pathological personalities that lack compassion, love drama, blame shift, take no accountability. Do we know who we're talking about here, right? But family court judges aren't aware of that. They assume that, these are just two people that don't get along. DCS workers, and all this research is in here. Tons of research has been done on this. It just hasn't made it to the people that need to know about it. So DCS workers, characteristically, if they find out, there's a custody battle, hands off. And research shows that. And 63% of the time, they've found there is actual abuse that's taken place that was totally ignored because the DCS worker says, there's a custody battle, they're just fighting it out, let's let them figure it out. So it becomes a ping pong match where DCS doesn't do anything. They say, the courts are gonna figure it out. The courts get it and say, DCS didn't do anything, there must not really be abuse. And so they ping pong it, and it happens with law enforcement as well. When allegations are made to law enforcement and they find out you're in a custody battle, the courts are gonna take care of it. So it is volleyed all around to all these agencies, and the children are left unprotected and nothing happens to protect them.
So, would you say then that today's therapists and probably today's judges are woefully inadequately trained?
Absolutely.
Not just in what their job is, but I'm going to struggle with the psychology of individuals that make their way deep into the system.
Yes, research shows judges do not do any better than the average person on identifying an abuser.
Okay.
No better.
Next question is, is it your impression, since you've been on the inside of this thing, I'm reading your card, so you're a therapist, former DCS intern, protective, and you've got a long list of stuff here on your card. We've got a situation where, frankly, your colleagues, you're going to have to blow the whistle on them.
Gladly. For children, gladly.
Didn't know what they were doing.
Absolutely.
Is that a fair enough statement?
Absolutely.
So it was about, we're just going to pass the ball to somebody else that hopefully they know what they're doing.
Right. And there's a lot of professionals that do that. They just think, or the judge, the next judge will just stamp it because this is what the last judge did. And that's what the last judge did. So instead of them getting informed themselves, they just kind of follow the train of what the previous person did.
Very similar to an ex parte conversation without saying a word.
Correct.
Okay.
Correct.
So the next question I've got for you is, of these people that finally make it into the court system, I'm going to call it the vortex.
It is.
Well, you can't get out. Do these tend to be folks who are, shall we say, more wealthy?
It can be. In my case, that was definitely the case. I think to me, it's people that, for example, I was told, if you start this, if you file for divorce and you try to take I will destroy you. I will take everything. Go ahead, see what I'm going to do. That's what I was told. It's those type of personalities that are competitive and will take it to the end, even at the expense of their children. The children are collateral damage. If they can, and it's post-separation abuse is what it's called, and if they can harm the person that dared to leave them and dared to stand up to them, they'll do anything that they can to make them pay, including hurting their children. And that happened extensively. In the case with my judges, it was just to tell you, the applicant for a judge that came open in Yavapai County, here's the criteria. Applicants must be at least 30 years of age, of good moral character, admitted to the practice of law in Arizona, and a resident of Arizona for the last 5 years. That's the criteria. So to me, that's like saying, okay, we have someone that needs brain surgery here. Who here at the hospital has been here for 5 years? Oh, okay, go in there and do that brain surgery. There is zero requirement to be in a family law background, zero requirement to understand psychology, zero requirements to understand abuse. That, to me, my number one issue is to make sure judges are required to do extensive training to understand domestic violence before they ever step foot in a family courtroom. But right now, my judge that I had was a tax and estate attorney. And he was brand new to the bench. So I was his first case, lucky us, and I had a $29,000 custody evaluation done by Dr. Moran in Scottsdale. The opposing party had chosen him. I chose somebody else that was much more versed on domestic violence from what I thought. So the opposing party chose him. This 75-page paper comes out and says, father is unsafe. He has hurt the kids before. He's going to hurt them again. 50-50.
And the court?
50-50. The judge took a half hour to deliberate.
Slow down. Slow down.
Yeah. Yeah. It's insane.
Look, everybody, I appreciate the passion that's going here, but there's so much information coming at us. I want to make sure that we have a moment to absorb it. Okay. So, father had a history of domestic abuse.
Correct.
Physical, mental, or?
Correct. Mainly towards the children. Not so much as me, mainly towards the children.
Okay.
Yes.
All right. Well, that helps. Did at any time the court have a discussion, an open discussion about, I hate to use the term, what's best for the child? What's best for the children? I mean, or was this purely about the adults?
They regularly referred, because the opposing party was a doctor, so they would regularly refer, Dr. So-and-so, blah, blah, blah. You could tell they gave a lot of deference to him, and I think just discarded because they're not aware of the research that says if you're in family court, there's issues you need to look at. They kind of just look at it as, oh, she's just making allegations that are not accurate, because this is what man that goes to 8 years of college would treat his kids this way. So the stuff I had to say was so crazy, but true, that they would just disregard what I had to say.
Are you aware that family court duty for a judge is a rotation?
Yes, I have heard that, and I feel like they should not be allowed in that room until they get extensive training, because it's like sending a surgeon or somebody to do surgery that's never had the training to do surgery, and that sounds crazy, but they do it in family court all the time.
Yeah, it's a 3-year assignment, and I have it on good authority from a family court judge that it is the most hated assignment in the entire court system.
Right. Understandably, but those are our lives. They just have to hear about it.
Understandably,
Those
but
are
at
our
the same
lives.
time, these are individuals who have a hatred for what they're doing.
Right.
Have ultimate power over the people that they're doing it to.
Right.
Okay.
Mr. Chair.
Yes, ma'am.
Could I ask a question?
Are
you still going?
Sure.
Okay.
Yeah.
You had emailed me.
Yes.
About my bill in regards to currently it's 50-50.
Yes.
That's being awarded. And that because of that, that is what caused some, you said $200,000 in courts.
Yeah, I stopped counting at 200,000.
Yeah, and then also that, unfortunately one of your daughters had suicidal efforts there as well. So can you talk to that, how maybe currently the way it's set up, the 50-50 is creating some of the problems that we're seeing right now?
It just seems like your kid literally has to be at death's door, or like the parent, chops off appendages before the court will listen. Otherwise, it's just like split the baby and move on, is what it feels like. Just split the baby and move on. So no matter what I would say and things I showed in court, my daughter with rope burn marks, pictures of her with the rope burn marks around her neck from her dad, and he just made up a story in court. So I submitted all this information. I reported stuff to DCS. I did all these things, and I literally got chastised by Judge Christopher Kotke for wasting the resources of the police and the DCS. And he got after me for crying.
To that point, did anybody bother to interview the minor?
Well, Dr. Moran did, and he ignored that 75-page paper.
What about the police department?
Yes, the police. So at one point, my kids have, and that's the part of the problem is you have more people involved and more people that don't do anything. Everybody that comes along after looks at that and says, oh, it's one of those. And they step aside and let it continue. So that's what's happened in my case.
I'm struggling with if it was reported to the police that a parent, you just heard from somebody else who their child had rickets and had a broken bone.
Right.
Okay. Seems like law enforcement was very aggressive there.
Right.
DCS was very aggressive there.
Right. It's
My
so
question
arbitrary.
to you is, in this particular case, was there a police report made about the marks on your child?
Yes. Well,
And the police report, did they interview the child? I'm going somewhere with this.
Yes. Yeah. There's so many different times where police did interview my kids for different things.
Did the children, just pick one, did the
Okay.
children express what happened?
Yes.
And as a part of the court proceeding, was that ever considered?
I submitted it in court. So one example is my daughter talking about sexual abuse from her father. I took her to the Prescott Advocacy Center. They interviewed her, and in the interview, they determined, well, some families are nudist families. And I'm like, well, my family has never been a nudist family. So dad sleeping with a little girl naked while he's naked, that's not normal to me. But they felt like that did not raise to the level of being able to do something about it. Yet I still had that video. And I said, okay, the police aren't going to do anything. I'm still going to take this to court, because surely a judge is going to say, you know what, a grown man sleeping naked with a little girl that's never did that. We didn't do that before when I was married to him. This is when I was separated. That's not normal. And so I took it, and Judge Michael Bluff gave him primary custody after that. And I was chastised for leaving, because I packed up my kids, my family came and got me, and I moved from Cottonwood down to Phoenix, and I was chastised for hurting the relationship of the kids with their father. Michael Bluff told me that, so he gave custody. So I had the choice, this poor woman that talked about what she had to do, I had the choice to let my kids go be with this man that I knew was not safe, or tell him, oh, you know what, I changed my mind, let's work it out. And that's what I did. For the next 2 years, I moved back into that home and stayed with my little girls, because I was not going to leave them with the man that did that. And I secretly recorded him and did everything I could to get proof that what I was saying about this pillar in the community that goes to church and is, referred to as a doctor all throughout the community, I finally got proof. And that's why Dr. Moran sided with me, even though the opposing counsel hired him, because I had so much proof. And then Judge Kotke comes along, and what I know about Michael Bluff, I was told by somebody, they said, you know what you need to do? You need to go to his bar that he owns downtown and flirt with him after hours. That's what I did. That's what turned my case around. And I said, that does not fit with my morals. And I was told by the domestic violence agency there in Cottonwood, you'll never, if you're a victim of abuse, you will never get a good ruling from Judge Michael Bluff. He's been divorced twice, and he tried to get custody of his kids in his divorce, and I since have looked this up, public record, and wasn't able to. So you are not in a good position to go against him and try to get custody as a female, to try to get custody of your kids.
So would you say that he's not a neutral arbiter?
Oh, not at all.
Okay.
Not at all.
All right.
So just really quickly, Mr. Chair, was there actual evidence of either physical or sexual abuse or that was presented at some point? Because I've heard that time and time again, that there's actual evidence presented.
Yes. And what you need to understand, and I understand having been an abuse victim and now on the other side of it, is you have to be ready to pull the plug and be done with the relationship. Because if you try to go report to the police, hey, he just did this, and then go back home that night, that's not safe. So I left and then said, hey, police, here's all this evidence. Oh, this is in the midst of a custody battle. Hands off. So it was dismissed as, so you're up a creek. If you try to report it while you're still in the home, then you're under the same roof of an abuser who's not safe. I mean, the last night with him, I slept with a chair up against the door handle of the door because I was so afraid of what was going to happen, and I knew my family was coming the next day to save me. But just scary. You cannot go report that stuff and then stay in the home with that individual. You have to get away, get safe, and then start reporting. But unfortunately, everyone looks at it as, oh, sour grapes, you're just trying to get a leg up in the legal process. And I have, in my reports here, I have a policy brief as well as an annotated bibliography, and it all talks about how that's very, very common, that professionals that are profoundly uneducated on this just assume, they go off of gut instinct. Most people go off of gut instinct, and they just assume, oh, this is a legal strategy that this person is using, and they're just trying to get a leg up in the divorce. And I, no disrespect to the TI that gave testimony the last hearing, as I listened to her, I said, this person is very, very uneducated on pathological personalities. Mm-hmm. That's like saying, oh, come on, Jewish people, you really need to get along with Hitler better. Please, for the good of everybody, just get along better. It's like that. And how ridiculous is that, right? Or Mother Teresa would not be able to get along with these type of people because you literally just have to lay back and not fight at all. And that's when your kids are at stake. To be a peacemaker, you're just supposed to lay back and let them be hurt. that was the alternative.
I'm familiar with that in the TI world, that somebody's got to roll over and be belly up.
Yep.
So, all right, members, any further questions? Ms. Ballard, thank you very much for your time. And you got a cute bunch of, oh, I'm sorry.
Thank you.
Senator Warner.
Thank you. Could you provide your contact information?
Sure.
For staff over here? I'd like to reach out.
Yes, I would be happy to help in any way that I possibly can. This is like my dying wish to
And if
have
you
the family
would,
court system
the
overall.
documentation you have, would you please give that
Yes,
to Zach?
yes.
Thank you.
I also wanted to mention, if I could, the National Violence Against Women Act has incorporated money for states that are willing to overhaul their family court custody system and give money. So our state could get money. If you look up Caden's law, states that are implementing this overhaul get funding from the federal government, because this is a problem all over the place. But each state needs to decide, oh, we're going to change things. So Arizona could get some funding if we are willing to do this.
Well, and Title 4D is a problem, obviously, so if you would, please make sure that that information is either given to him or her. Thank you. Okay. Shelley Regard? My best regards? Is properly pronounced?
Shirley Requard.
Oh, that's a cue, sorry.
Yeah.
You can use the switch to bring the table down. That'll maybe make it a little more comfortable for you. All right, Shelley, if you would please give your name for the record and who you represent, if it's somebody other than yourself.
Shirley Requard. I'm representing myself.
Okay, and you have 7
And
minutes.
I'm the oldest and shortest here today. So I don't
I'm
want
sorry?
I don't want any age jokes or short jokes.
No, I'm not going to give any short jokes, other than time is short.
I'm going to hold you to that.
All right. All right, ma'am. Please proceed.
In late October of 2023, my 8-year-old grandson was removed from my care in Tucson and placed with friends for 14 days due to a false allegation by my grandson of physical abuse. The Pima County Sheriff's Department closed the criminal case within 9 days, finding no evidence, yet DCS refused to return my grandson to me. The DCS investigator himself witnessed the forensic interview with the detective, first grade, or whatever, whichever, that was there. And so he was right there. I have that documented. But he failed to report that the detective had dropped the charges, therein violating Brady versus Maryland. Civil rights attorneys call this judicial deception.
Mm-hmm.
This is known as a failed front-end investigation, as you know.
And this happened in what year, ma'am?
October of 2023.
Thank you.
Later, DCS falsely alleged that I violated their home safety plan by confronting my friends who had my grandson at their home, verbally accosting her and her fire captain husband, who was also a friend, and attempting to take my grandson, which did not happen. On November 9th, I filed a writ of remonstrance by affidavit, demanding my grandson's return. Instead, DCS moved him to a placement in Casa Grande, Pinal County. This done without notifying myself or the court. 2 weeks later, Judge Kristen Schreiner learned of this violation of their policies and procedures and ordered that my grandson be returned to his Tucson private school, which he'd attended since preschool, and he was in the 3rd grade at the time. 156 miles round trip every day on the deadly I-10 because DCS refused to search for a Tucson placement for an 8-year-old little boy. This was torture. This was torture. Note, despite stating otherwise, DCS made no effort to contact my other daughter living in Washington State as placement. She was eager to welcome her beloved, bonded nephew into her care. They reported multiple phone calls to her. My daughter said, "Nobody called me." For 9 months, DCS denied my grandson any contact with me or his older brother, claiming he was too afraid to see me. disproving this claim by DCS. When I finally was allowed to see my grandson days before his 9th birthday, he ran into my arms, told me he loved me, wrapped his arms around my waist. Hey, Grandma, I miss you. DCS continued pressuring me to admit to the allegation that I struck him multiple times with a stiletto heel. DCS violated policy, rules, statutes, and every constitutional norm in existence. My grandson during this time received multiple vaccinations despite a documented religious exemption. Several of those shots were duplicates of ones that he'd already received, mandated prior to preschool. And despite a drug allergy, amoxicillin was prescribed for him, risking his health due to DCS's failure to check the medical records of his own pediatrician because they took him to another pediatric clinic. My brave little grandson came forward and admitted that he had lied about the allegations against me. I didn't hit him with a stiletto heel. He did not have blood rolling down his arm and onto the floor. And I didn't hit his friends. All allegations alleged in the DCS report. Despite his admission that his original statements were false, DCS's contracted therapist refused to believe him. She was sitting right there. She refused to believe him because DCS and this contracted therapist got together and figured out that I had coerced him.
Excuse me, ma'am. How could you coerce him if you don't have any contact with him?
I was sitting right next to him the first time I ever got to sit with him.
Did
with
they
the
observe any
therapist.
conversation between the two of you?
I had not spoken to him other than just little bits of information, back and forth, how are things, that kind of thing.
Okay.
And the therapist said to me, "What brought you to DCS?" Which opened the door. So I could then address what brought me to DCS. I said, well, he had some bruises on his arm. She said, "Did you have bruises on your arm?" "Yeah." "Where?" "Right here." I said, "No, honey, they were on your left arm, according to the pictures." And he said, "Oh, yeah." And how did he get those, Shirley? Well, he said that the paperwork said that I hit him with a stiletto heel. Then I said, "Did that happen?" "No, it didn't happen." "Oh." And I'm not making eye contact with him. I said, "Well, what about the blood that was rolling down your arm and onto the floor?" "Blood? There was never any blood." "Well, what about the times that I hit you, that I hit so many of your friends?" "You never hit any of my friends." So with those allegations under her belt, his recanting of this story, I went to the therapist's office the next day. And I asked if I could have a copy of the transcript.
Excuse me, is this the information that was included in your Brady motion?
No, there was no Brady motion.
Oh, okay.
I'm just telling you that it was a
Okay.
violation. I went there the next day and she said, "Oh, I didn't take notes." "You didn't take any notes." And she had as it came out, she had gotten together with the DCS caseworker and they decided that if they said that I had colluded with him, try to coerce him into saying these things when I hadn't had any contact with him, that they could keep him. So what that forced me to do was engage a private licensed psychologist to get unbiased therapy for my grandson. He told this therapist he had not been struck, no blood, no injury to his friends, all charges that were alleged in the DCS report. So DCS isolated my grandson from me and his older brother, mishandled his medical care, and violated HIPAA privacy laws, and failed to provide transparency due to systemic failures of the Guardian system. As you are undoubtedly aware, the $89 Guardian system implemented in February of 2021 remains dysfunctional to this day, hindering the access to disclosure for families, thousands of them, facing permanent termination of their parental rights. Judge Gass, presiding over the First Division Appeals Court, is investigating DCS and the Attorney General's handling of disclosure to parents. Redaction is allegedly the problem. However, without consulting taxpayers, Health and Human Services just gave DCS another $31 million bailout for the Guardian system, despite its record of abysmal failure. To me, this smacks of rewarding poor performance and ensuring fat salaries for those who have no incentive to assure or achieve their goal. Could go on for years. $51 million a year.
Would you mind just finishing up, because your time is up, Shirley?
Okay. This also doesn't address the fact that I've been placed on the child abuse registry, which means I can no longer teach Sunday school. I can no longer help with Vacation Bible School. As a registered pediatric nurse and an ordained chaplain, they're not going to give me any help in reversing this, and it's going to take months and months and months of paperwork, is what I've been told.
Okay,
So,
so just a minute. Who placed you on the child abuse list?
sir, I wish that you would be able to address that. I've asked everyone, and I've been told it's just automatic. Within days of being charged with something, you're automatically placed on the child abuse registry list for
Okay.
7 years.
Okay, before you leave, let's make sure that we get your contact information to the lady to my right, your left, all the way down there. I think we need to follow up with you and make sure that due process has been followed, because that sounds like a massive violation of due process in your civil rights.
Thank you, sir.
That should not be an automated thing.
None of this should have been automated.
I'm pretty sure that whoever told you that does not know what they're talking about.
The Arizona Assistant Attorney General is the one who told me that.
Well, then we'll have a conversation with the Assistant Attorney General. Okay,
Thank-
we need to have you wrap it up, ma'am.
Thank you so much.
All right. Members, any last minute questions? No? Okay. Thank you very much, ma'am. And ma'am, make sure you get your contact information to this lady here. Okay? Thank you. All right, next up,
Chair.
ladies
Chair,
and gentlemen.
Chair, I have a question.
Oh.
For some reason, my mic is echoing. I do have a question.
For this lady?
No, for you.
Okay, yes, please.
I'm just wondering, are we talking about juvenile court or are we talking about family court? We seem,
Our focus is on family court, and I believe
Okay.
that that's what she was talking about. Shirley? Were you engaged in family court or juvenile court? Family court, okay. No, they're two different courts. Okay. All right. We'll get to the bottom of what the connection is, because it sounds like what you were going through was a family court matter. But I know that south of the Gila, they have combined court things because they don't have the volume of cases that we have in Maricopa County and North. All right, but thank you, Senator Totley. We'll look into that. Okay, Maulina Shiram? Okay.
Hi.
Drive the, okay,
I've
if you
been-
would,
Yes.
please give your name for the record, and forgive me, I know your name, but I didn't recognize your handwriting, so you have 7 minutes.
Melinda Sherwin. Thank you. I'm just making notes about what has transpired here today. There's a woman, a horrible woman, on the court list in Pima County. Her name is Holly Jobert. And she has a PhD and then an LDM. And I said, what the heck is an LDM? She is a legal decision maker for the courts. LDM. I thought you would be interested in that.
Is that an appointed position or what?
I don't know, but it's behind her name, and she's wild. She's a wild woman in the courts there, favored by the courts as a therapist and a court evaluator, and she will. I mean, she's sent. She crosses people's cases and sends them to the wrong people. And she's been arrested for drunk driving.
So I need to understand, ma'am, is this hearing is for personal experiences? Is what you're testifying to, please don't talk over me. Is what you're testifying to a personal experience or a professional observation?
Yes, personal.
Okay.
I said I'm on watch in the courts for 34 years.
Okay.
So everything that I tell you is something that I've seen with my eyes or I've heard with my ears. Okay, so let's see. Judges, what happened to judges reading evidence? They have relinquished their judicial authority to these cash-only third-party professionals on court lists. And I'm also an ADA advocate. I've sat next to families or a father or a mother who is being arrested. The court bailiff is walking toward them to put them in handcuffs because they haven't paid Miss Jo Bear her $5,000 for her services. And so I will say I can't do law, but I can ask the victim that's sitting next to me, ask the judge, are you forcing me into a contract with a person that I don't know, I don't trust, they're not working for me, and I can't afford to pay? And that halts judges because they know, if they've gone to law school, they know that you can't force people into contracts. What they do is a psychological game. It's like they get you to stipulate to a contract. It's when you come back and you're complaining, and they make you believe that if you don't get into that contract with that woman, that you are going to lose your kid. It's a psychological grift in the court, because when they come back and they complain about the evaluator or the other third-party appointee, they are told, isn't that your signature on the contract? Well, yes. So that's one of the issues that happens in the court.
What is your observation about the claim of coercion?
It's absolutely, of course that's it.
If they claim they're coerced into signing this agreement or this stipulation, and they're led to believe that if they don't participate, for example, with the TI, that the court will just assume that they're uncooperative and remove custody.
You're going to lose your kid. Yeah, absolutely. Okay. They say it. It's implied. And and then they call these third-party appointees will call their new client, and they will just hound you until you sign the paperwork. You've got to sign the paperwork. You've got to get in my office. Bring money. Blah blah blah. And insurance companies don't employ these people because they're constantly being sued, and insurance companies have standards, and so. How do you force a single mother or a dad who has a brain injury, a vet who has a brain injury, to pay $300 a week to have therapy with their kid? It's just it's ridiculous. So I'm for judges who do their jobs. It's like. And there was a lady who said that the evidence that you bring into the court is ignored. So you have the right to get your evidence on the record. It never happens. One side holds the evidence and presents the evidence, and then one side has one hand up. So in these cases, if it's post-judgment in a divorce, and yes, 90% of people do decide to settle their cases. Dad goes back to work, mom stays home until the kids get older, and then they grow up, the children get older, and mom can go back and upgrade her education, and then she can start working. That's what normal people do. But if you've got a case that has gone into the courts and it goes on for year after year after year, somebody's being abused. And they say this is a bitter divorce case. No, it isn't. It's an abuse case. So also about the lobbyists that come to these legislative meetings. Marty's bill, which was HB 2675, it was called Right to Jury Parent-Child Relationship. So I go to all these court meetings. I went to the task force, the Supreme Court task force on countering disinformation with the idea that Russians were saying bad things about Arizona judges. Yeah. Okay, so I will go to that. I go to the family
Melinda,
law.
Go ahead and finish up just
Okay,
as quick as
the
you can.
family law improvement committee, and so Judge McMurdy, who was running the family law committee, said, "I sure hope that right to jury parent-child relationship bill doesn't go through," and so friends of ours. Elise Kulik and who's the girl with the dress? Lena Garcia.
Oh, okay.
And so she pipes up and she says, "Oh, I spoke to the sponsor of the bill, and we're trying to reason with him because people did not like those jury bill. They didn't like those juries." Well, we used to have, in 2005, I think it was, we did have juries. And 89% of them settled. And that meant that if a judge was going to have a jury looking at him, the cases were settled. But so Leanna goes and talks to the legislator, tries to talk him out of it, and Elise Kulik writes a letter to Nancy Bartow and says, "This is not a good idea. People didn't like that. It's going to be too expensive. We don't have courtrooms."
So that's several legislatures ago when you've invoked Nancy Bartow's name?
It happened with
understand.
Senator Farnsworth. It happened with Leo Biasucci, and it happened with Justine.
So we're gonna have to wrap it up here. But
I'm done.
There is, I think, some relief that we learned of earlier today. Article 7 of the Constitution, the $20 limit.
We've tried that.
Well,
we've submitted that in the courts, and we've said we're going to do it. We're going to do a jury. If you can't make a decision in 60 days, then we want a jury to decide.
Okay, you have a new legislature in place. Now, the question is, will the governor veto House Bill 2256? That will be the measure of whether this state, we already know that the legislature is serious about it. I believe folks have already seen the voting record on that bill, both in the House and the Senate. Now we're going to question whether the governor is serious about reform. Let's see what the veto pen does. All right?
Well, I think that the governor should give us a statute, some sort of a monument.
It's not her business to give us a statute. That's our business.
Or maybe you should have one with the names of the dead children who have died as a result of these family law.
Yeah. We'll take that up in the next session. All right, members, any questions? All right. Thank you very much. I appreciate it. All right, next up we have Rachel Cardona Barnett. Hi, Rachel.
Hello.
Good to see you again.
Good to see you guys.
If you would, give your name for the record and get as close to the microphone as you can. And then, are you representing yourself or somebody else?
I'm representing myself. My name is Rachel Cardona Barnett.
And you have 7 minutes.
I have
So,
7 minutes, yes,
your
sir.
name?
Rachel Cardona Barnett. I'm going to cut some things down for the sake of time. On June 27, 2023, Judge Melissa Zabor issued an emergency warrant without any notice to remove my 4 children from my safe home based upon claims that contradicted even the previous court ruling, the same court ruling, that had already been addressed. Specifically, I was accused of having fled the state of Ohio with my children, that I was in the process of fleeing Arizona again, and a threat to safety to my children. The warrant read that my ex-husband had just located us after searching for 4 years. That was absolutely not true. It was not true, and it should be noted that we had shared custody until DCS investigation suspended his custody, a fact that Judge Melissa Zabor was aware of. Upon the 4 boys being forcibly removed from the home, that was labeled safe by, this is very important, Stephanie Preciado, who was the best interest attorney assigned from this court. She sent out a DCS worker as well as a social worker from her agency who assessed my home and stated that there was no safety concerns and that the children would be in danger if they were taken. Yes, sir.
I'm sorry, Rachel. Did you say best interest attorney?
Yes, sir. My children were assigned a best interest attorney through Maricopa County Family Court.
Okay. Similar to guardian ad litem?
Yes, sir. With the exception of her actually being a preside, I guess she's actually an attorney. She has her credentials to be an attorney, so she's worked both ends of it. I will say she was wonderful. She was very thorough in her investigation.
Okay. And she certified to the court that the home the children were in was safe?
Yes, sir. Not only that, but she stated that if my children were removed from my home, they would be in danger, and that I was my children's primary attachment. Their removal from my household would result in irreparable damage to the children.
Okay. All right. Please proceed.
Yes, sir. Thank you. The father also admitted to a history of domestic violence. Now, even if Judge Zabor was not aware of the case history because she had just came on, 3 days after the removal of my children, my ex-husband admitted in open court to having falsified all claims with the intention of gaining emergency sole custody of the children. In response to this unexpected and impromptu confession, his attorney, Regina Pangiero, abruptly got up in court and stated that my current husband, just a day prior, had forced his way into her law office and physically assaulted her paralegal, knocking this woman to the ground, throwing papers around, and then running off into the night. This unreported crime was quickly disproven, and after much back and forth with the Arizona Bar Association, this attorney, Regina Pangiero, was asked to remove herself from the case due to her unethical behavior. Even so, I was still placed on supervised visitation for 4 hours a month that I had to pay for, and I was monitored by Kristen Alcott, who was a provider who came here last month, who made the quote, "Judges can rule whatever they want. That's why we have the appellate court." My case is currently in the appellate court, and I'm at the mercy of these judges, hoping that they will rule in our favor and see all that has happened. But I'm also aware of the fact that if they do, my case goes back to Judge Melissa Zabor, who would then be able to make the same decision if she sees fit, and then I will again start and reinitiate the process of appeal.
And you have legal counsel?
I do have legal counsel now. In fact, the counsel that I had who did my appeal, she has been an attorney for 40 years, and she stated that in the 40 years that she has practiced, she has never seen anything as egregious. So much so that she took my appeal pro bono. She said, "I've never seen anything like this." And so she knew that the finances were a factor, and so she did my appeal for free because she said she's never seen anything like this. In addition to this, I was sanctioned and made to pay over $100,000 to my ex-husband. I was told I had to pay that amount of money with no means by which to pay it. I was told I had to pay that simply because the DCS worker who testified stated that the children were abused, but as so many other parents here said today, I'm a safe parent, thus DCS is putting their hands up and walking away.
So let me get this straight.
Yes, sir.
DCS makes what appears to be a false claim.
DCS didn't make the false claim, no, sir.
Okay, who made the claim that the children were abused?
The
You
school,
said DCS threw their hands up.
Yeah,
I'm-
so no,
I'm- you
DCS
lost me.
didn't make the claim. I'm sorry, to clarify. My children went to the school, and the school saw the bruises on my children. They called DCS. An investigation initiated. The DCS worker, Jamila Shakir, who was a very good worker, came out, did her due diligence. She said, yes, these children are abused by the father. However, because this mother is a safe parent, this is a family court matter, DCS is going to step away from it.
Okay. And that is what the court used as reasoning to hit you with a $100,000 payment to the court or to the alleged co-parent?
I was told that the $104,000 that I would pay would be his legal fees for him because I cooperated in a DCS investigation that was ultimately didn't result in anything.
Okay, hold on. The court came after you because you cooperated with DCS,
Yes, sir.
who is engaged in an investigation by a required reporter, a
Yes, sir.
mandatory reporter.
Yes, sir.
And this judge is, what's her name again?
Her name is Judge Melissa Zabor. Currently, my case is before the appellate court, and even now, even though my case is in the appellate court, she continues to make rulings on behalf of my case. Next month, I'm supposed to go to court because my ex-husband has now requested that I have no access to my children's medical records, and she's going to hear that.
Okay, in your divorce decree,
Yes, sir.
I'm pretty sure that there's a codicil in there somewhere that says that parents will have equal access to medical records and decision-making. Is there not?
No, absolutely. And just to clarify, my divorce took place in Ohio, our home state, at which time my ex-husband voluntarily gave me full custody of the children in exchange for waiving child support, giving him my home and all access and any finances I had. In essence, it's sad to say, I gave up everything and I bought my children's freedom.
Okay. Is there a therapeutic interventionist involved in this equation?
And it's funny you asked, yes, sir. In my case, Kristen Alcott acted at one point as that as well. She served multi-purposes in my case. She was a transportation agent, at which time there was a 1-hour recording of my children and her in which they were telling her they were fearful of their death. Their father was going to one day kill them. They went into detail about all the abuse that they had experienced, and she stated, not knowing, I presumed that she was being recorded, later on to the court, that my children adore their father, that they should be removed from me, and that I was the problem, that they never, ever reported any abuse.
Who was Kristen Alcott working under? It's already been established that she's not degreed and that she's not enrolled in a course of study.
She was working under herself.
So she wasn't working for a psychologist, psychiatrist, somebody with a master's degree, a PhD, not essentially a licensed practitioner. So she was working without a license?
She was working without a license. I am aware that she was already connected to these people she spoke about last month. However, for my case, when she was initially brought on, she was to monitor her father per DCS, saying that he couldn't be alone with the children. So the family court named her and said, well, if this is what we're going to do, we want to pick somebody. We don't want DCS to be involved. And they picked Kristen Alcott. So she monitored him. I had to give her money to monitor him with my children. Thereafter, she was rehired as a transportation agent, and she was to transport my children directly to the father because they were stating that I did not want the children to go. So I had to remove myself, which I did, and I had to pay her to transport my children, during which that recording took place. At some point, she was then hired by the court to monitor my social media, and she began presenting to the court. I guess she made a secret account and presented my social media, just showing that I was speaking against the family court, that I was exposing people in the family court, at which point my children were taken. And I was told by the judge, even after the father of the children admitted he lied about everything, that I was a danger. When I asked for clarification, how am I a danger? They said, you're a danger to the family court system. And this is after I was elected as a school. I'm currently a school board member, and over the state of Arizona, I'm the president of the Black Alliance. So anybody whose children attend school in the state of Arizona, I'm able to make decisions on behalf of your children. I am not able to make any decisions on behalf of my children. I did not know where my children went to school, and I was not listed as their mother on their paperwork per Melissa Zabor.
I bet they do see you as a threat, ma'am. I bet they do.
Mr. Chair, I
Representative
have a
Kushner.
request that's pertinent to what she's talking about. So you've shared those with me, the transcripts, really quickly, because I want to get this on the record just to make a point of what the transcripts include of the recorded call. At one point, one of your children says, "But these judges aren't God." And Kristen Alcott says, "Oh, I'd have to disagree with you."
That is
So my request is, are you okay with sharing that, or do you want to, I want you to, whatever we can get on the record, I think is better.
I would very much like for it to be shared. At this point, I still do not have access to my children except every other weekend. I have no access to them, so I would like everything to be shared, because at this point they've put myself and many other parents in a unique position because our backs are against the wall. You took everything that we had. We have nothing to fight for. And when you back somebody into a wall, then you're going to see what's really going on.
All right, if you could provide us with a transcript of that recording, or the recording itself, we'll see to it that it's transcribed and we get the recording back to you, okay?
Yes, sir, it's been submitted. Thank you.
So are you currently, I'd like to go back to, so you're telling me the court appointed Alcott, not a TI, not a psychiatrist, not a psychologist, not a licensed professional. The court engaged somebody who not only doesn't have a degree, is not engaged a course of study, to act as though they are?
Yes, sir. And what's unique about that is that the person who was qualified, which was the best interest attorney, her testimony, her entire report that was very well written, very detailed, even she brought people on, she brought a social worker on because she said, that's not my area of expertise and I want this to be completely clean. All of what she presented, all of her evidence, everything was discounted. My children were taken because Kristen Alcott said, simply.
Okay. Are you finished, ma'am?
I'm finished.
All right. Members, any questions? Representative, please.
Okay, thank you. Rachel, thank you. I just have a question here, and I'm not exactly understanding why this wasn't taken into consideration. You said that your ex-husband confessed in court, but then his attorney kind of jumped up and tried to do like a diversion factor? Is that what I'm understanding? And was that confession recorded at all or been utilized at all in being able to determine the custody?
Yes, ma'am. Thank you. So what happened was they took what this attorney, Regina Pangero, said at face value. There was nothing requested. Thankfully, the day prior when my husband went to her office to drop off the jump drive after my children had been taken, because I was representing myself, I had to present evidence. I told my husband, I said, I have a weird feeling, go ahead and press record. He never entered the office. So I was able to use that recording and submit it to the Bar Association with a complaint to say this woman lied and falsified this assault that took place. Now what's odd about that was months prior to that, which was factual and which the court is aware of, my ex-husband chased me into my children's school building and was found by the Glendale police waiting for me in the parking lot of a school with a loaded gun to kill me.
Oh, boy. Okay. But also, Mr. Chair, just to follow up.
Yeah.
But you did say your ex-husband did confess in court.
He did, yes, ma'am. He confessed in court. He said, so what happened was that he was, I was representing myself, and I had the documentation from the original Ohio decree, and that explicitly gave me directive and gave me permission to take the 4 children out of the state of Ohio to Arizona. That he was aware of the fact that we had been sharing the children when he followed me here and the children, that until DCS stepped in and said, stop exchanging the kids, he was getting the children every other week. So he admitted to that. So I said, I got him to confess. I said, so you're saying that this is your signature? Yes, it's my signature. So you're saying that when you got this warrant, what you swore to was false. Yeah, who cares? I can do what I want.
Okay. Thank you.
Okay. Members, any further questions?
Thank you. Could I get this?
Yes, thank you, Rachel. If
Thank
you
you.
would, hand that to this lady over here. All right, next we have, by the way, folks, we're at 3:10, so we're probably going to have space for about 5 more people before we call an end to this hearing. There will be 3 more. I apologize if we can't get you in. We knew that we'd have a lot of people here, but we want to make sure that everybody has the opportunity, a fair opportunity, between 7 and 10 minutes to speak, okay? Next up, we have Jacqueline Fashar Curran. Jacqueline, are you in the room? Okay, you have 7 minutes. You're on the clock. If you would please give your name, and if you're representing somebody other than yourself, identify them.
My name is Jacqueline Fasher Curran. I am representing myself and everyone else who can't be here. You know, this problem is worldwide, and I've spent the last year and a half researching it. January 31st, 2024, DCS came to my house because my daughter had some bruises.
Hey, Jacqueline, can you get as close to the microphone as you can?
Can you hear me now?
Much better, thank you.
Okay. January 31st, 2024, DCS came to my house because my daughter had some bruises that I could not explain. And to this day, it has been 467 days. I do not know how my daughter got those bruises. I agreed to a dependency alternative program. In the beginning, it was successful. I got my mental health stable, was working on enrolling in college. Everything was going great. May 2024, the woman who has third-party rights started telling me, 1, that I was never going to get my daughter back, and that 2, she was her new mom. The last time I got to see my daughter was June 26, 2024. The woman said to me under no circumstances was she going to allow me visitation, which was against the court-ordered visitation schedule. June 27, 2024, I hired my current attorney. We filed contempt, but I still did not get to see my daughter for 4 months. October 21st, we had trial. This woman came with absolutely no proof to any of her claims that I had supposedly threatened her and her husband. As far as I know, in regards to the burden of proof, we both have the burden of proof. Where I submitted documents that I had completed anger management and am in counseling, on medication, and text messages from the other woman telling me, no, I will not let you see your daughter. And this other woman submitted a journal entry as evidence. Judge McCoy ruled that this woman acted in good faith and was not in contempt. Very shortly after that trial, visits stopped again. I think I had seen my daughter a total of twice until we had to go back into court. And my attorney again filed for another contempt. My case was then reassigned to Honorable Judge Demke. We had an evidentiary hearing March 4th, where again, this woman had absolutely no proof of anything. She submitted evidence that got striked because she missed a deadline. And so she had no proof of anything, nothing. She walked in there, sat down and said, oh, she did this, that, and the other, with no proof of it. And where was I? And then, but she had filed, this is the second time she's done this, filed for severance, claiming that I abandoned my daughter when she will not let me see my child. Physically told me, no, I will not let you see your child. Months down the line of me having my visit supervisor, my attorney, any legal professional, they text her and say, hey, you know you need to follow a court order, right? I didn't get to see my child, and she said that I abandoned her. So now I have a severance trial coming up. It's going to be in 18 days. This severance got dismissed. And then we got a new judge, so it got filed again. Now we're going through a severance trial. You know? I don't know how that happens, but you know what? That's what happened in my case. Now, I also wrote a research paper in college on parental alienation, and I had copies hopefully given to you guys. You know, this is something I've been working on for the last year and a half.
Okay. Jacqueline, if you'd like to give whatever papers you have to Zach here.
Yeah, we
Oh, okay, all right, very good.
I know that, I made mistakes as a mother. I'm sure all mothers have. And I needed to get my mental health configured and stable. But now that I have that, I don't think that what's happening to me in family court right now is justifiable.
Okay, Jacqueline, who's your daughter with now?
She's with, should I say her name or?
Well, let me reframe that question. Is your daughter with
Family? No.
family?
No.
Is your daughter with a
Friend? No. I met this
Okay.
woman at church, and I dialed her number by accident when DCS was at my house, and she came to my house, and I looked at her, I was like, where do I know you from? And she's like, you know me from church. There you go, I know her from church. Okay, she might be a safe person. I need my daughter to be with a safe person.
So is this a foster parent
No.
situation?
No. DCS
it's
has even told me they would not give her a foster license.
Okay, so they wouldn't give her a foster license.
If she applied for it right now, they would not. Because of DCS is now involved.
Okay.
And they don't agree with what she's doing either. The parental alienation is so severe. You should hear the things coming out of my 5-year-old child's mouth. The things she's saying. That no 5-year-old child should know. And someone had called DCS, and so me having my parental rights, DCS called me. I had to go and have an interview. So I willingly obliged, and I sat in their office for 3 hours. And the investigator told me that this is getting dragged on. This isn't right. And it's time my daughter comes home. But unfortunately, because she filed for severance, we're going to see what happens in court.
Members, any questions for Jacqueline? All right, thank you very much. Appreciate your testimony.
Excuse me.
Yeah.
Thank you. I do have one question, Chair. Thank you for your testimony. I do have one question. My question to you and your experience that you're talking about regarding your child, is this within juvenile court or
Family
is
court.
it in family
No,
court?
This is in family court.
Okay. So you have experience with the court advocates, advisors.
Guardian Item, Mojave Advocates, DCS, yeah. Right now, I'm very well known in the family court in Mojave County.
Thank you.
Okay, thank you very much.
Thank
you. Next up, we have Amber Snodgrass. Amber, if you would, please give your name for the record and who you represent, if it's somebody other than yourself, and you have 7 minutes. Get as close to the microphone as you can.
Sorry, you got to tell all of us that. My name's Amber Snodgrass. I'm representing myself. I'm a mother of 3. My older 2 kids are adults now, but my youngest is 9. I've been a radiology tech for 18 years. I taught Yavapai College radiology program for 5 years. Next month, I will have been involved in Arizona Family Court for 10 years. I filed for divorce for my first order of protection when I was 8 months pregnant with my youngest daughter. There was ongoing domestic violence. I suspect I'll be in family court for 8 more years, which is why I'm coming forward, even with the fear of retaliation. I do have an open case and I'm awaiting another trial. I have over 600 documents filed in my docket. We have had 5 final trials, most of them lasting 1 to 2 days. In the past 2 years, we have around 190 documents filed, 90 filings from him, where he continually makes false accusations against me and every party to our case, using the family court to harass me and cause further trauma. 32 orders from the court during that same time frame and around 58 filings from my attorney, many of which were caused by having to respond to his filings. I can provide a letter with a lot more detail later. I did have to shorten it. It's 10 years of information, so.
I invite you to do that too.
Okay, thank you. So I came up with some things that I've come across in my time that I've found that really need to be changed. I'm one of the lucky parents. I was able to keep my daughter under supervised visitation with her father for 7 years. I do have majority custody, and I have sole legal decision making. With 8 more years to go, I'm terrified that that's going to change. So hence the reason for wanting to get some change made in our laws. With the documents that I've claimed, let you know that have been filed, I think the vexatious litigation law needs to be updated. I think it needs to include some verbiage about family court. Family court doesn't really know about it a lot, I don't think. With almost 200 documents in my case in 2 years, it's been nonstop. He was self-represented the majority of that time. The biggest thing in my case that scares me for the general public is that you've heard a lot about supervision, supervisors for parents. My ex-husband was supervised for 7 years. During that time, he started a supervision company in Maricopa County and Yavapai County, where I was located. And he proceeded to work as a supervisor. He still claims that he's doing that work to everyone. He claimed that Maricopa County had given him referrals from the judicial office when they were handing out the rosters at that time. He claimed that he was on that. Unofficially, I do know of at least one parent that received his name from a court when they were looking for a supervisor. He
I'm
had
sorry, forgive me for interrupting you. Do you know whether the court does a background investigation on individuals that they appoint for such a position?
I don't believe they do. They would have been able to access our court records if they did, I would imagine.
Okay, that's
Yeah,
something.
no, I don't believe
I
that
don't
they
know
do.
is a good answer.
Yeah.
We'll
Sorry.
make sure that we follow up on that and see if there is a process for background investigations for these individuals. Please proceed.
In my time when I found out that he was, I actually started to research all of that because it was terrifying to me that he was supervising people in these situations. And I found no laws governing supervisors. I found no disqualifiers. I found no qualifiers. I found nothing that said what they're allowed to do and not do. I asked for clarification from the judge when his father was supervising. He let him walk around a 2-acre area with our infant baby. And I asked the judge to please let him know what supervision entails. And she said, people know what supervision entails, and didn't tell him anything. So I think there needs to be really detailed information on what supervision means and who's allowed to do it, whether it's a professional or a non-professional. The only place that I found information was California. They have non-professionals and professionals, and they do have some rules and a guidebook and stuff like that helps. I'm going to look through other states and see what else I can find to come up with. Another thing is that I'm a member of the Arizona Address Confidentiality Program. I didn't find out about that until I'd been in family court for years. Family court they filed a document with my address on it when it was protected before I was in the ACP program. So I found out about it and I joined it. I moved. He hired a private investigator, my ex-husband, to find me, and then I was told there's no law against them looking. There's only a law that they get in trouble if they find it. So there was nothing to hold him responsible. He didn't do it more than once, so it wasn't harassment. I will say that I had the same judge in Yavapai County for 6 years, and it was awful. He did not treat me respectfully. He is known for not liking women and for treating us with disdain when we're in the courtroom. He just talks down to you. There were a lot of things that went wrong in my case there that caused me to, when in 2022 with my 4th trial with him, I decided to move to Maricopa County to escape because I had no other way to get away from him.
And the name of that judge?
That's Goldstein, Commissioner Goldstein.
Okay.
And many women that I confer with have had very similar stories with him.
Okay.
I had a
You
whole
just have
thing I
about
was
10
going to read.
seconds left.
Oh, no. Well, I'll send it all to you guys.
Well,
There's
just
a
put a
whole
bow
lot.
on it, because whatever you've got there that you haven't been able to get to, if you will give that to Elena, we'll see to it that it's in the materials for the report.
Okay, and then I'll send over a more detailed information. I tried to do the 5-minute thing and
Okay.
timed myself. Okay, well, I guess I'll read the last part. The safety of children should not hinge on luck of the draw on which judge you get, financial resources, or judicial assignments. I'm always worried going back into another trial. Parental alienation claims cause healthy moms to lose their children and dads. My ex and his attorney try to claim it regularly. My daughter has been resistant to going to some visits and vocal about not wanting to go for long visits. Family court has drained me emotionally and financially. My recent anxiety, born of years of trauma and legal retaliation, is now being weaponized against me in filings. My daughter deserves better. Until judges face true oversight and accountability, protective parents and vulnerable children will continue to suffer. In what world should we constantly try to award more parenting time to a person that has proven he is volatile, angry, unstable, and will be emotionally damaging to a child? Our statutes need to prioritize the physical, mental, and emotional safety and well-being of our children over everything else.
Thank you, ma'am. Members, any questions?
Mr. Chair, really quickly, I would like to get your contact information. So you have some really good ideas for legislation. So as we start to work on that, I don't want to get want that to get lost.
Okay, thank you.
Thank you, ma'am. Next up, Julie Anderson Holborn. All right, Julie, if you will, please give your name for the record and who you're representing, if it's someone other than yourself, and get as close to the microphone as you can. You have 7 minutes.
Thank you.
That'll go up too, by the way. The little switch to your right.
Oh, I think it's okay.
Okay.
Is this close enough? Can you hear me?
If you could get a little closer to the microphone.
Closer. Okay, closer. Good afternoon, Chair, Co-Chair, and committee members. Thank you for holding this important multi-part hearing series on family court. I come before you as a victim of the Phoenix, Arizona Family Court and the Orange County Family Court of California. I took my pain and turned it into purpose by first being an advocate and speaking up at the state capitol in California on Peaky's Law and other legislation. When I saw I wasn't having a big enough impact, I apprenticed with some reporters at the Sacramento Observer, and I became a national reporting journalist on family court about 2 years ago. I published nationally on Newsbreak, on Substack, and I cross-publish on other platforms like the Family Court Circus, and my work has been featured and shared by National Safe Parents and the Center for Judicial Excellence. I want to let you know that in my investigative work, I've had parents reach out for me all across the nation and the world. And this is, in fact, a national crisis. Our family court system, America's family court system, sorry, I'm trying to read from my text. It's small. I've had people and parents reach out from all across the nation and the world, and this is in fact a national crisis. Our family court system, America's family court system, and who plays a part in this? It's the judges, it's the lawyers, it's the minors' counsel, the therapist, the evaluators, the litany of other little professional names that they come up with, including family court services mediators, CCI investigators. But it isn't just family court. It's also a problem that's impacted by CPS. Law enforcement, and the problem with those two agencies is that they work with family court, and the majority of CPS social workers are as corrupt or as lacking in education, as you've heard from many other people here today. And they're doing this and they're assessing child abuse and domestic violence and coercive control and physical abuse and child sexual abuse and rape. And none of them have the specialties for it. Not the judges, not the lawyers, not the minors counsel, not the therapists. And that could be said the same for law enforcement, including the DAs who don't prosecute domestic violence and child abuse. And I have heard from hundreds of parents, more than hundreds of parents. DAs do not prosecute child abuse and domestic violence cases because they cost more. They take more time. They're not like little drug charge deals where they have plea deal and they make their little pay points on both sides. And a lot of people don't know that. So we don't have that happening. Then we have CPS who piggybacks to support the law enforcement. And then we have judges, and they all have relationships and they all hang out together, which is a problem. It's a huge problem. So how do we fix this problem? We immediately invoke denying immunity, judicial immunity. We put cameras in courts, audio and video. We make every court hearing available in person and remotely to the public, with exception to those narrowly tailored moments where they're discussing something about a minor. We do away with transcripts that cost thousands of dollars, and we make those audio-video recordings available to the parties for a nominal fee. We hold every mandated reporter accountable. We get rid of this idea of this quasi-judicial immunity because these people are not protecting children. They're doing the exact opposite. I just want to reiterate, the problem is the judges, the lawyers, the minors counsel, the custody evaluators, the therapists, the reunification experts, the transporters, the reintegration therapists, the COBIs, the TIs. So, like I said, I'm here as a parent and a victim of Phoenix, Arizona Family Court and Orange County Family Court. I submitted my 38-page grievance through my DV advocate. You all got a copy of it. I think you specifically, Representative Fink asked for it specifically in the email chain. My first 3 children from my first marriage were subject to Dr. Lavitt. That's who Kristen Alcott came from and was his assistant. Caused horror to my children, like significant horror. And now some of that stuff transferred over to Orange County, and it was the same type of thing that I experienced in Arizona in Orange County. And every single one of these parents.
I'm sorry. So let's go back to who Kristen Alcott was working under. That was who?
Dr. Lavitt.
Lavitt?
Lavitt,
okay.
yes. So my children were subject to that man in 1999. I subsequently moved to California and remarried, and we then divorced, and I became subject to the horror in Orange County Family Court. Lucy, who you heard speak earlier, was one of the parents after I became an investigative reporter that I investigated her case, and a litany of other parents. She mentioned Jessica Sinclair, who was a licensed marriage and family therapist who went around for almost 15 years claiming to about to be getting her PhD when she had been disenrolled from the program since 2011. And so my investigative work has uncovered a lot of corruption in Orange County. I've written on Madeline and Sophia's case here in Arizona. I've written on Grace and Gwen's case out of Chicago. I've written on Adam Rocks is his hashtag, and Elena is his mother out of Florida. And I have so many people emailing me on a daily basis and reaching out to me in my DMs of all my different social media platforms since becoming an investigative reporter. I can't keep up with it. So this is not isolated. These stories are real. What is happening is rampant, and the only way to really make a difference is to end immunity for the minors' councils, for the lawyers,
for the judges and for the state bars, individual state bars, to start investigating family court attorneys and minors counsels. And thank you for letting me speak. Thank you for holding this. We're just, so many people are so grateful that you've done this, as am I. And thank you very much.
Thank you for your testimony.
I have a quick question, Mr. Chair. So since you've experienced this in both California and Arizona, something that I heard, Rachel was talking about it earlier in her testimony, how it seems like some of these people are actually, you mentioned a lot of roles, like there are roles to play in this, that they're actually swapping their roles too. How much of that is going on where one person is, say, taking on a different role depending on the case? You know, they might be a TI on one, the guardian, or not the guardian ad litem, the counsel for the child on another. Do you see that frequently, and do you see that since you're involved in a lot of different states? Is that kind of the same no matter where you're at?
It is, and what I see is there are typically some court-approved or preferred providers, and one of them gets on, and then they get their other colleagues in on a different capacity, like a special master, a TI, you know, a monitored visitation provider, and that's another issue, the monitored visitation provider. While California has like a rule book, it's really not, there's really no oversight. And I know these things because I have a lot of sources who've come forward to me, and it is rampant, and it is across all the different states, and why it is such a big problem. And cameras in court would make a huge difference. If there was exposure to what is happening in these courtrooms, and parents are threatened. They're threatened by judges, they're threatened by their own attorneys. Their own attorneys tell them not to go to the media, or else I'll sub off your case. You know, there's just been this blanket, you know, unspoken gag order, don't go to the media, don't talk about it. And what's happening is nothing short of horror in these family courts.
To that point, I honestly, if that's happening with the roles, there's a huge ethical problem, in my opinion. But I will tell you, I have sat down with local media. Now, the media is not very nice to me most of the time. I don't talk to them very often. When it comes to family court stuff, we are all on the same page. And I sat down for an interview with one of the stations. I won't throw him under the bus. He was going to air it, and he got threatened not to.
That is,
just so you know.
I will tell you from my investigative work and all my interviews and everything I have done, I have been told by high-level administrative positioned people at newspapers in Orange County and LA that they are not allowed to report on family court. They were given that directive that you are not to report on family court. That's why I stepped over into doing this, because big mainstream reporters for papers or media will not report on this. They want to say, oh, it's a he said, she said. It is not. Like you heard from the therapist, the mom turned therapist, I forget her name, I apologize, Ballard, I think. You know, it's only 4% of cases, you know, divorce cases that end up in family court. And it's not because they're high conflict, it's because it's a contested custody case involving abuse, child abuse, domestic violence, child sexual abuse. That's what's going into family court. And they are keeping a lid on the child abuse. They don't want it coming out. DAs don't want to prosecute it because it costs money. And the media blackout is across the nation and the world, for that matter. I mean, I have people reach out from the UK, same type of thing. So people need to be told, like, this needs to be reported on. We need cameras in courts to expose it, first of all. And we need to do away with immunity for everybody involved. Because why are we protecting them when we know that they're hurting children? And we know CPS's record. We've seen the news all across the nation, these horrible settlements. And we don't hear about it until the settlement comes out because they keep it hush-hush. It's time for an overhaul. I appreciate you listening.
That's the point of this committee.
Very appreciative of that. Thank you very much for having me and for holding this.
Thank you very much for your testimony.
Thank
okay, next we have, let's see, we're looking at, we had 20 minutes. If we're really good, we can fit 4 people in. So, Troy James Odell. Troy, can you do it in 6 minutes?
I'd be crunching it, but I can try, sir.
Crush it. All right, please give your name, who you're representing, and if you want, elevate the platform a little bit to get the microphone a little bit closer. All right, I'll tell you what, I don't want to put pressure on you. Take as much time as you want, up to 7 minutes.
Okay. Thanks, Chairman.
All right.
So my name's Troy James Odell. I'm representing myself today and my son. His name's Liam Allen James Odell. He turns 10 years old on May 29th of this year. Unfortunately, I can bank on not being there for his 10th birthday because of what I'm about to share with you today. On 12/27/2023, I was served unknowingly a restraining order granted by Judge Demke of Mojave County with my son on the restraining order while I had full custody of my son. When I went back and listened to this recording, I was shocked to discover that the judge even admitted that he legally couldn't do that because I had full custody and she had to go through the court custody battle thing. And she broke down and started crying and said, well, what do I do? And the judge said, and she told the judge that I had been doing meth, which was a lie. And then the judge said, well, I'll do it this one time since he's doing meth, and granted it. That's what I discovered when I went back and listened to the recording. So carrying on.
I'm sorry, when you say you listened to the recording, it was the recording of the court proceeding or what?
Yes, sir.
Okay.
Yeah.
All right, go ahead.
So I challenged the restraining order on January 10th of 2023. The judge upheld the restraining order, but dismissed it to my son. But when I received the papers that day, the court orders still said in black and white that my son was to remain a protected person. So I went on to believe that I could not talk to or see my son. And while I went on to believe that, on January 17th of 2023, I was served an emergency custody order. That forced me to, from my position that I was in, I was already homeless when I got that order because of the restraining order kicking me out of my house. So I had to take out a $5,000 loan to hire an attorney. When I hired an attorney, he advised me to take a hair follicle test, which I did immediately. When the court received the hair follicle test, nothing happened. Even though she swore under oath that was the truth, I guess the oath doesn't mean anything anymore.
So I presume the hair follicle test came back negative for drug use?
Yes, sir.
And the court accepted the report but took no action?
They acknowledged that the results were negative across the board.
Okay.
But yet they didn't dismiss the case or make any other acknowledgments of it. They just acknowledged it. That was it. So even though I've already proven within 2 weeks of this transpiring that she's lied, it still goes on. DCS gets a hold of me and they say, well, I get a letter in the mail from DCS saying that based on their investigation, there's no substantial evidence of any neglect or abuse, so the case was thrown out by them. So me and my lawyer at the case management on 2/14/24, we were going over the hair follicle results with the judge, and we were going over the fact that DCS blatantly stated that there was no neglect or abuse found through their investigation, and they threw out their case. Even though that was brought to the judge's attention, she still set another hearing and so on and so forth, dragging this out.
I'm sorry, when you said she, you've changed judges?
So the restraining order was a guy, Demke, and the person with the emergency custody orders was Judge Megan McCoy.
Also Mojave County?
Yes, sir.
All right.
So I managed to get a lawyer, get my own apartment. I had to get a new job because of rumors that were spread around town about me being on meth, and my boss believed it. So I got a new job. I actually started my own business, which I still have to this day.
So just a minute, did you have access to the report to show your old boss this is fallacious?
I did, but he wanted me to take another drug test, and it just, there was no point in me taking another drug test if I've already taken a hair follicle. Hair follicles go back 90 days, and...
So instead you saw it as an opportunity for change?
Yeah. Yeah, I mean,
Good
if
on
they're
you,
not
man.
going to accept me, you know, if they're going to let me go, I started there in 2020. This is in 2024.
Yeah.
4 years of being a great employee, outstanding employee.
All right.
And they just let me go like that.
What's your new business?
Johnson Services and Repair. I do air conditioning and refrigeration and automobile repairs and stuff like that.
All right.
So the judge ended up spanning it out, and she set a trial for 2.5 hours, according to the court minute entries, on 6/24 of 24. In the meantime, my lawyer told me on the phone that the judge is a bitch and he will not go to trial. So there went $5,000 out the window. I fired him because he's told me that, and I recorded it too.
Okay, hold on. You hired the attorney. The attorney says, I'm not going to trial in front of this judge.
Correct.
And quits.
Correct.
Did you get your money back?
No.
I think you should probably speak to the bar.
I did. They said they wished that there was more that they could do, and they gave him like a slap on the wrist.
Okay.
Yeah.
Keep going.
So I ended up litigating this case by myself with no prior experience as an attorney.
You got about a minute, man.
Okay. I'm going to skip to the trial. Several witnesses and I arrived at 9 o'clock at an empty hall. The trial was set for 9:30. As we anxiously awaited the court proceedings, my grandma and her niece show up, along with the best interest attorney, Shannon Glau, who I've never met in person. I actually thought that she was her attorney because she sat with her the entire time in the hallway and was coaching her on what to do. When the court doors opened, the people inside rushed out. One woman looked me dead in the eyes, and she said, "Good luck, that judge is a bitch." I smiled politely at her and walked into the courtroom like I owned the place, looking sharp in a Hawaiian dress shirt, almost as if I was a CIA agent doing a drug bust in Cuba. Shannon Glau, the best interest attorney, sat with my grandma to the right. At this point, I'm nervous, thinking she had gotten a lawyer to come to find out she's the BIA. Finally introduced herself minutes before the judge walked out at 10:27. I quickly made the judge aware that it was making me uncomfortable that Miss Glau was sitting so close to my grandma as if she was representing her. That was not really a concern, and the trial proceeded. It doesn't say when my grandma was sworn in, but by my best memory, I can testify she verbally spoke for less than 5 minutes. She got one paragraph out, 2 would be pushing it, and that was her entire case, aside her one witness, which was her niece. In cross-examination, I asked her niece if she ever told her 13-year-old daughter if she would buy her drugs for beating her then 8-year-old daughter up while screaming this at the top of her lungs, and she said no, under oath, in cross-examination in this trial. Then, when it was my turn, I played a recording of said niece saying just that, screaming that loud and clear at the top of her lungs at her 8-year-old, telling her 13-year-old daughter if she beats up her 8-year-old daughter, she'll buy her a pre-rolled marijuana joint. So now, her only witness she called to testify against me has purged herself in front of the judge. Okay. Then I had asked my grandma point blank if she ever witnessed me for a period of time since my child was born being strung out on drugs or alcohol, and her answer was no. There was never a time when she witnessed me strung out on drugs or alcohol, but because I worked so much, I shouldn't have my child.
Okay, Troy, we're going to have to wrap it up, man. What's the name of the attorney that fired you as a client?
The one that I fired.
Well, they fired you. You paid him $5,000 and
Right.
you said, I'm not going into court. They fired you.
His name's Keith Knuckle.
Okay. All right, members, any questions for Mr. Rodell? All right. I wish we had more time, but thank you for your story.
Yeah,
Okay.
thanks, Chairman.
All right. All right, next up, we have Carrie Killebrew. Carrie, are you still in the room? All right. You got 7 minutes, Carrie. Sorry to be so restrictive, but we're coming up on a time limit. You can hit that switch to your right so that you don't look like Kilroy. You old ones, or you younger ones won't get that one. Okay, there you go. So
Okay.
get as close to the microphone as you can, and please give your name and who you represent if it's somebody other than yourself.
Okay, my name is Carrie Killebrew. I'm representing myself. My testimony comes from a point of view as a daughter and an older sister to my brother and sister. My dad has had sole custody of me since I was 5 years old up until 18. Now, as an adult, we run a business together and have a very good relationship. My dad and former stepmom were married for 6 years and had 2 kids, my loving younger siblings. During their 6 years of marriage, I experienced my own mental abuse from my stepmom. At the age of 9, she would tell me that my dad was a narcissist and was not capable of loving me or anyone else. She would try and turn me against him and try to manipulate me by constantly blaming my dad for any issues in the home, and she would punish me behind my dad's back for sticking up for him or myself. This lasted up until I was 15 when they divorced. Thankfully, growing up with my dad alone for the first 9 years and knowing who he truly was, I was able to see through the lies and manipulation. Since their divorce in 2015, my former stepmom has attempted to take my siblings away from my dad at least 5 times. Each time, she files and creates false narratives and states many false accusations with no proof. My former stepmom is a court-appointed forensic therapeutic supervisor who had previously testified at this last hearing that judges may order whatever they would like. When my dad asked for...
Time out.
Yes.
The individual at the very end of the last hearing?
Yes, sir. I didn't know if I was allowed to say names. She is a
Well, her
court-appointed...
name's been thrown around here all day long,
Okay.
so... Feel free, ma'am.
Okay, yes. So Kristen Alcott was my former stepmom.
Okay.
Okay. So the one that said, judges may order whatever they would like. When my dad asked for a change of venue, given her role in Maricopa County Family Court and conflict of interest, my dad was ordered to pay almost $2,500 to her attorneys for even asking, and of course his motion was denied.
And the judge's name was?
William Wingard.
I'm sorry?
William Wingard?
Okay.
My dad has never had money for a lawyer. Any lawyer he has had has been short-lived and been paid for by loans, friends, or family, including myself. Yet, since his ex-wife, Kristen, works for the family court and works closely with the judges, he has been ordered to pay over $35,000 in her attorney fees. During his last court hearing in January of 2025, he presented clear and convincing evidence and facts about the quarters that she had broke and the mental abuse she was implementing on my siblings. Very clear evidence. I had the opportunity to testify for my dad, and so did Miss Alcott's father. He also testified in favor of my dad. In the court order put out in March by Judge William Wingard, he did not acknowledge a single piece of evidence that my dad presented, nor did he acknowledge either mine or Steve Alcott's testimony. Instead, almost the entirety of the order was based off of the court-appointed therapist Carol Mellon's opinion. This therapist had never met my father or my siblings. She admitted to only reviewing the mother's evidence and her side of the story, and she was paid by Miss Alcott to testify in her favor. My former stepmom has testified publicly about how much her profession can make in the family court. If I remember correctly, it was around $150 to $400 an hour. Many people testified about how much money they have been ordered to pay her and others in the same profession. Despite this, and despite my dad's income proof showing he makes under $50,000 a year, he has been ordered to pay her $1,500 a month in child support, which they know that he does not have. The judge ignored the fact that she has reported my dad to CPS 5 times with no evidence and all reports coming back clear. I myself have been interviewed by them multiple times, even as an adult. They keep allowing her to report him with no evidence. It has been 3 times just in the last 5 years. Years ago, before she worked for the courts, a judge placed an order stating that mother keeps making the same allegations with no evidence. How is this not harassment? At the end of my dad's last hearing, the judges said his goodbye to my former stepmom's lawyers by saying, "It was good seeing you guys." The bias in family court is clear. No matter how hard he fights, every time he tries to stand up for himself and my siblings, he gets punished by the system. The judge has ignored my 13-year-old brother's pleas to be with our father, yet told my 14-year-old sister she can pick where she lives, which is essentially what my dad wanted for both of my siblings, for their wishes to be heard and acted upon. My brother has pleaded and expressed his fear of mental abuse from his mom, with it all being ignored, even after his mother had him arrested, causing him to spend a night in juvie. During this whole situation, my relationship with my younger sister has been severely damaged. We used to be best friends, and she came to me about everything and confided in me with really personal issues she had. We would have weekly sleepovers at my house. We hung out daily, and now I am blocked from her phone and have not seen her in almost a year, with no reason given. She has also not spoken to our 13-year-old brother since last year. I am proof that my dad is a good father. If he wasn't, I wouldn't be here as an adult. As a 25-year-old who is doing my best to fight for my siblings and my dad, my heart hurts for him and my siblings who have been ripped away from him solely to protect Miss Alcott's image in the court system. Something needs to change. The court-appointed officials need to be held accountable. Judges need repercussions. Parents who cannot afford lawyers need more access to legal help. You get arrested and you get a free lawyer, but someone tries to take your kids and you're on your own. The system is flawed and we need to fight for a change.
Thank you, young lady. I appreciate you coming. I have a couple questions. I'm sure some of the members might.
Okay.
So did Kristen Alcott act, or did she play a role in counseling for you during the period of time that all of this was going on?
Counseling for me specifically, no.
Okay. Did she have any part of any forensically informed interview of you?
No, I think she has treaded lightly to not draw too much attention to the case, knowing her position, and not to make the corruption very obvious.
Members, any questions for this young lady?
Yes, Mr. Chair, I have to that point. As far as you're concerned, has your stepmom ever claimed to be a forensic therapist or act in that capacity?
Yes, she has.
Thank you.
Okay, let's explore that for just a moment.
Okay.
Who did she represent that level of expertise to?
Her business name is Family First Forensic Consultants, and online publicly she claims to be a forensic therapist and, well, a therapeutic supervisor.
Mr. Chair?
Okay. Representative?
And so your stepmom, has she, I mean, she says she has this forensic business. Is she trained? Does she have any degrees or anything like that that would substantiate that position?
I don't directly communicate with her for obvious reasons, but to my knowledge, no. I know that she definitely doesn't have experience in adolescence specifically. And I know that she said she is working on her master's, but from what I've been told, she is not currently in school.
Okay. Thank you.
Members, any other questions?
Thank you for coming.
Okay. Carrie, is Kyle your brother by chance?
Kyle is my dad.
Oh, okay. All right. Well, we're out of time. Kyle, would you stand up for a second? Just, okay. It's 4 o'clock, and we're done at 4 o'clock. However, thank you very much. I appreciate your testimony, ma'am.
Thank you.
And it's valuable.
Thank
All right. Ladies and gentlemen, we will have another hearing, in fact, 3 more hearings. This is a pretty deep subject. As you can all see around the room, there's a community of interest here that has some pretty significant concerns. The next meeting will rely on a quorum call, but look for that to happen in June, hopefully early June, so that we can take a break for some of the hot months. But don't hold me to that, okay? But we will indeed have 3 more hearings. I'm not yet decided whether we will put out an interim report for the ad hoc committee or if we're going to wait until we're completely done. But I think that at least a few of my colleagues will agree. We've heard some pretty disturbing stuff today and in the last hearing. I encourage you, if you did not get to testify, and by the way, I got a stack of about 30 of you that wanted to testify, but we just didn't have time. Please come back. We'll do everything we can to get you in. Your cards will be saved for the next hearing so that you get priority to testify, okay? All right, with that, we are adjourned.